Yes, those are selected.
All right, good afternoon. Welcome to the House Environment and Transportation Committee for Tuesday, February 18th. We have a number of bills and a lot of witnesses, so we'll roll right into House Bill 767. Delegate Terrasa, Tenant Possession Recovery Act. If you have a panel or anything, feel free to bring them up.
All right, we have, there are three of us here and one on,
Yeah.
we have one more? Yeah, she's coming, okay, great. All right, we have one on their way. Now, there, okay. All right, good afternoon, Chair Corman, Vice Chair Boyce, and the esteemed members of the Environment and Transportation Committee. For the record, I am Delegate Jen Terrasa. Thank you for this opportunity to present HB 767, which simply requires tenants to be given notice of an eviction date and sufficient opportunity to reclaim their possessions after an eviction takes place. This is cross-filed with SB 442 by Senator Sidner. So what's the problem? When a tenant, and you guys have heard this before, when a tenant is evicted, the process is incredibly dehumanizing and often unpredictable. Not only are they losing the place they call home, they often lose access to valuable personal belongings, including medicine, pictures, family mementos, and important papers. Oh, okay. Thank you. All right. We got to work that. I got it now. All right. So I should start over? No, I'm kidding. So just a quick reminder of what happens now. Once the landlord files in court, which can be in as few as 10 days after the tenant is late on rent, a court date is set. If the landlord wins a judgment and a judgment is entered against the tenant, the landlord can move to the next step in 5 days. After that, things get much less transparent and predictable for the tenant. Anytime after those 4 days, the landlord can ask for a warrant of restitution, at which point the sheriff can schedule an eviction. This could be on the 5th day, the next week, or even a month or two later. After the warrant of restitution is issued, the landlord has 60 days within which to ask the sheriff to schedule an eviction. So the landlord knows when the eviction date is scheduled. But there's no requirement now that the tenant be given notice of this request, the issuance of the warrant, or the date scheduled for the eviction. Even when the tenant or their attorney if they're lucky enough to have an attorney, reach out to the sheriff's office to find out that date, my understanding is that some sheriff's office will not provide that to the tenant. And herein lies the problem. Any time up until the sheriff evicts the tenant has a statutory right of redemption. So that is the right to pay off the unpaid balance of their rent. And it's my understanding that many tenants do this, or at least believe they will be able to do this successfully right up until the sheriff's office arrives. And you can imagine if you were in this situation, you yourself might want to reserve any resources you have to keep trying to pay your rent rather than trying to find another place or having to move to a shelter. When the sheriff's office arrives, it's too late. Under current law, the tenant is locked out of the home and their important belongings are put to the curb where they can be destroyed or stolen, etc. So last June, the Fourth Circuit Court of Appeals ruled that Baltimore City law that declared tenants' belongings were abandoned upon eviction without adequate notice and a reclamation period was unconstitutional, violating the couple's 14th Amendment due process rights. The court affirmed a $180,000 money judgment in favor of the couple against the city of Baltimore. While the Todman case only addresses the constitutionality of eviction practices in Baltimore City, their holding implicates every jurisdiction in Maryland, particularly those like Baltimore County and Prince George's County, that also declare a tenant's possessions abandoned upon the eviction. My understanding is also there's a class action suit underway being brought against Baltimore City from all the other tenants or many of the other tenants who lost personal property due to these unconstitutional evictions. So what does my bill do? It requires landlords to provide notice to tenants at least 14 days before the scheduled date of eviction, information the landlord already has, and gives the tenant 10 days after eviction to reclaim their possessions if needed. The landlords are responsible for safeguarding the tenant's possessions during that 10-day period. It must facilitate reasonable access to the tenant to recover their items. Note, on the actual day of eviction, the landlord would still be given possession of the premises. So the tenant can't get back in without the landlord. So right now, Maryland is behind other states when it comes to tenants' rights over their belongings. More than 30 states and the District of Columbia have reclamation periods, including nearby states of New Jersey, West Virginia, Pennsylvania, Delaware, Virginia, and also Washington, D.C. Of these, 19 states and D.C. also require and give the landlord some duty to store the tenant's properties. So HB 767 brings Maryland in line with other states. This is really a win-win-win. It makes the situation much more predictable. The tenant knows what is happening and can keep their belongings, such as life-saving medicines, and I've talked about all the other things, kids' toys, other things that are lost. And of course, important papers. For the community, there's great benefit because, for example, when the tenant's home belongings are out on the sidewalk, it blocks the right of way and creates public safety and a public eyesore. And it helps local jurisdictions by addressing the Fourth Circuit's Todman decision to ensure our localities are not open to liability for constitutional violations in the eviction process. As for the landlord, the vast majority of cases, the landlord has notice of the date of the eviction more than 14 days out, and in most cases, more than that, up to 6 months in some counties. So 14 days notice should not add much, if any, time to the process. In addition, having a date certain will make it more likely that the tenants will be able to remove some or all of their own possessions. So it saves the landlord from having to pay employees to move all the tenants' possessions to the curb, and also then to clean up the curb after the items are destroyed. It also reduces ambiguity for the landlord because they know when the law considers the tenant's property officially abandoned and when they can dispose of the property. So in conclusion, this bill adds predictability around the eviction process, benefits tenants, landlords, local jurisdictions, and the community, treats tenants with the respect we all deserve, and I respectfully urge a favorable report. Thank you. Do you guys know the order?
Good afternoon, Chair, members of the ENT Committee. My name is Albert Turner with the Public Justice Center and also Renters United Maryland. The Tenant Possessions Recovery Act is a priority for our coalition. This is a bill that we've brought with great enthusiasm in the past. I will refer to our written testimony where we link to a story by Charnay Hunt. Ms. Hunt has testified in front of this committee many times in regards to an eviction that occurred a couple years ago where she was at work and she was evicted. She got a call noting that all of her belongings were outside. By the time she got home, all of her belongings had been picked through, had been stolen, had been destroyed. Come to find out, her eviction should not have taken place, that it was done in error. This is something that happens throughout the state of Maryland, whether it is done legally or illegally, where the eviction process takes people's personal property, throws them out in the streets to allow people to rummage through them, for the wind to take them out, to create clutter, to do all these other issues that other states have gone through have gone through the order to rectify. Something that the delegate has spoken of is this Todman decision. So the Fourth Circuit has declared Baltimore City's abandonment statute to be a violation of due process. This does not only apply to Baltimore City, but it does apply to other jurisdictions such as Baltimore County and Prince George's County. Now, there is some jurisdiction, there are jurisdictions out there that also are looking at due process violations because in the state of Maryland, there is no statewide requirement for notice. Most tenants do not know when their evictions are coming. In addition, there is no reclamation period, and we want to make sure that we are adjusting to that. In addition, there are other states throughout our country that have addressed this. Most importantly, in Pennsylvania, there's 30 days. Washington, D.C., 7 days. West Virginia, 30 days.
Great.
For that, we request a favorable report.
Appreciate your testimony. Delegate Trust, you want to move on down the line of your panel?
Sure. Good afternoon, members of the Environment and Transportation Committee. My name is Lisa Sorrow. I'm Director of Advocacy and Litigation for Community Legal Services, a nonprofit provider of legal services. We work a lot with tenants who are facing potential eviction. I've been doing this type of work for nearly 30 years in Maryland. Every discussion of evictions needs to start with the basic fact and be grounded in the fact that the most likely person to be evicted in the state of Maryland, the United States, is a baby up to 4 years old. Children 5 years old and younger are the most likely to be evicted. That's who's affected by evictions in the country. We can do better than that. So with that in mind, I have 3 quick reasons why this bill is necessary. First and foremost, it's the right thing to do. No one should be left with absolutely nothing after the roof has already been taken from over their head. Second, this bill benefits not just tenants, but also the government agencies and nonprofit organizations that have to step in to assist after an eviction takes place. When tenants lose everything, they're starting from scratch. They lose, as was said, absolutely everything, important documents, stuff they need for work, stuff to make a living, children's books, toys, what the kids need for school, everything gets tossed out. That shouldn't happen. People should have a chance to save that stuff. When they don't have it anymore, someone else needs to pick up the pieces. Those organizations are already strapped. And finally, perhaps most importantly, Maryland does not have due process protections in state law. The Todman case clearly states that jurisdictions have to have a constitutional process themselves, or they can be liable. For all 3 of those reasons, I would respectfully urge this committee to report favorably on this bill.
Good afternoon, Chair Corman and other members of the committee. My name is Chelsea Ortega. I'm a private consumer protection and tenants' rights attorney with the law firm Santoni, Bacci & Ortega, as well as a Renters United Maryland member. Currently, Maryland car owners are given more protection when their vehicles are subject to repossession than tenants have when facing eviction. The financing law that most finance companies use in Maryland provide that a finance company must provide notice after 5 days of following the repossession of the location of the vehicle so that people can get their belongings from the vehicle. The finance company is then required to keep the vehicle in possessions for at least 15 days. And then another 10 days before sale, the finance company is required to provide notice of the sale of vehicle. It does not make sense that we have better laws protecting people's vehicles and the possessions inside their vehicles than those inside their homes. We have represented clients who have lost things like their family members' ashes in these evictions and other items that are irreplaceable. You've heard some of those things. There have also been a number of studies showing that people who have been evicted or are at risk for eviction suffer at a higher rate of mental health issues than those who are not, including children. The fact that they are then susceptible to losing all of their possessions makes a bad situation worse. We have clients who have to tell their children that their PlayStations and their backpacks have been lost. It's a terrible situation. The uncertainty of when the sheriff is coming to evict causes conflict between the landlord, the tenants, that is unnecessary. The sheriff's office is overwhelmed with calls currently as to when the eviction is going to take place. All of this could be resolved with the passage of this bill. And for those reasons, we would urge a favorable report. Thank you.
Dr. Cross, did you also want Councilmember Hummer on your first panel?
Thank you. Good afternoon. There we go. Close enough. I'm Anne Arundel County Council Chair Julie Hummer, representing District 4, coming out in support of this bill. Just last week, I received photos from a resident in my district showing a mass of mattresses and furniture piled on the public road at the entrance of her community. I receive these types of pictures all the time. This is the 3rd year in a row I've come out to testify on this bill, and I hope that the 3rd time is the charm, and 2025 will see passage of this compassionate, common sense bill. Once a person has reached the eviction stage, they are already in a precarious financial situation, and the loss of their personal belongings only exacerbates that instability. Items thrown on the curb are subject to damage from the elements and scavengers picking through the things. Replacing mattresses and pots and pans and couches is expensive, but even more painful and irreplaceable is the loss of personal items. I currently have a box of family photos in my basement that a neighbor rescued from an eviction pile on a curb, and I'm trying to locate the displaced family to return some of their cherished family's memories. That's heartbreaking. Landlords know these piles of furniture give a bad impression of their properties. The sheriffs hate having to enforce the dumping of possessions on the road. Residents have their lives further disrupted and their financial stability further undermined. Children suffer lifelong trauma. So who is actually supporting and celebrating the current system? I hope that you will support this common sense alternative to the current practices. Adding trauma to an already devastating experience is not reflective of our state's drive to support and serve our most vulnerable residents. Thank you.
Thank you very much. We have a question from Delegate Lehman.
Let me get closer. Can you hear me now? Yes. Okay. Thank you for your tenacity and your commitment to this issue and bringing this bill back. I wondered if you or any of your panelists could address the concern by some landlords that the bill will draw out the eviction process, will make it longer. Is that a legitimate concern?
Sure. Thank you for that question, Delegate. So we have done we reached out to our partners in particularly these rural areas of Maryland, and our understanding is that this would extend the eviction process by a couple of days. But that is a very, very, very small amount of evictions that occur in the state of Maryland. An overwhelming majority of evictions in Maryland would not be affected by this law because it takes more than 14 days to execute an eviction in an overwhelming majority of these situations. And in addition, I will harp back on Todman. I think Todman requires these type of notices to take place. And Todman makes it clear that without reasonable time to know when you're losing your property and a reasonable time to address that, to have a redress, that is something that all jurisdictions need to abide by. So an overwhelming majority, I would say 98, 99% of these evictions that occur in Maryland would not be paused because of this bill.
Thank you. Mr. Chair, can I ask a quick follow-up? So the other question is, I think it's pretty obvious that, what the benefit would be to tenants and then to the, to the larger community. But what about landlords? What, if anything, how does this bill benefit landlords?
So I think, Delegate, one thing that we've harped on is this idea of the uncertainty of how evictions take place. So in most jurisdictions, the sheriff requires a number of movers to be present at their eviction. So in Montgomery County, we have 12 to 15 people need to be there if they're going to evict a single family home. Harford County, 4 to 8 people. So what happens is if you're a small landlord and you're looking to evict someone, you need to have at least 4, 8, maybe even 15 people present for the eviction before it can happen. And what happens if, one, the tenant pays? Tenant pays, there's no eviction, or it rains, or there's cold weather, right? The small landlord is out of the cost of having to pay and organize all those movers to be there. So what this bill does, it would not only clarify to the tenant when the eviction happens, it would clarify to the landlord when they actually can bring those movers in to bring out whatever that property is. So under the bill, the lockout would happen, they would have 10 days to recover their property, and then after those 10 days have passed, then the landlord is able to say, okay, I know exactly when I can move that property out, and it gives them more flexibility to do so.
Thank you. Thank you for that. Thank you, Mr. Chair.
Delegate Holmes.
Thank you, Mr. Chair. I appreciate the opportunity to hear this bill. I've heard a couple of you indicate that the tenant doesn't get notified So you're saying that when an eviction takes place, the tenant has no knowledge of the eviction at all?
So, okay, so to clarify, they have no knowledge of the date of the eviction. They've certainly been involved in the process. There's been, a court date. They're aware of that. But what they don't they don't know or have any information about is the date of the eviction, and that's the problem. So from that perspective, they are still trying, many of them are still trying and scrambling to try to figure out how to pay and stay. They're trying to figure out where to go, what to do with their belongings. And so oftentimes this is, it's a surprise in terms of the date. And it could be any time within, say, 6 months.
Thank you.
And if I can add to that, Delegate, so in Baltimore City, there is a requirement, 14-day notice and a 7-day notice. I know PG County has similar notices, but that is generally only for failure to pay rent cases, right? For tenant holding over, for breach of lease cases, the tenant typically does not know when their eviction is happening. And that eviction can happen at any point as soon as the warrant is signed. So statewide, that is something that needs to be addressed. In addition, when there's something like what happened to Ms. Hunt, where there is some type of eviction process that should not have happened, right? This allows for the tenant to be able to say, hey, I should not have been evicted, or this date that happened, that should not have happened. It allows for an error, human error, to be minimized because of the fact that there's not property just laying out on the street because of this error.
Great, thank you. I do not see any sorry, Delegate Long.
For your momentary indulgence, Mr. Chair. It's Prince George's County, not
George's.
PG County, isn't it so?
I apologize. I apologize, Dale. Prince George's County.
Okay, thank you to the sponsor and this panel. We have another panel of favorable witnesses: Catherine Davis, Pro Bono Resource Center; Jennifer Whale from Maryland Legal Aid; Jake Kemiak from CASA; and Rachel Buck. One of you, please go ahead.
Good afternoon, Chair Corman, Vice Chair Boyce, the members of the committee. My name is Catherine Davis. I'm the director of the Pro Bono Resource Center of Maryland's Tenant Justice Program, which provides representation to tenants in eviction-related litigation. Last year, we represented over 3,000 tenants and talked to over 1,000 more on our hotline. Many of them were calling to ask what to expect after receiving a judgment in rent court. We support this bill as a critical measure to ensure that evictions in Maryland are conducted in a constitutional and humane manner. This means tenants receive notice and have an opportunity to reclaim their possessions. Despite the Todman ruling that you've just heard about, we warn callers routinely that local laws do not ensure that they have access to their belongings after an eviction. That includes birth certificates, passports, school books, family photos. Local jurisdictions still subject tenants to the whim of the landlord regarding their possessions. This bill can change that, and we urge you to do it. We've also heard about the lack of notice given to Marylanders on their eviction. We guide callers through the sometimes complicated process of tracking down their eviction date. And until they do, we hear that they're often afraid to go to work or to leave the house because when they come back, they might find themselves locked out with their belongings locked inside or stuffed into black bags on the outside. We had a situation a few years ago that sticks in my head. One of our staff attorneys was speaking to a client, a 75-year-old woman who was currently working with United Way to get some rental assistance to pay her rent when she overheard banging on the door. Our client was surprised and unprepared. She had some cash on hand, but not enough to pay to stay the eviction. So our attorney listened as our client raced up and down the stairs, first looking for her wallet and then for her inhaler as she got increasingly out of breath. Tenants have a right to the notice of their eviction date. They shouldn't have to scramble like this. The point of an eviction is the transfer of property back into the hands of the owner. House Bill 7067 provides the framework to help that happen, and we encourage a favorable report. Thank you.
All right. Good afternoon, Honorable Chair Corman, Vice Chair Boyce, and members of the committee. My name is Jacob Kimmich, and I'm a staff attorney with CASA. CASA is the largest membership-based immigrant rights organization in the Mid-Atlantic region with more than 60,000 members in Maryland. I speak on behalf of our members who disproportionately face eviction, but nevertheless work tirelessly towards a future where the rights of renters across our state are fully honored and protected. CASA is proud to offer testimony strongly in favor of the Tenant Possession Recovery Act. A common theme that I encounter in my work, primarily in Montgomery County and Prince George's County, are tenants who are blindsided by court judgments and then by evictions that they don't expect. For example, let's take just one tenant. We can call him Mr. J. Mr. J calls our hotline and says that he received a court summons on his door that he's not sure what to do with. The court date, by the way, is just 1 day away. He tells me that he reached out to his property manager, who told him not to worry about the court date. She says that they file these things automatically all the time through a system that she doesn't entirely understand, but they will let their lawyer know to dismiss the case because he's paid up on the rent. I tell Mr. J he should still go to court, and sure enough, their attorney has no record that he was supposed to dismiss the matter. What would have happened had Mr. J not shown up in court and taken their word on the dismissal? Under our current law, he would have not received any further notice. The landlord could file for a warrant and get an eviction in just a week's time, especially in smaller rural counties where tenants are more vulnerable. While he could prove to a sheriff that he's paid off his eviction, why would he be at home at the time of an eviction when he works a 9 to 5? I wrote about just a few evictions which I have witnessed in our written testimony. If you have never witnessed an eviction, I encourage you to contact your local sheriff's department and ride along on one. Even as a bystander, the emotional toll that evictions take on a community are horrific. I would also encourage you to stay after a sheriff leaves. As soon as the sheriff steps away and heads to the next site, a person's property is fair game, and their personal documents, children's toys, and valuables are often picked clean by the time they get home. This harm is unnecessary and needlessly cruel, and has a lasting emotional impact on tenants, sheriffs, hired movers, landlords, and their surrounding community. Maryland is an outlier. 46 states have enacted notice periods, reclamation periods, and evictions. There is a growing consensus demonstrated by our federal courts in the Dodman case that our eviction process is unconstitutionally unfair. The fix is simple, and CASA strongly urges the committee to produce a favorable report. Thank you.
Good afternoon. My name is Jennifer Weil, and I'm a senior housing attorney with Maryland Legal Aid. I'm here to ask that you support House Bill 767, and to illustrate why this bill is so critical for tenants in Maryland, I want to tell you about a client that I worked with last year. His name is Reginald Reynolds. Reginald is a 56-year-old man who was working full-time and living in public housing in Washington County in December of 2023. That month, he was injured in a bus accident on his way to work, and he missed 2 weeks of work as a result. The injury, his missed hours, and then a paycheck error that was completely outside of his control led to a temporary reduction of his income. With lower income, he quickly fell behind on rent. The housing authority would not adjust his rent in light of the hardship since it was temporary, in their words, and Reginald was evicted from his apartment for failure to pay rent in January of 2024. On the day of eviction, Reginald was on a bus headed to his apartment with the money in his hand to pay off the judgment and redeem his apartment. But he arrived too late. When he returned to his unit, he found that the locks had already been changed. Everything he owned had been inside that apartment, including his prescription medicine and all his belongings. That day, and for several days following the eviction, Reginald searched the outside of the property for his belongings, walking the perimeter with his friends over and over. He talked to security and maintenance, and nobody could direct him to his belongings or his medication. Because of the eviction, he lost every single thing he owned that was not on his back. He lost all his furniture, all his clothing, sentimental items like family photos and photos of his daughter when she was born and growing up. He lost his own birth certificate and his daughter's birth certificate, all his personal medical papers, and most importantly, he lost his blood thinner medication that had been prescribed because he has atrial fibrillation. He had just refilled that prescription, and in that post-eviction moment, it could not be refilled. As a result, Reginald went without necessary medication and ended up hospitalized 3 times due to symptoms of atrial fibrillation in the 7 weeks following his eviction. For Reginald, post-eviction access would have protected him from not only the trauma, but also the dangerous health consequences. And he's just one of many clients we see who loses everything after an eviction.
Great, thank you for your testimony.
Good afternoon, committee members. My name is Rachel Buck with A Wider Circle, a Maryland-based social service organization and the largest furniture bank in the Maryland, Virginia, D.C. region. On behalf of our organization and our participant-led Social Justice Committee, and in partnership with Renters United Maryland, we support House Bill 767 as a critical measure to ensure tenants have a reasonable period to reclaim their items after facing an eviction. Through A Wider Circle's work to end furniture poverty, each year we serve more than 10,000 individuals with items ranging from furniture, home goods, infant items, to professional clothes for job seekers. A full 10% of those who called us for support last year had lost their items due to an eviction. With the bill before us, we have an opportunity to address a cause of furniture poverty and allow groups like A Wider Circle to serve others in Maryland who are in urgent need of support. And so, let's ensure there's no surprises in the eviction process, no families lose all of their possessions, and no families are having to eat and sleep on the floor of a new residence. It is with those that we serve in mind that we stand in support of House Bill 767 and ask that you join us. Thank you.
Thank you. Just a reminder to all our witnesses waiting, when you are speaking, make sure to pull the mic close to your mouth so we can all hear you up here. And when the time buzzer goes off, you don't need to wait for me to interrupt you. You can just stop. If your last line is, we ask for favorable report, trust me, we already know what you're asking for without doing that after the buzzer goes off. Any questions for these panelists? Delegate Healy.
For one of the attorneys on this panel, you've looked at this bill closely. I have a very simple question. Do the provisions of this bill also apply to squatters who are trying to, that landlords, or not even landlords, that property owners are trying to evict? Any attorney at the table?
I am almost positive that this is only failure to pay rent, breach of lease, and tenant holding over.
Yes, it would follow those eviction actions.
Thank you so much.
Any further questions for this panel? Okay, thank you all. We have another group of favorable panelists, Ayanna Bunch, June Henderson, Rachel Buck, and Derek Bailey. Ayanna Bunch,
Yes.
Chisel Baker, Derek Bailey, and June Henderson. Please go ahead when you're ready.
Good afternoon. My name is Ayanna Bunch. I'm a part of the Social Justice Committee of A Wider Circle. I believe House Bill 767 is a critical measure to ensure that tenants have notice of their impending eviction date and a limited period of time to reclaim their personal possessions in case an eviction is executed. Evictions are not just a symptom of poverty. Evictions cause poverty and homelessness, especially when renting individuals and families lose all of their belongings. The Tenant Possessions Recovery Act, HB 767, will mitigate this trauma by requiring that tenants receive 14 days notice of the eviction date and a 10-day window to reclaim their belongings if an eviction is executed. Please pass this bill, HB 767. If you and your family were evicted, wouldn't you want 10 days to gather your belongings to get to your new residence? Thank you.
Yes. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Giselle Baker. I am an independent scholar of international affairs and a Social Justice Committee member of A Wider Circle. I stand before you today in strong support of the HB 0767 because housing stability is a matter of dignity and justice. The time to act is now. Protect Maryland renters. The foundation of justice is not just force, it's wisdom in action. Like the creative power of the heavens, true leadership moves with strength and foresight, not reckless. Yet today, Maryland allows landlords to cast tenants out with no time, no grace, and no dignity. The moment an eviction happens, belongings, memories, tools of survival, pieces of a life refuse. This is not justice. This is not order. A society that discards its people's dignity weakens its own foundation. Stability is not the root of progress. And when we strip people of their right to reclaim what is theirs, we fracture but our own. To allow just 10 days, 10 simple days is not a radical demand. It is the bare minimum of humanity. The laws we write today shape the world we walk into tomorrow. Will Maryland be a place of wisdom, strength, and fairness? Or will it cling to the policies that disrupt, destabilize, and destroy? Now is the time to act, not in hesitation, not in doubt, but it is clear force of righteousness. Let us ensure that no person, no family is left behind. Thank you.
Thank you.
Thank you so much. Any questions for these panelists? Okay, we will turn to some, thank you both. We will turn to some virtual favorable witnesses. Terrell Askew.
I'm here.
Please go ahead when you're ready.
Okay. Good afternoon. My name is Terrell Askew, and I live in the 46th District, and I'm testifying in support of House Bill 767. I support this bill because I have lived with the threat of and impacts from evictions most of my life. As a youth growing up in Baltimore, I both saw people evicted and was forced to move due to a looming eviction. I can say without hesitation that it is one of the most degrading and soul-wrenching experiences that anyone can have. I can still remember vividly the day we were forced to leave. We packed up as many boxes as we could transport and keep with family members who had space. My sister and I packed up our book bags with as much school equipment as they would hold, and we hugged our pets, 1 dog, 3 cats, 1 turtle, and a garden snake, and said our goodbyes to them, which proved to be very fitting since we never saw any of them again. In our scramble to try and save as much as we could, we ultimately lost it all. Nothing about that day seemed right, and never in my life would I feel as safe as I did before that day. That is what I think this bill seeks to address: the senseless cruelty and undue mental anguish that evictions create in the lives of those who experience them. Trying to, in some small measure, sustain the dignity that the evicted have and remove the needless shame people are forced to bear simply because they don't make enough to maintain 4 walls and a roof. In a few words, using the law as a means to find the justice that we all believe we are entitled to but have for too long been denied. For those reasons, please don't allow that denial to continue any longer and vote favorable on House Bill 767. Thank you.
Great, thank you very much. We'll turn to favorable amendment virtual witness, Lisa Lowe. Please go ahead.
Hi, I'm Lisa Lowe. As a commissioner of the Montgomery County Interagency Commission on Homelessness, I've encountered many individuals with egregious stories. Can you hear me?
We can hear you. Please go ahead.
Okay. Egregious stories of their eviction encounter, experiences which leave a lasting memory of trauma and stress. For a minute, I'd like you all to imagine that you've returned home from a trip to the library or to the grocery store one day to find all of your belongings piled outside on the lawn without warning, cherished and once valuable items broken when they were tossed carelessly by the sheriff's movers, all of your worldly possessions quickly diminishing as your neighbors pick out items and carry them off. If you have minor children old enough to have been home when the eviction squad came, they're sitting glumly atop the pile of furniture, keeping the greedy-eyed neighbors at bay and pretending that this is not the most embarrassing day of their entire existence to date. To make matters worse, if you exhibit any emotion that can be construed as mentally imbalanced by the sheriff's thugs, i.e. angry words, cursing, sobbing, falling apart, you could easily find yourself at the nearest hospital for a week or so until you calm down. Out of a dozen patients at a mental health wing of one hospital, 3 of the patients, all of whom were elderly, were admitted on the day of their eviction, and all 3 claimed that they did not pose a danger to self or others at any time during their eviction proceeding. Regardless, each was held against her will for observation for at least a week. When this happens, you may as well consider all of your belongings irretrievable. If your children are teenagers without knowledge of where or how to seek assistance and avoiding placement in foster care while you are locked in the hospital ward, they may be forced to sleep outside until you are released. If I may conclude.
Thank you for your testimony. Thank you for your testimony. We appreciate hearing from you, especially because you're from Montgomery County, my favorite county. Seeing no questions, we will call up our panel of unfavorable witnesses. Bill Costelli for the Realtors, John Carr, Prince George's County Sheriff, Brian Anlou Aoba, and Ashley Clark. Please go ahead.
Thank you, Mr. Chair. Bill Castelli on behalf of the Maryland Realtors, and we are opposed to the legislation. Many of our realtors are property managers that manage single-family properties, although they manage also some small multifamily properties too. We're opposed to the legislation because we do believe there is a lot of notice built into the system. This bill covers 3 instances: failure to pay rent, tenant holding over. It covers breach of lease. There's already in the code, in fact, many of you supported a bill on the tenant holding over case where you extended the notice period. So if someone's not going to renew a lease, you extended that from 30 days to 60 days. So they know that they are not going to be extended in their lease in that tenant holding over period. And this would tack on additional time to what you've already given, which is in 60 days, this property is no longer going to be available to you, so you have time to move, find additional housing, move your property. Same thing with failure to pay rent. You've extended the notice periods for that so that they give at least 10 days before they're able to process that notice of eviction. But also as a tenant, if you haven't been paying the rent, you know that that process is moving forward. Same thing in terms of breach of lease. You have a notice, depending on whether it is an imminent danger breach of lease, which might be a 15-day notice. If it's it might be a 30-day notice if it's not imminent danger, but if it's a breach of lease, you provide that notice. And this, again, would extend on. What we're concerned about in terms of, especially like single-family properties, it is almost always the case that you have personal property that is left over. And it is almost always the case that it is not personal property that somebody wants. It might be a broken aquarium, it might be a broken lamp. And now we have an additional 10 days that that property would be off the market, waiting for that property to be moved, and at the end of the 10-day period, it's still probably not going to be moved.
Good afternoon. Chair Corman, Vice Chair Boyce, members of the committee. My name is Ashley Clark. I'm here on behalf of the Maryland Multi-Housing Association. I do want to thank Delegate Terrassa for speaking with me regarding the legislation, and want to state that landlords are in the business of providing housing and not evicting tenants, and dislike the eviction process just as much as tenants do. However, they should be able to exercise their legal right to regain possession of their property when a warrant of restitution has been granted. So for the sake of time, I'll focus on the reclamation period, which really boils down to the storage costs that are associated with the evicted tenant's personal property. This bill doesn't allow a landlord to charge for the storage of the former tenant's personal property. The only cost the landlord is allowed to charge for or to recoup are the expenses incurred in providing the notice to the tenant of the eviction, and that amount is nominal. It can't exceed $5, which doesn't factor in the turnover cost and the vacancy loss that will accrue during that proposed 10-day reclamation period. I've heard conversations about the Todman decision out of the Fourth Circuit, and I wanted to quote on page 21 of that opinion. It says, had the abandonment note ordinance provided any reclamation period at all, even one as short as a few hours, they would have been able to retrieve their belongings. This is in alignment with codes like Prince George's County, which allow a tenant that's present at the eviction to have a reasonable period of time, not to exceed 4 hours, to salvage and transport their personal belongings. So in sum, this bill seems to place the onus exclusively on the landlord who's exercised their legal right to regain possession of their property, and there should be a shared responsibility. And it's so, excuse me, running out of time. There should be a shared responsibility that's not acknowledged, but instead elevates the tenant protections above the rights of the landlord. And so we're asking for an unfavorable report. Thank you.
If it pleases the chair, I'm requesting permission to step in for Brian Anlou. Thank you very much. Hugo Cantu on behalf of the Apartments and Office Building Association. AOBA members oppose the bill because it lengthens the eviction process and increases turnover costs. But first thing, I'd like to walk the committee through the lengthy eviction process in Montgomery and Prince George's County. Landlords are required to give tenants the 10-day notice before filing a failure to pay rent case with the district court. The courts are currently taking 30 to 60 days just to schedule a hearing. Once the hearing is even scheduled, the sheriff then serves the tenant with a summons that includes a date and time of the hearing, and only if the judgment is entered in favor of the landlord, the tenant has 4 days to appeal and or leave within 7 days. After those 7 days, the landlord can apply for a warrant of restitution or writ. Just the simple process of signing and issuing the warrant can take 7 to 10 days in Montgomery County and 6 to 8 weeks in Prince George's County. And once the writ is issued, the sheriff can schedule the eviction, but this can and often does change for things like inclement weather, as we saw earlier this year, number of evictions scheduled for that day, and even whether there's enough staff alone to actually move on with the eviction in the allotted time. And I mean, in summary, really the takeaway here is failure to pay rent case can result in 2 to 3 months of lost rent, which is the best case scenario, and the bill adds nearly a month to this process, which obviously differs from the earlier statement that it only adds a couple of days. And I'll conclude by saying that evictions raise housing costs for everyone because the only way to recoup this is through rents. For these reasons, AOBA urges unfavorable report.
Thank you very much. We have a question from Vice Chair Boyce.
Thank you, Mr. Chair, and thank you all for your testimony. I have a couple of questions. One is, what is actually your process for tenants to recoup their property? I've heard what it's going to do to you, but I haven't heard what actually your process is for tenants to recoup their possessions.
Okay. Well, once the sheriff, and maybe, do you want me to start at the point? Okay.
Well, I guess I want to start from the point of the individuals that you represent. What is their process for tenants to get back their possessions?
Okay, well, after the eviction is done by the sheriff's department, after the eviction is done by the sheriff's department, and the items are moved out of the apartment home and they're placed on the sidewalk, perhaps, the residents, and I know we've heard in some of these instances that the residents are not present, but there are often times when they are, and some are prepared with moving trucks to transport their items once they are taken out of the apartment home by the eviction crew. And so it's at that point, typically the residents will transport their items or they will remain there.
So they get their possessions by picking them up off of the sidewalk or in the front of the house. Does anyone else have what their process is?
Yeah, I mean, I can speak, different property managers and landlords have different process, but I will say there's the legal process, which differs in different counties. Mm-hmm. But I will tell you, just the process is typically a lot of communication between the landlord and the tenant saying, when are you going to be out? Because the landlord is also thinking about, I've got to turn over the property.
Which they have to turn over anyway.
Right, but they're also thinking about, I need to schedule painters, I need to schedule whatever I'm going to have to do in terms of cleaning the property. So
which they would have to do anyway, correct? Even if the tenant was able to have a truck, and I didn't mean to cut you off, Mr. Castelli, yep, and they removed all their stuff, you still would have to pay a cost to turn over the property. So you're not incurring more of a cost, you're just delaying the cost that you would have to pay to turn over the property, correct?
Yeah, but delay, I would say delay is cost in the sense that every month, and take it from the small landlord's perspective. I mean, you may even have a mortgage still on the property. You're still paying that mortgage. The rent is helping you to defray whatever that mortgage is. So the longer that period is, you are going to be not collecting income that's going to help you defray.
That's fine.
So, but I think communication is the key, and I think there is, for example, when we were talking about the tenant holding over situation, you know, there's a 60-day notice which this legislature passed, really to provide, you know, 2 months of notice to someone to say, look, you know, this lease isn't going to get renewed. You've got 2 months to try and figure out what you're going to do with your property and where you're going to go.
So I do want to speak to kind of the cruelty of this. Does any of your properties literally lock people out of their homes so they actually cannot, without notice, so that they don't know? So it's one thing to know that the door's going to be locked on Wednesday, the 19th at 3 o'clock. Therefore, I have time to get out. But do your clients lock doors and lock folks out of their properties?
Well, you can't lock someone out until the warrant is issued. So like in Prince George's County, which the place I'm most familiar with, Ashley described it too, there is that period. And in fact, a lot of times, especially with our small landlords, they already have to have a moving crew just in case someone isn't there, so which is another pretty significant cost. But there's a period of reclamation that they have to do that. Now, there's not a notice necessarily, you know, the sheriff's, you know, at that point, it's the sheriff's duty to communicate.
And forgive me to jump in, but I believe it's state or local law, and we can get that information in which once the moving company's moving the property, no one can touch it until it touches ground on land, and maybe someone can correct me on that.
So I'm going to move on. Isn't there something like this in Baltimore City?
I don't understand the question.
This bill, it's something like this, not exactly in Baltimore City, correct?
Are you talking about the notice requirement?
And the ability to get one's possessions, yes.
I know that there's a notice,
Okay.
the 14-day notice requirement, but the reclamation period being 10 days.
So what do you do for your properties in Baltimore City? For the portion of it that is the same?
In Baltimore City, the notice is, the 14-day notice is provided to the tenant.
And do those people tend to get out in time to not have their stuff thrown out?
I think it just depends, and I think Delegate Terrasa spoke about it a little bit. There are instances where tenants are kind of waiting to see if there's any, maybe there's some support from social services or some family members that can step in to help them cure their deficiency in payment. And so it's not necessarily that the notice is giving them the opportunity to maybe move their things before. It really depends on the individual. So I can't say with certainty.
Right, so you're also not okay in this portion of the bill about the landlord being able to sell whatever is left over to the point of the broken aquarium to then put towards the payments that are owed for the tenant.
Okay, well, I guess what I will say is that for landlords, they're not really in the business of wanting to have to do that process of selling things to recoup the loss that they've incurred.
So it'd be discarded, more than likely discarded then?
Well, I guess it would be discarded if the resident doesn't take that with them.
Okay, thank you.
Delegate Stewart.
Thank you, Mr. Chair. Thank you all for coming. Your arguments this year, as in previous years, are good. I've been persuaded by them myself in past years. Clearly, as a committee, we've been persuaded by them. The Senate has been persuaded by them, which is why this bill's never moved. You got to help me out, though, because I'm a little stunned that you guys all have come in unfavorable instead of favorable with amendments. The reason I'm stunned by that is that in June, the Fourth Circuit dropped a huge bomb on us that I think has been, if anything, understated in the hearing today. They said even mediocre lawyers like me can read this opinion, and it's extremely clear what they're saying. They're saying that Maryland law, as it stands today, is flatly unconstitutional. No ifs, ands, or buts about it. So whether or not the answer to that is this bill or not, we will have a conversation about this session, and y'all will, of course, be at the table as always as we have that conversation. But help me understand how I'm supposed to vote against this bill and also uphold the oath that we all took to uphold the Constitution.
Well, I would say this, Delegate, to the extent that the committee is going to address these issues, you know, we always talk about the timelines to getting property back into productive use and rent it again. You know, tenant advocates will often say it's too short, we'll say it's too long, but there is a rationale behind it. I mean, we all know about the shortage of housing, and when you sideline properties longer and longer and longer, you're keeping it out of.
No, I get it, Mr. Caselli.
So I would say, and that's leading up to the point of it should be as short as possible.
Okay, I mean, listen, again, I told you your arguments are good. I've been persuaded by them. I'm just saying if the courts are telling us that what we're doing is unconstitutional, and specifically that no notice of a date and that no reclamation period is unconstitutional, I don't see how we can sit on our hands this session and vote this down or put it in the drawer or whatever this session, knowing that it's unconstitutional, right? We have to do something. I mean, wouldn't you all agree that we have to pass something this year? We can't just abide unconstitutionality, or else, I mean, are we just going to be in the business of ignoring the court? I mean, maybe we're headed down that way as a country anyway, but I mean, would you guys agree with me that we've got to do something this year to put our law on the right side of it? I mean, the court case cites Idaho, Alabama, West Virginia, all these states as examples of constitutional schemes, and then us on the wrong side of it. So wouldn't you guys just agree with me that we've got to work out something this session, whether it's even if a short reclamation period, we got to work out something this session if we want to be constitutional?
Again, it's 4th District Court, so they are not the final arbiter in terms of whether it's constitutional or not.
With the circuit court.
Yeah.
And the circuit court hasn't been appealed. So as far as I'm concerned, it's law. No one's appealing it. It's not going en banc. It's done.
So, but my point would be, you know, any process that we set, given the significant notice already built into the system, should be as short as possible.
Okay, appreciate y'all.
Great, thank you, Professor. I do just want to clarify that a Circuit Court of Appeals rendering a decision, we are bound to follow that. I just want to make that sure you understand that, right?
Yes, I do.
Okay, great. Thank you. I do not see any other questions. So that concludes the bill hearing on House Bill 767. We'll turn to House Bill 716. It's a departmental housing and community development statewide rental assistance voucher program eligibility alterations. Mr. Secretary. Welcome back to your favorite committee.
Chair Corman, Vice Chair Boyce, members of the committee, great to be with you again this afternoon. For the record, my name is Secretary Jake Day, the Department of Housing and Community Development. I have with me Assistant Secretary Greg Hare, Director and Assistant Secretary of the Community Development Administration. We are here today to talk to you about House Bill 716. My appreciation again to the chair for this hearing and for advancing this piece of legislation. This is a technical bill that is designed to change regulations for the statewide rental assistance voucher program. This program was enacted in the 2023 session, and it provides vouchers and housing assistance payments for low-income families that are on a wait list under the federal Housing Choice Voucher Program. It essentially acts as a supplement and addition to the federal vouchers. However, in the early life of implementing this program and designing the regulations for this program, some administrative costs as well as program procedures have impeded participation by the public housing agencies or PHAs around the state from participating. House Bill 716 will help the state voucher program operate more effectively by aligning certain aspects, including inspection guidelines, family contribution amounts, administrative expense rates with federal standards that are already published and in effect for the federal voucher, thus reducing administrative burdens on local PHAs. It amends some of the regulations around voucher prioritization to prioritize provide more flexibility to those PHAs in serving all vulnerable populations. It also codifies the Maryland Department of Housing and Community Development as a PHA under the program. By the way, under federal law, we are considered a PHA. It's the 2023 legislation that sets us apart as a different type of entity, and then promulgates some rules that differentiate us from other PHAs, which is not how federal law views the department. DHCD, so that I'm clear about this, DHCD operates as the PHA for the federal program, administering vouchers in most of Maryland's rural counties. But again, as amended in 2023, we are not authorized to administer the state vouchers as a PHA. That's a limiting factor in the viability and applicability of this program. This disparity in authorizations admittedly made it somewhat challenging for DHCD in our negotiations and conversations with PHAs to get this program implemented. House Bill 716 corrects those disparities. The creation of a statewide voucher program was a long time coming, in many ways groundbreaking, and really critical. We've even been asked to speak to other state legislatures about the importance of this program, and we're looking forward to being able to sing the praises of its success. The federal voucher waitlists are packed. And this program has already proved to be a crucial tool to assist low-income and vulnerable Marylanders to secure stable housing. The revisions in this legislation will smooth over some of the speed bumps that we've discovered when the rubber hit the road and make it a better, more impactful, and implementable tool. Finally, the department has been in discussion with partners like the Public Justice Center, Leading Age Maryland, and social work advocates for social change regarding a clarifying amendment to the family income contribution aspects of this bill. And I know that the organizations have submitted testimony supporting the amendment, and DHCD views that amendment and that testimony as favorable. We have also uploaded a letter in a separate document in addition to our written testimony supporting the amendment. So for those reasons, I request a favorable report on House Bill 716 with the addition of the friendly amendment, and Assistant Secretary Hare and I are here to answer any questions the committee has.
Great, thank you very much. Are there any questions on this bill? Delegate Seeler.
I just wanted to ask about the provision that a family assisted under the state program shall be expected to pay now 40% as opposed to 30. I've always thought this was one of the few instances where a percentage is less useful than a number, because there is an average rent. And if you make $30,000 a year, that's an entirely different thing than if you make $300,000 a year, if you see what I mean, in terms of leftover money for food and the rest.
I do. Delegate, I think it's a great point, and we're going to venture a little bit into the federal law dictating this right now. So the amendment addresses this issue of 40 versus 30. It doesn't address the precise amount, to your point, but the federal Housing Choice Voucher Program considers up to 40%. Our law provided for 30%, and thus the increase simply aligns with federal law. I think what the advocates that I mentioned are seeking to do is ensure that we stick to 30% and then say, unless federal law provides otherwise, which is essentially what we're trying to do, is make sure we're in alignment there. But with respect to an amount, I'm going to ask Assistant Secretary Hare to jump in here too. With respect to the amount, I think the variable that we would have to consider is that from year to year, the value of a housing choice voucher in each jurisdiction and in each market will change based on fair market rent calculations. And so aligning it by percentage probably just allows it to fluctuate with that FMR, but I'll ask Assistant Secretary Hare to weigh in and correct me if I'm wrong.
Yeah, Secretary Day, I think you covered it well, but I will say just at a really high level for the Federal Housing Choice Voucher Program, they do have this thing called essentially a payment standard, and they have essentially a total tenant payment. And so in some cases, a household that's of extremely low income, if their rent and utility cost falls under the payment standard that we set for that unit, the household might not pay anything. So it is still income-based in a sense.
Okay, thank you very much.
Okay, Thank you, Mr. Secretary. Mr. Assistant Secretary, that concludes the bill here on House Bill 716. We'll turn to House Bill 751, Delegate Schindler, Municipalities, Annexed Land, Land Use and Density. Delegate Schindler, welcome to the House Environment and Transportation Committee.
Mr. Chair, permission to have my panel come up as well? Thank you. Good afternoon, Mr. Chair, Madam Vice Chair, honorable members of the committee. Thank you so much for the opportunity to speak to you today. For the record, I'm Delegate Matthew Schindler, and I'm here to present to you House Bill 751. House Bill 751 would enable municipalities to have greater control over determining zoning of recently incorporated areas. Under current law, county governments maintain the final authority in approving or rejecting a municipality's request to rezone newly annexed areas. Specifically, if express approval is not granted by the county, municipalities are prohibited from rezoning newly annexed areas for 5 years if the rezoning is different than the authorized use or is at a substantially higher density in accordance with county zoning classification. This zoning restriction greatly inhibits municipal planning and growth as public-private partnerships become unattainable with these restrictive timelines. The bill simply changes the statute to use the comprehensive plans for land use in comparing the zoning of the annexed area. The comprehensive plan provides a more detailed analysis that would be more efficient in determining proposed zoning rather than relying on zoning classification of the county. This was originally instated in 2006 with House Bill 1141, which was sweeping legislation with the intent to make sure municipalities were engaging with smart growth planning principles. These other principles are in place, and all municipalities should be in current adherence with those policies. I'll respect your time and not rehash the fiscal note or written testimonies, but both DHCD and DLS both highlight the meaningful benefit for growth and housing development that this bill would create. County and municipal governments should promote collaboration, cooperation, and where possible to grow our economies and communities. At the same time, municipalities will be better equipped to engage in innovative strategies to support economic growth, housing development, and community revitalization if they maintain more local control over zoning within their corporate boundaries. The current express approval is too often used as a bargaining chip in unrelated negotiations instead of its intended purpose. This would take the subjectiveness away from a 5-year wait that often sees a municipality lose economic development opportunities or create unnecessary obstacles to urgently needed housing construction. Therefore, I ask for a favorable report for HB 751. Thank you.
Dr. Schindler, normally I let panelists go with the sponsor, but you said something that sparked a lot of questions up here, so I don't know what you said. All right, welcome to the House Environment and Transportation Committee. Why don't you go ahead and have your panelists speak in whatever order works for you.
Thank you.
Good afternoon. Thank you for this opportunity to speak. My name is Kathleen Marr. I'm the Director of Planning and Code Administration for the City of Hagerstown. I have been working in city planning for Hagerstown for the past nearly 30 years. The city supports this proposed change to the annexation process. It will provide greater certainty and flexibility of property owners and developers seeking to annex into municipalities. The current process, which has been in place since 2006, requires municipal zoning to be not substantially different from the existing county zoning. The conflicts arise when it comes to residential zoning. Urban municipal zoning and rural suburban county zoning are typically quite different when it comes to permitted dwelling types and density levels for residential zoning. If the residential zoning is substantially different, the county commissioners must approve the zoning change for development that will occur within the municipality. In our experience, that process takes a very long time, which creates frustration for the prospective developer and property owner. When approval is ultimately not granted, which often happens for us, the developer walks because they are not willing to wait 5 years to use the municipal zoning. Proposed change would take this process back to what it was before the 2006 change. Zoning assessment was on the compatibility of the land use and density recommendations in the comprehensive plans. Comprehensive plans more broadly recommend low, medium, or high-density housing for areas deemed appropriate for that type of development. When the zoning assessment process was based on the comprehensive plan, there were far fewer conflicts regarding assignment of zoning for annexation. It is time for this change. Municipalities are now limited to annex within the growth area prescribed in our comprehensive plan. This is another change from 2006. Our comprehensive plans are required to do extensive analysis to ensure proper growth management planning is in place, especially for annexations. The time for the more punitive zoning ordinance comparison for annexations is past. It only creates red tape and conflict and results in an impediment to smart and sustainable residential growth. The governor has made it a priority for Maryland to address our housing crisis. This change will make it easier for municipalities to do our part.
Good afternoon, Chairman Corman, Vice Chair Boyce, and members of the committee. My name is Jill Thompson, and I serve as Director of Community and Economic Development for the City of Hagerstown, and have been serving the City of Hagerstown for nearly 14 years. The bill provides reasonable authority to municipalities to have exclusive jurisdiction over planning, subdivision control, and zoning in an annexed area. The bill allows a municipality to apply zoning classification and encourage development that is consistent with and not substantially different from land use recommendations in the comprehensive plan of the county or municipality applicable at the time of the annexation, including not exceeding 50% of the density that could be granted in accordance with the comprehensive plan recommendation. Hagerstown, like cities across Maryland and the United States, is facing workforce and affordable housing shortage. There is land contiguous to the corporate boundaries of the city of Hagerstown that is available for residential development, and we need this tool to attract housing developers. Recently, we worked with several housing developers who did walk away from their projects that could have created 900 to 1,000 units of new housing because this tool did not exist to provide the zoning classification that was reasonable to us as a municipality and to what the desire of the developers were. And this included our efforts to attract developers from Pennsylvania and Florida, and a number of conversations that we were not successful to move forward. A developer will enter into a contract to purchase a property. They will work to secure their zoning entitlements through a due diligence period. When they fail and exit the contract, not only do we not get the housing project. Thank you.
All right. Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. Justin Fiore here on behalf of the Maryland Municipal League in support of House Bill 751. As you've heard now, we're about 20 years into this experiment with express approval, and it's clear that we're losing out on housing, and we're losing out on housing in the very areas it makes the most sense to build. But during this time, we've also made significant strides in our smart growth planning as required by that legislation in 2006, which requires any municipality with zoning authority to have a growth element that covers where they expect to grow, the impact to the services, how they'll finance this. We're talking schools, libraries, recreation, public safety. All of these facets are in these growth plans that we're talking about today. And while we've taken these steps forward, significant steps forward in our smart growth planning, we have not in our growth. So we think it's time to tweak the experiment. And if you want us to build housing where it makes sense, where we've already planned to build housing, we ask that you provide a favorable report on House Bill 751.
Thank you. Are there real questions for the sponsors panel? Delegate Lewis.
Thank you, Mr. Chair. Thank you, Delegate, for this really interesting bill. And thank you to your panel for coming a long way. I think some of you came from pretty far out west, so thanks for being here. I'm curious. I think we've all had, a gallon of the smart growth Kool-Aid, and at this point, I think it's general consensus that we should concentrate development in a way that's sensible, that uses resources and doesn't lead to sprawl. I'm curious, Delegate, whether this bill could potentially contribute to sprawl. And that raises a red flag for me, particularly in places that are still green and wooded and beautiful and untainted. What impact do you expect this bill to potentially have on sprawl?
Thank you, Delegate.
Whoever's
And
best to answer.
Could I perhaps ask Ms. Meyer to address that?
I'm the planner at the table, so I knew this was coming my way. Because of the changes required to be made to comprehensive plans for cities, we are expected to look at the raw and redeveloping land in our community as well as potential growth on our boundaries to see what does that zoning and land use recommendation, what could it yield, how many housing units, et cetera. Then see what is your water and wastewater capacity, what can you serve it or not? And then we're supposed to.
Excuse me, could you stay a little closer to the mic? Or
sorry.
Bring the mic close to you. Yeah, make the mic do the work. There you go.
And we're supposed to set a boundary that our analysis shows that we can serve. So that's a mechanism to contain sprawl, so that we know we've assessed what the land could generate, we know what utilities we have, we can serve it, and this is the boundary we're set. And we cannot annex beyond that boundary.
So if I'm understanding, and thank you for your answer, if I'm understanding, you're saying that existing planning provisions would inhibit sprawl, even if it's...
For municipalities, yes.
For municipalities. And if I may, Mr. Chair, I also think this bill is interesting in that it lends to our state's committed goal, a goal that Governor Moore has expressed, to increase housing availability and affordability. And you mentioned that, for example, I think in Hagerstown, you mentioned that you've had opportunities to attract residential housing development, but those opportunities were quashed because of the prohibitions or your inability to approve development on properties that that counties can, control. So are you saying that if this bill were to pass, a place like Hagerstown that has already identified an area to annex, that already has a development plan, could now welcome a developer from anywhere to put up hundreds of units of all different kinds of housing? I mean, you can't now. This alone would make that possible.
Sure, I can speak to the 900 to 1,000 units of housing were located on the corporate boundaries of the city of Hagerstown. They were inside the medium range growth boundary, which is what Kathy referred to as the designated smart growth area. And this tool, had it been in place at the time of those conversations with 3 development companies, could have resulted in a level of density that is consistent with the urban environment that the developer desired, and a density that contributes toward workforce housing goals and affordable housing goals.
Mr. Chair, if I may also. Delegate Luz, thank you for the question. To your point, yes. The detriment to these developers was both the waiting period for the express approval, which we had to wait to even see if we would get express approval for that proposed change in zoning. And then once we did not get approval, it was the 5 years of waiting before the developer could do any work at that new density, at that new zoning. So that, I mean, that is such a deterrent to development, and especially in our area, but I know in others across the state as well, that 5-year moratorium is such a detriment.
Thank you. And Mr. Chair, if I might, just one last little bite at the apple. So I'm still learning about zoning, and I appreciate the patience of the planners at the table to explain the perspectives of developers have been well represented. I think I get that. But my last question is about the people of your region and their desire for more housing, different housing types. Not everybody wants to live in an apartment. Not everybody wants a single-family home with a yard that you have to mow the grass or buy sheep to eat the grass or whatever it is that folks do. Do the people of your region actually want more housing choice? Because ultimately, we're all here representing the needs, desires, and interests of the people of Maryland, not necessarily corporate entities. If this bill were to pass, would it serve the expressed desires, will, and needs of the people?
I'll speak to that, and if anyone else would like to chime in, if that's okay, Mr. Chair. Yes, so specifically, I can speak to my experience. Our area is very blue collar. We have warehouses proliferated across our county, blue collar workers that are making warehouse job wages that need affordable housing. They need the type of housing you're speaking of. They may not be able to afford on their income a single family home with a yard and a picket fence, right? But they need a place to live, and our citizens would like to have a place to live where they work. Right now, we have many, many citizens, and I think you could both speak to this, that commute, because in Hagerstown, you can go 15 minutes and you can live in West Virginia. Or you can go 15 minutes and you can live in Pennsylvania, because we're at such, the skinniest part of the state. So we are driving away our own citizens sometimes that, where they could work and live in Maryland, are choosing to go and live in other states, frankly, because they don't have the affordable housing available to them where they work.
Great. I do not see any further questions for the sponsors panel, so thank you. We do have a number of unfavorable witnesses. I'm going to call up more names than there are seats, so please do a little rotation after you speak. Michelle Gordon, Washington County Board of County Commissioners. Bruce Barriano on behalf of Washington County. Jill Baker, Washington County Government. Zachary Kiefer, County Commissioners of Washington County. And Michael Sanderson, Maryland Association of Counties.
Michelle Gordon, County Administrator for Washington County. Thank you to Chair Corman and Vice Chair Boyce and respected committee members. The Board of County Commissioners of Washington County wish to express their opposition to House Bill 751. As an elected body, the board is invested in the well-being of our community and our state. We believe that this legislation is detrimental to cooperative planning efforts between counties and municipalities, especially if left unchecked. This bill seeks to dilute the ability of the county to have input related to the impacts of the growth that will potentially affect its infrastructure and resources. Currently, annexation law requires a county and a municipality to compare the current and proposed zoning districts for land seeking annexation. The comprehensive plan is a guidance document, not a regulatory document. Land use policy areas contained in the comprehensive plans are generalized and do not specify permitted uses or residential densities. Implementation of these policies is achieved through the amendment of local zoning ordinance, which provide a more definitive and consistent metric. Typically, land being annexed into cities contains infrastructure that is owned and maintained by the county. More often than not, the municipality will not assume responsibility for the infrastructure being annexed, nor does it contribute to the future maintenance. Annexation also lowers the county's ability to collect property taxes due to differentials ceded to municipalities. Ultimately, this leads to the county having the same amount of responsibility for maintenance with less resources to serve all citizens of the county. The Board of County Commissioners of Washington County urges you not to support this bill. And although we disagree on this bill, I'd like to thank Delegate Schindler for his work representing our shared constituents. Thank you.
Good afternoon. Jill Baker. I am the Director of the Department of Planning and Zoning for Washington County. Thank you, Mr. Chair, and the members of the committee for the opportunity to speak on this bill. The proposed language of this bill is an attempt to link annexation law to the recommendation of a comprehensive plan. By doing so, you are effectively making a plan a regulatory document. This thereby undermines the purpose of a comprehensive plan, regulatory documents such as zoning codes require a level of specificity and enforceability that a comprehensive plan simply isn't designed to do. This could potentially create confusion and conflicts between the plan's broad objectives versus specific legal requirements. Zoning codes provide more specificity to the gradient of development that may occur. As an example, zoning codes can specify the location of a neighborhood grocery store versus a Walmart. On the other hand, the broad land use policies of a comprehensive plan cannot do that. This highlights the conflicts that can arise when planning for future infrastructure and resources based upon the intensity of potential land uses between jurisdictions. There's no persuasive need for this language. The existing law provides a much clearer method of comparison between the existing and proposed land use patterns between the county and its municipalities. As far as the ability of housing to occur in Washington County, we fight this every day in terms of how small we are and close we are to both West Virginia and Pennsylvania. We see more competition from those two areas that are pulling from our resources than anything. So the development that was referred to by the city was also a development that sat on the very edge of the city and next to a commercial industrial district proposed by the county, therefore creating further conflict. That is one of the many reasons that we would urge you to keep the zoning rather than comprehensive plan land use policy areas. Thank you.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the committee. For the record, Bruce Ferriano here on behalf of Washington County. For the sake of brevity, and it was so articulately expressed to you in opposition, I would adopt the testimony of the folks you just heard from, and don't have anything further to add, and would ask for an unfavorable vote.
Thank you, Chair Corman. Following Mr. Bariano's lead, I'll simply adopt that of the testimony of my colleagues and cede the rest of the time. Thank you.
Great. Mr. Bariano, can you slide out for Michael Sanderson? Can you just rotate with Michael Sanderson?
Want me to step out?
Yeah, just so Michael Sanderson can sit down. If there's a question to you, we'll direct it to you. Yep.
Thank you very much. Mr. Chair, members of the committee, I'm Michael Sanderson with the Maryland Association of Counties. Heard a great deal about some local concerns with land use in and around Hagerstown, but just understand that the bill before you is a statewide bill with repercussions everywhere. We made mentions earlier of 2006. Oh boy, was 2006 a year in this committee. The big debate, white hot real estate market, and folks were going absolutely bananas. We had developers who wanted to build a strip mall find themselves a pipe stem annexation. I'm 1.25 miles away from a small town, but I want to find a way to get on their zoning so I don't have to go with the tougher zoning for the county. It was a big, big deal. We wanted stuff, the towns wanted stuff. This committee beat the heck out of us and ended up with a compromise that includes the stuff that's being amended in this bill. There's a lot in this bill, even though it doesn't have all that many words. Really big consequences, but the fundamental question here is, does the idea of someone saying, I want to be part of the nearby town and play by their rules tomorrow, not after time, but tomorrow, is that something that's no consequence for anybody else? Are there no ripple effects for the rest of the area and so forth? This committee some years ago said, we don't want to go that far. And I think it was probably the right thing to do. They didn't do everything counties wanted. They didn't do everything municipalities wanted. We ended up with new things in our land use plans and so forth. I think on balance, that was a good compromise. You end up saying you play by new rules as soon as you annex into the nearest town, and it's a ball of yarn for every adorable development idea out there. There's a Pandora's box here. This is a really big deal bill. I got concerns. I understand where Washington County and Hagerstown are coming from, and the desire for housing is powerful. There's a lot more than that in this bill.
Great. We have a question from Delegate Healy.
Thank you to the panel for being here and for your perspective. I did have a couple questions. I mean, obviously, this is a classic municipality, county. This is where there's a rub. There's always a rub. And that I wanted to ask you about one of the things you mentioned in your testimony. You said about the tax differential costing you revenue, but it seemed, I happen to know a little bit about tax differential, and that is designed to offset for the people who live in the municipality and receive municipal services that the county does not have to provide because municipality does. So it's not really a loss because they're paying for something, they're not paying for something, they're providing it, providing the same service. You don't have to provide it to them, whether it's trash collection or snow removal or whatever it is, police protection. And there's a formula to do that so that it's a balance. So I'm kind of curious as to why you think that you're going to lose money because of the tax differential.
I think what we're trying to get across here is maybe not necessarily the loss of taxes. The fact that when the infrastructure is then annexed into the municipality, i.e. roads, water, sewer, things like that, the offsets don't necessarily take care of those. The county is still required to maintain those resources under our jurisdiction, but with less money because that's not necessarily included with the offsets. As far as police, fire, rescue, trash pickup, all those kind of things, obviously those are readily available. This doesn't even go into the aspect of schools and how this impacts our schools, where our municipalities typically do not put any money into that.
Okay, but
that offset does take care of that.
Thank you. Thank you for your response. And the other thing was, Mr. Sanderson, you talked about after time. I wonder, I mean, is 5 years the right amount of time? Is it maybe a year, 2 years, 6 months? Is there room for compromise on that issue between you guys? Because I joined this committee in 2007, so I missed all of that in the committee, but I was on the periphery of it, so I heard about it. So please.
I want to not be too cute with an answer. So I don't think this bill really came from the municipal league. This isn't a fight between the two organizations. There's a local issue in and around Hagerstown, turns into a bill. Municipal authority needs to be statewide. You can't do a local bill just for Hagerstown. So
Correct.
Nuts and bolts here, that's why there has to be a statewide bill.
Correct.
We certainly could have brought you another piece of legislation saying 5 years is not enough. I could have given you 2 panels of testimony to say 5 years actually is still too strong an incentive for perverse outcomes in the annexation process. We didn't do that, it's fine. But I hope that the idea of, well, we're at 5 today and this bill suggests 0, let's find some room in the middle. It's tempting to do, but that's just, I mean, it's creating a false incentive. I don't want to come here with a phony bill that says just go to 12 years just so we can negotiate more strongly.
Well, let me ask you this. I mean, it's been some time since 2006, and as my colleague has said, the issues are different now, and we have a need for new housing throughout the whole state. We have a deficit of 100,000 units in the state. So we're looking for ways to help people who don't so they won't have to move to West Virginia or Pennsylvania in order to live and still want to work in Maryland where there are better jobs. So there are always balances that we have to find. And I wondered if you would be willing to work with that.
So I would say on behalf of MACO and our county leaders, we're eager to work with the committee in a variety of ways. I'm not sure this is the most productive way to do it. I think it's a really indirect way to get at that problem. You've got much more direct legislation, including when should the county be able to say no to a housing development based on school overcapacity and things like that. You've got that bill in this committee already this year, and we're at the table on that one. I think that's the fastball down the middle. This is a curveball bill.
Thank you very much.
Sorry, that bill from the governor, though, wouldn't affect this particular problem at all, right?
If the concern, I confess, I really don't know the facts on the ground in and around Hagerstown. But if the concern is that the county's laws say we can't develop more in this area because we are overcrowded in those schools in that area, I mean, that's one of the things that's dead center in the governor's bill, to say you're only allowed to say no to a housing.
The governor's bill doesn't override the local zoning.
No, but what it says is you have to have a good, you have to have a really good, strong reason to do
But
that.
if it's zoned for single-family homes and you want to put up apartment buildings, the governor's bill has no impact. But we'll get to that hearing, I guess.
But this is the bill that says if it's zoned for agriculture and you want to do a strip mall, that's going to be fine. That's what this bill is about. That's what this
I
bill
just want to be
says.
clear. You're citing the governor's bill as we have the bill to deal with this. And the governor's bill does not deal with this situation. Because under the governor's bill, if something is zoned single-family, a product that is not single-family is not eligible under the governor's bill.
Yes, I understand. But another important element from the governor's bill says that for a local jurisdiction that has zoning authority to say no to a project that is for housing, it has to pass tests to do so. If a county's being unreasonable and saying, oh, we're using.
If it's zoned that way, Mr. Sanderson, it can't, the governor's bill doesn't override the zoning. That's not what that bill does.
And I think that's the question we have, is that this amendment shifts the focus from zoning to land use policy areas, which are not intended to tell you what the zoning district should be.
Great.
So I think that's part of our focus here.
Okay. Look forward to having Mako back on the governor's bill. I do not see any further questions, so I think that concludes the bill hearing. On House Bill 751, we'll turn to House Bill 755. Delegate Foley, Common Ownership Communities, Recreational Common Areas, Sensitive Information as Condition for Access.
Mr. Chair, can I call up my panel? You can sit here. Sit here.
Good afternoon, Chair Corman, Vice Chair Boyce, and the wonderful members of the Environment and Transportation Committee. I'm Delegate Linda Foley, and I am introducing House Bill 755, Common Ownership Communities, Recreational Common Areas, Sensitive Information as a Condition for Access. This bill, I should note, is cross-filed in the Senate as SB 540 by Senator Charles. The reason for this legislation arises from a constituent's concern. That constituent, Shula Clark, will be testifying today. She resides in Clarksburg, Maryland, and was in the process of obtaining pool passes for her children. When she learned that she needed to provide her homeowners association with her children's birth certificates. Yes, you heard that correctly. This, of course, was a major concern. She has owned a home in Clarksburg Town Center for 5 years and pays her HOA fees regularly on a monthly basis. Recently, her HOA decided they wanted to audit her pool passes and demanded that she prove the parentage of her 5 children who already have pool passes and share her last name, by the way. They required her to show them the children's birth certificates. They then turned off access to the pool when she refused and stated that she would not be able to use the facility until she showed them her kids' birth certificates. This practice is not only an unreasonable invasion of privacy, but also raises serious concerns about potential discrimination and may threaten the safety of some families and children. Demanding birth certificates could potentially expose private information about adopted children whose families may not yet have disclosed their adoptive status. Ms. Clark said she was appalled to hear that her HOA makes parents who adopt children show the adoption documents and birth certificates. In addition, birth certificates, as you may surmise, may reveal a child's transgender status, which could lead to unnecessary scrutiny or discrimination. In addition, COCs should not have access to residents' sensitive information that might reveal personal financial information, religious affiliation, national origin, or immigration status. Keeping that information private is especially important given the current situation in our country. Montgomery County Council member Marilyn Balcom's office has worked with me on this issue. A strong letter of support from Councilmember Balcom is attached to my written testimony. It's my understanding that she sent that letter to each member of the committee. I also want to point out that the Women's Legislators of Maryland, the Women's Caucus, also supports this legislation. An HOA or COC does not have a legitimate need for sensitive personal details about its residents, and there is no guarantee, by the way, that the association has adequate data security protocols in place to protect this sensitive information. There are far less intrusive ways for a COC to verify residency for common amenity access purposes. As lawmakers, I believe we have a responsibility to protect the privacy and civil liberties of Maryland residents, even in the context of community associations. Requiring individuals to disclose sensitive information like their social security numbers, birth certificates, immigration status, or religious beliefs, just to use a community pool or playground is an unreasonable invasion of privacy. This bill, I believe, strikes the right balance. It still allows COCs to require a government-issued ID for secure access and safety purposes, but prohibits them from collecting more sensitive personal data that could be misused or lead to discrimination. Residents should not have to sacrifice their privacy in order to enjoy the amenities they've already paid for through their HOA or condo fees. Protecting individual privacy is a core American value, and I believe this legislation is an important step in upholding that principle within the context of common ownership communities. I urge the committee to give this bill a favorable report and send a clear message that Maryland values and Marylanders value the privacy rights of all citizens in this state and all residents in this state. Thank you very much, and I'll be happy to answer any questions. And now, if I may, Mr. Chair, I'd like to go to Ms. Clark.
Okay. Good afternoon, members of the committee. My name is Shula Clark. I am a resident of Clarksburg Town Center, as mentioned. I'm here today to testify in strong support of this bill. Just a brief disclaimer, I am here as a private citizen in capacity. My views does not reflect the agency that I work for. Okay, so I've personally experienced intrusive and unnecessary data requests from my HOA in Clarksburg Town Center. They currently require residents to submit their children's birth certificates to obtain pool passes. This practice is a gross overreach of their authority and a serious invasion of privacy. This policy raises several concerns. Privacy violation. Birth certificates contain private family information that should not be shared with non-government entities like HOAs. There are no assurances that this sensitive data is being stored securely, leaving residents vulnerable to potential data breaches and misuse. There's also a national security concern. Maryland is home to numerous federal agencies and employees such as the FBI and CIA. Imagine the potential security implications if these individuals were required to submit sensitive documents like birth certificates to the HOAs. This creates an unnecessary vulnerability and a potential target for those seeking to exploit such information. We must protect the privacy of those who protect our nation. This bill is crucial for protecting the privacy and security of Maryland residents. It sets clear boundaries, preventing HOAs from overstepping their authority and demanding sensitive information they do not need. It ensures all residents, regardless of their family structure or background, can enjoy community amenities without fear of discrimination or privacy violations. I urge this committee to favorably support this bill. Thank you for your time and consideration.
Good afternoon, Chair Corman, Vice Chair Boyce, and members of the committee. My name is Jose Coronado Flores. I work for the organization CASA, Maryland's largest immigrant advocacy and services organization. But I'm also here as a DACA recipient who would feel totally discriminated if I was requesting my social security card or my passport to access my condo's gym. HB 755 is a critical piece of legislation that addresses protecting people's sensitive information for spaces that they should already have access to and feel entitled to. CASA has been a long advocate to ensuring individuals' private information is not collected unnecessarily and misused. This bill addresses practices in cooperative housing corporations, condo associations, and homeowner associations that are asking for unnecessary and excessive documentation just to access these recreational spaces. These individuals, as I said, have a right to these spaces by simply being members of these organizations or having their homes in these communities. It's wholly unreasonable for these types of associations to demand highly personal documents to access something like a billiards room, a pool, or a gym. Requesting these types of documents is definitely a form of discrimination and creates barriers for community members who can be nervous to share this type of information. With the growing uncertainty around federal immigration attacks and the growing fear among the immigrant community in general of people of all immigration statuses, it's important to make sure that our community members feel welcome and have the ability to access spaces to, like I said, are already entitled to. For these reasons, CASA urges a favorable report. Thank you.
Chair Corman, Vice Chair Boyce, members of the committee, my name is Karen Strawn, and I work for the Office of the Attorney General in the Consumer Protection Division. I don't want to be duplicative of testimony that you've already heard, but I will point out that the sensitive information specifically excludes a driver's license. So there is a way for the association to make sure that someone is residing in the area that they live in, to make sure that they are doing what is necessary to make sure that people who are paying the fees are the ones who are getting benefit. It's a balancing act, but that balancing act should not allow for such sensitive information to be taken. And when you think about it, many times a pool is being run most of the day by teenagers. They are the lifeguards. They are the ones who are taking information when you come in. And those teenagers don't necessarily know why it is important to keep that information private. They should not be sharing that sensitive information. They should not have to share that sensitive information. And I have gotten complaints from people that we cannot help because it is not a statute. So for those reasons, we also would ask for a favorable report.
Great, thank you. I have a question from Delegate Holmes.
Thank you, Madam Chair. And Ms. Clark, huh?
Mr. Chair.
Oh, yes. I'm sorry. Sorry that you went through that. What happened when you submitted your complaint? What happened when you submitted your complaint to the board of directors or your community manager?
Nothing happened. They came back and said that there are no laws that restrict them from performing the act of asking for your birth certificates.
Thank you.
Vice Chair Boyce.
Thank you, Mr. Chair. Thank you so much, and thank you, Delegate Foley, for bringing this bill. So just so that I have the story correct, your children had passes as residents there, and they still required their birth certificate upon entrance of the pool?
Yes, ma'am. So essentially, we had passes when I moved in 2019. Sure. As I think the summer of last year came around, the community center decided that they wanted to do an audit of the pool passes. And so that's when they came and said, hey, you either have to send us your birth certificate by email and or come in person and show us your birth certificate to verify your children. I'm sorry.
Your children are on your lease or your...
Well, I own my home.
I'm sorry.
Yes.
My mistakes. So it doesn't matter, actually.
Yes.
And has that happened before with anything else?
No, just that particular incident.
Interesting. Thank you so much.
Any further questions on the bill? Delegate Healy.
I just want to thank Delegate Foley for the bill, and I just wanted to address, one of the witnesses asked for an amendment to include medical conditions as things that you're not supposed to ask for in your bill. Have you seen that? Are you interested in that?
I have not seen that amendment. I didn't know about that. I mean, that is, that person submitted that as testimony. I've not seen an amendment to that.
Okay.
I don't know that I would oppose that as the sponsor of the bill.
Okay, thank you.
Okay. Thank you. That concludes the bill here on House Bill 755. We'll turn to House Bill 563, Dorchester County Delegation, County Property Leases Notice Exemptions. Is Dominic Setter-White here? Great, come on down. Please begin when you are ready.
Make sure you all can hear me adequately. All right, whenever.
All right, thank you, Chair Corman, Vice Chair Boyce, and members of the ENT Committee. My name is Dominic Satterwhite. I am the legislative intern for Delegate Hutchinson, who is the delegation chair for Dorchester County, and I'm here on his behalf to testify for House Bill 563, which is also cross-filed as Senate Bill 797 with Senator Moutz. This bill simply allows Dorchester County to enter into a lease with a term of 5 or less years without providing a published notice for 3 successive weeks in at least one newspaper of general circulation in the county. These types of leases will be added to an open session agenda for the county council's review and consideration so that the public will still have the time and opportunity to comment. The county council has approved of this and is asking for this change to omit the increasing advertising fees as well as to expedite the process of county property leasing. On behalf of the Dorchester County delegation, I respectfully ask the committee for a favorable vote on this bill. Thank you.
Thank you. Are there any questions on this local bill? Delegate Foley?
Thank you, Mr. Chair. Isn't it so that last year there were some changes made with respect to Dorchester County in the law and the publication of notices like this?
I believe they had a bill similar to this, but I'm not sure to the extent of which it related to this particular instance of the leasing itself. I know there was something with advertising, but I don't remember if it was for property leases through the county.
I think they may have been covered by the bill that was passed last year. So I just, want to make sure that we don't undo the work that we already did, right? So.
That would probably be a better question for Delegate Hutchinson, just because, again, as far as I was aware, it was for 2 separate areas, as far as I know.
Okay, thank you.
Great. Any additional questions? Okay, thank you very much. That concludes Bill hearing on House Bill 563. We'll turn to House Bill 768. Delegate Johnson, municipal incorporation, county commissioners or county council required approval of referendum request. If you have a panel or anything, feel free to bring them up.
Good afternoon, Mr. Chair and members of the committee. I'm Delegate Steve Johnson, here to present House Bill 768, Municipal Incorporation, County Commissioners, County Council require approval referendum request. There is a cross-file SB 546 to this bill. This is more of a taxation without representation bill. Right now, we have areas in our state that have taxation with little representation. They do not have anyone advocating on their behalf. The reason areas look to incorporate or to have authority over development, finances, government services, apply for grants, and decide what quality of life projects they want in their communities. They want to elect a mayor and council from their own community to advocate on their behalf. Under current law, local government article prescribes the manner in which a new municipality may be incorporated under Article 11-E of the Maryland Constitution. In order to incorporate, a community must consist of a minimum of 300 residents in the area proposed for incorporation. A petition to incorporate must be submitted to the county in which the area proposed for incorporation is located. A standardized petition form developed by the Office of Attorney General is available for communities seeking incorporation through each county's local board of elections. If the community's petition satisfies statutory requirements such as at least 25% of the registered voters who are residents of the area proposed to be incorporated, or at least 20% of the registered voters who are registered of the area proposed to be incorporated, together with the owners of at least 25% of the assessed value of the real property of the area proposed to be incorporated. The county must appoint a liaison to work with the community organizing committee to develop a proposed charter and exchange comments between the county and the organizing committee. Next, the county may, and this is where we really have a problem in our state, the county may schedule a referendum on the matter of incorporation or reject the proposal of incorporation. House Bill 768 proposes that the county commissioners, county council shall approve the referendum request if a valid petition is presented by not more than less than 40% of registered voters who are residents of the area proposed to incorporate. We upped that percentage because we thought that was a fair trade-off to have the counties make it, they shall put it on the referendum. We wanted to make sure that we weren't wasting the time of the county or money, so we upped the percentage of the signatures to 40%. In 1954, the General Assembly's involvement in local municipal affairs diminished significantly with the ratification of Article 11-E of the Maryland Constitution. But I don't think when we did that, we intended for there to never be any more municipalities in Maryland. Since the ratification of the Municipal Home Rule Amendment, there have been only 5 new municipal incorporations, 5 since 1954. All these municipalities are in Montgomery County. The Maryland Municipal League indicates that over the recent years, several attempts at incorporation have failed in the state. The trend, incorporation of municipalities is not merely a formal establishment of a town. The process is one of empowerment for the communities. Government is present at all levels of American life. Yet when we think about our small towns, we don't necessarily associate them with government. The sphere of influence in a town is smaller than the federal government and even state government, where interests of these communities aren't always prioritized. Unincorporated areas can have public health implications, economic depreciation, and overall lack of autonomy for the citizens that reside in them. In 2010, according to the study published in Social Science and Medicine, around 37% of the entire U.S. population live in unincorporated towns. Census data from 2000 demonstrates that 2 times more people live in an unincorporated town rather than an incorporated one in the state of Maryland. This population trend has continued over the decades, with less than 20% of our citizens living in legitimate municipalities. Local government determines what kind of services are available, such as school transportation, road maintenance, and policing. A lack of local body lessens the ability to acquire these resources, putting Marylanders at a disadvantage and abandoning them in their time of need. Doing better by individuals takes shape of municipal incorporation. By increasing the services that are available, we are sure to see improvement in quality of life. From the economic standpoint, incorporation attracts investment and growth and local economy, increases revenue, and drives employment. Of the states that comprise the East Coast, Maryland qualifies as the state with the most unincorporated towns. So we're looking to change this. Not only does municipal incorporation provide much-needed organizational functions to the towns in our state, it nurtures the government at the local level. It encourages involvement in community members and is a fundamental component of American democracy. This enables our citizens to thrive. This summer, I was invited to be a moderator at MACO, and I was the moderator for county and municipal communications. So after we finished those discussions, we moved on to the discussion of municipal incorporation in Maryland. I thought I was going to start a turf war, but instead, it was a very comprehensive and engaged conversation in how we move our state forward. And I do believe that municipalities play a big part in Maryland moving forward. And with that, I would like to ask for a favorable report on HB 768. Thank you.
Good afternoon again, Mr. Chair, members of the committee. Justin Fiore here on behalf of the Maryland Municipal League in support of House Bill 768. Last year, you heard me say that the system in Maryland here is fundamentally broken. And that's true. There was reference to 5 new municipalities created. There has not been a single new community, so not already a special taxing district, that's been incorporated in the state of Maryland in over 70 years. We've focused a lot of conversations the past few years on Edgewood, which I know is in the delegates' district, and how they've been underrepresented. But Mako would have you believe that this would open up the floodgates. I'm not sure that's true, but what floodgates are we talking about? To economic development, to representation, to housing? Here's what we do know. Population's growing about 4 times faster in municipalities than it is in non-incorporated areas. Property values increase 12 to 13% over time due to value that's being cultivated in municipalities. 1/3 of all state sales tax is generated in municipalities. It's 5% of the land, generates 1/3 of the entire state's sales tax revenue. So in addition to providing a voice for communities that are left behind, municipalities are benefiting the state as a whole. And so unless the General Assembly wants to take back the authority to create municipalities, we're asking for a better balance at the local level so that one form of government just can't keep saying no to the other. So with that, we ask for a favorable report on House Bill 768.
Great, thank you both. We have a question from Delegate Foley.
Thank you, Mr. Chair. So I just want to understand how this process works, because I'm a little bit confused by the way the bill is written. So, and it may be me, probably is me. So as I understand it, the county commissioners of the county government, county council, whatever, does a report and posts a report on their website. And then a group of residents or registered voters, it says, in the area that is under consideration, that at least 40% of them have to express their desire to have a referendum on this, to do this, right? So first question is, when does the clock start? Because there are time limits in here when they can do this. When does the clock start? Does it start when it's posted on the website? Does it start when the county council, does the county council or county commissioners institute some sort of process? How do the residents know when their clock starts? Because if you just post it on the website, they may not know that that's under consideration, right? Like they would, how would they know when to start the clock? That's my first question.
Well, first they get together and they, with a community municipal community group, and they then have to start getting signatures in the area that's proposed. Then they take those signatures to the county, and the county then has to verify the signatures that they live in that proposed area to be incorporated. And so it would go from the time that they approach the county with the signatures. And from there, they move forward. But right now, the county can just throw it in a drawer, and that's the end of it.
I got it. Okay.
So this is enabling legislation. The folks would still have to vote on it, but at least, a lot of our jobs here as legislators on the state level is creating pathways. And this is just a pathway for citizens, if they feel they're being underrepresented or not being represented, to create their own form of government from leaders in their own community.
Okay, so it's instituted by the residents themselves.
That's correct.
Okay, thank you. That's my first question. If I could, Mr. Chair, another question. All right, so then later on in the bill, after it talks about the 40%, right after it talks about that, this is where I'm really confused. It says if a referendum request presented by less than 40% of the registered voters who are residents, then it looks like the county commissioners or county council, and this was existing law, can by resolution do it anyway. Is that right? They can require the referendum anyway.
So currently, that's what happens as long as residents, 25% of the residents file the petition. So what this bill is saying is that if you get to 40% of the residents, it will go to referendum. It will go to a vote. If it's anything less than 40, then the commissioners may still take it to referendum, but they don't have to. So there's still that ability for county to block a municipal incorporation referendum for anything under 40% of the proposed residents.
Okay, thank you.
Yep.
That clears it up. Thank you.
Delegate Lewis.
Thank you, Mr. Chair. Thank you, Delegate Johnson, for bringing this bill. It's really interesting. I'm curious. Are there, to your knowledge, examples in other counties and other parts of the state of Maryland where residents have petitioned to incorporate as municipalities and been denied more than once?
There's one in Harford County in 97.
But that's your county.
That is my county.
Okay, I
yes.
meant other parts of the state.
And there was one in Montgomery County, or wait a minute, in Montgomery County in 2007. There was one in 2017 in Calvert County.
Do you know? Sorry,
there have been several over the years that, again, have just been rejected by the counties, not even taken to a referendum, for the folks to have a choice whether they want to become a municipality or not. The decision's being made for them.
Thank you. And do those three examples, just taking those three examples, do they have anything in common?
A lot of these areas, and I've noticed this across the state, a lot of the areas are largest concentration of minority communities. So
I wasn't expecting that.
We're looking to, of course, the citizens would still have to make their own choice and vote to become a municipality. We're just trying to take obstacles out of the way so they have a fair opportunity.
Thank you, Delegate. So I'm both gratified and horrified to get that answer, because I was kind of hoping you would say, no, they're all different. This example and that example had nothing in common, but what you've just said is that the common thread between these three examples is that the areas requesting essentially democratic self-governance were all majority-minority in population. Is that what you just said?
That is correct. You know, there's also, Delegate, an economic side to it. For instance, the Edgewood area that tried to incorporate, it's close to 30,000 citizens. That would be a major city in Maryland, and that's a large chunk of tax base that is being collected from that area and spent elsewhere in the county. So they're getting little to no reinvestment whatsoever for their own tax dollars.
Thank you. If I may, Mr. Chair, are there examples anywhere in Maryland of majority-minority municipalities? And there probably are. But,
Yeah.
okay, so
Yes.
isn't that so?
Yes.
So it's not as though folks of any demographic profile couldn't find a community, a municipality, in which they felt represented on the basis of their, let's just say, demographic identity. There are a range of diverse municipalities in our state, correct?
Correct, yes. We have one county that I think has 47 municipalities, Prince George's County.
That are
27.
that are predominantly
I'm sorry,
Yeah.
27.
that are predominantly majority
47,
minority.
Yes.
But in Harford County, are there any, just not picking on Harford County, but just since that's your jurisdiction, are there any examples of majority minority municipalities?
No.
And then the last question, Mr. Chair. How do I put this? How do I put this? I'm curious whether, from your perspective, as a delegate representing your district that includes the community of Edgewater, if it is your view that there could potentially be a pattern of, dare I use the word in 2025, discrimination in the decision to deny these residents the opportunity to set up their own self-governance?
I hate to really point fingers at people and accuse people of things. but it leaves one with an impression of that.
Thank you, Delegate. Thank you, Mr. Chair.
Great. Just want to clean this up a little bit, Delegate Johnson. One of your examples was Montgomery County. Do you know what that municipality, proposed municipality was?
Let me see.
Was it Rollingwood?
Rollingwood, that's correct.
Was it majority, minority?
That one, I'm not positive.
No, it was not majority minority. So I just want to make sure we're being specific in our specificity, as we like to do up here when we're talking about these things. Delegate Morgan?
Thank you, Mr. Chair. I know you had this bill here last year, I believe, correct?
Pardon me?
Didn't you have this bill here last year?
I did, yes.
Is there a reason that it would be enabling just for your county? Or you think there's, I'll use the words, or prejudice within the group to not make it just for Harford County?
Well, there is, it's when looking around the state, this would be not just to benefit my county, but any community in the state of Maryland. I mean, here we're state legislators.
Right.
So this bill would benefit any community in Maryland that decided they wanted to become their own municipality and have people from their own community advocating on their behalf.
I think you mentioned earlier that there was approximately 30,000 people. And did you say that community felt that whatever monies were collected was not being spent fairly amongst them, and it was subverted somewhere else to a other area that didn't have as much representation or less representation?
Yes, that community strongly feels that they're not getting their fair share of reinvestment or quality of life things in their community, and they feel their money is being spent elsewhere in the county for quality of life things in other parts of the county and reinvestment in other parts of the county. And this community is on the same exact Route 40 corridor. 6 miles up the road, they have Aberdeen, which is a municipality, and 3 miles up the road from that, they have Haverty Grace, which is a municipality. And they see a huge disparity between the quality of life and the things that, and the budget, and the things that those municipalities have, including being able to advocate for themselves, apply for grants, all of these things, that just 6 miles down the road that they have in their community.
Do they, excuse me, also realize that with such actions, there's a reaction to the point that such services may have to be provided by themselves at an additional cost, other than what the county already uses for, say, property taxes, excise taxes, et cetera?
Yeah, there would be an impact study that would have to be done before it went to referendum, so they would know exactly how much their taxes were going to be. And sometimes when municipalities come online or in the past, they could be a special taxing district to continue to use the county services until they collected money and brought services online for themselves, or they could decide to continue to pay the county for those services. That would be up to them.
Thank you, Mr. Chair.
Okay, thank you very much. We have one unfavorable, Michael Sanderson, Maryland Association of Counties.
Thank you, Mr. Chairman. Members of the committee, Michael Sanderson with the Maryland Association of Counties. First, let me thank the sponsor of the bill. As he mentioned, he came to the Mako Summer Conference. We had a big panel discussion about county municipal issues in finance and administration and land use and so forth. He served as moderator. Our events are always better for having participation of state leaders in the administration and also in the legislature who have their finger on these issues. So we're grateful for that, and I think there are a couple elements from that discussion that made their way into this year's bill to make it a better bill. That said, we're still opposed to the bill, and I want to just expand on one thing. I think the very last thing I said at last year's testimony was a quick quip. I said, if you pass this bill, I'm going to be the mayor of Severna Park by Thanksgiving. I meant it as a joke, but not really. So I want to unpack that for a moment, because our concerns with the bill are really not so much with the percentages and the process and the timetable that's in the text of the bill, but it's more about other things that happen in current law when an area becomes an incorporated municipality. You heard earlier about land use decisions, that there's a clock and then suddenly they get to no longer be concerned about capacity in schools and so forth. Set all that aside, just dollars and cents. As soon as, let's say, Severna Park, a nice, relatively high-income portion of Anne Arundel County, thinks of itself kind of as a city. You drive into town, there's a sign that says, "Welcome to Severna Park," feels like a town. It's an unincorporated area. Maryland has plenty of those, right? My campaign for Severna Park mayor will be no taxes, but we'll just take the money we get from the county by being an incorporated municipality and give everybody a tax rebate. We already built our high school. We're doing great. We don't need to support down at Georgetown East or other parts of Anne Arundel County. Let's take that county money, bring it back, and I'll just write refund checks. You pay a healthy salary for the mayor. I mean that flippantly, but there's more to the decision to become municipality than just the people in the town.
Great. Any questions for the mayor, Delegate Long?
Thank you, Mr. Thank you, Mr. Mayor. Speaking into existence, huh? So I'm just curious, what position does the bill need to be in for you all to be unopposed? Because you all tend to be opposed to a lot of things.
So I think in practical fact, what this bill says is that nobody else needs to be involved in the decision tree other than the people who drew a boundary and said, we'd like to be a town. It doesn't affect anybody else. No other towns, doesn't affect the county. There's no other decision by anybody else. Right now, that check is in the hands of the county government where the municipality's proposed, and they're the ones tasked with looking at the effect on schools and on infrastructure and finances and roads and so forth. You take that away from the counties, we're the stakeholders saying it's gone, but as a matter of policy, like, you've made a really big change.
Here's the issue, Mr. Chair, if I may. What do you say, and this does happen, okay? I represent a county, and there are populations where there are more minorities siloed into one particular area in juxtaposition to others, okay? So what do you say to the people in those areas who aren't getting the services that they desire up to par, number one, and then additionally, what do you say when the county government, for whatever reason, we don't want to point fingers to be disparaging, but the facts are the facts, reasons are the reasons. When under any circumstance they are vehemently opposed to ever taking it seriously, and so I think it's not satisfactory that you all are not bringing something substantial to put the bill into a good position. The counties can't just be left to say, "Oh no, we don't want to do this." Isn't that so?
I would say at the heart of your question is, what should we do if there's a troubling pattern? And I mean, there's intimations that might be the case. I think there would be standing for members in a community who'd like to incorporate. If they're being turned down by their jurisdiction and it looks like it's for wrong reasons or illegal or unconstitutional reasons, I think you take them into court and beat the heck out of them. I think that's fair. And if it were the county council or county commissioners who are behaving that way and responding that way, they deserve that level of accountability. I don't think the response to that is to upend the whole system for everybody top to bottom and every town who might feel like they'd be better if they were on an island.
I'll be quiet all day. It's one small bite. Where are they going to get the money to do that?
I know there are all sorts of organizations, ACLU and the League of Women Voters. There's a variety of organizations that when you run afoul of voting laws and election laws will show up and take up cases like that routinely. We're defendants lots of time in that sort of stuff.
Thank you.
Thanks.
Okay, thank you, Mayor. That concludes the bill here on House Bill 768. We'll turn to House Bill 769. Delegate Jones, real property, residential foreclosures, materially delinquent mortgages. If you have a panel, feel free to bring them up.
Thank you so much. Chairman, we had one of my panelists have a family emergency, and would it be okay if Tony Salazar from the OFR came up to replace, please, Kathleen Highland on your list? Thank you.
Yep.
Thank you so much. Chairman, we had one of my panelists have a family emergency. Deja vu. Sorry. All right. Okay, hello. Thank you for being here. Good afternoon. For the record, I am Delegate Dana Jones, representing District 30A in the House. That's Annapolis and Anne Arundel County. Chair Corman, Vice Chair Boyce, and members of the Environment and Transportation Committee. I'm here today to introduce HB 769, titled Real Property, Residential Foreclosures, Materially Delinquent Mortgages. I don't have you yet, I mean. This bill seeks to establish much-needed protections against sudden foreclosure proceedings that disproportionately impact Maryland's most vulnerable community. Also known as zombie mortgages, or as defined in this bill, materially delinquent mortgages, are very old mortgages that have typically been written off or charged off by the original lender, then sold off multiple times to debt collectors. Many of these debts originally originated before 2008 mortgage crisis, before Dodd-Frank, and before the Consumer Financial Protection Bureau, when it was common for lenders to qualify homeowners for an 80-20 mortgage. These loans were structured with 80% first mortgage and second mortgage to cover the 20% down payment, you may remember. As you know, a lien in the second position can only collect proceeds from foreclosure after the first lien is fully paid. After the financial crisis and significant drop in home values, many of these second liens were discharged, modified, written off, or charged off by the original lenders or servicers. This bad debt was then sold to debt collectors for pennies on the dollar, with the understanding that the debts could become valuable once home values recovered. From the consumer's perspective, understanding what happened to the loan was often difficult. But what mattered most was that they no longer had to make payments on that debt. Fast forward a decade or more, the current housing crisis and home values have recovered significantly, as we all know. As a result, second liens that once had no value in foreclosure proceedings now very much do. In recent years, private equity firms, debt collectors, and other parties have begun foreclosure proceedings against homeowners who were unaware that these debts still existed, let alone that they were still receiving monthly statements. No clue. This afternoon, my staff emailed each of you a link to 2 maps showing the spread and impact of zombie mortgages across the state. These mortgages have affected every corner of Maryland from Oconomowoc to Garrett County. The second graph in the email highlights how disproportionately these mortgages have impacted communities of color and working families. Zip codes with the highest number of zombie notices of intent to foreclose, NOIs, are predominantly Black or Brown and Hispanic. In Prince George's County, 4 zip codes with over 80% Black or African American populations are amongst the hardest hit. While this practice is not widespread, it is clear from the data that it is stripping wealth disproportionately from low to moderate income communities and communities of color. This legislation does not propose to eliminate debt or stop foreclosures. Instead, it would require lien holders to fulfill their duty of providing monthly billing statements before initiating foreclosure proceedings. This 24-month period will give homeowners who may have completely been unaware of the debt and were not receiving statements ample time to make informed financial decisions for themselves and their families. For creditors already providing monthly statements, this bill would not affect their ability to foreclose. Additionally, this legislation would also allow homeowners to raise latches, statute of limitations defense in foreclosure action for materially delinquent mortgage as defined by the bill. Over a dozen other states have passed this legislation to regulate second mortgages. Last year, the Virginia State Legislature unanimously passed HB 8184, which specifically addressed zombie mortgages with similar provisions. As the Office of Financial Regulation, OFR, can further explain today, since 2018, over 3,000 mortgagors have received a notice of intent to foreclose for materially delinquent mortgages here in Maryland. While this represents less than 1% of foreclosure proceedings, the impact on these homeowners is significant. The loans, along with the unfair practices associated with them, are predatory and pose serious threat to housing and economic security for affected families. As a Consumer Financial Protection Bureau, CFPB, stated in 2023, debt collectors are prohibited from collecting on old debt past the statute of limitations under the Fair Debt Collection Practices Act. But as we all know, unfortunately, as of February 9th, the Trump administration and the Elon Musk Doge office has ordered the CFPB to stop nearly all work. Employees showed up to locked doors and can no longer provide effective oversight. Additionally, current federal law is insufficient to protect mortgagees in these circumstances because, which my panel will explain further. This committee and this body have consistently worked to protect housing rights for Maryland's most vulnerable citizens, and I believe this bill is a crucial step in continuing the important work. Finally, I want to highlight that you will see favorable testimony in your floor system from the Consumer Protection Division of the Attorney General's Office. I also want to point out that there is a small technical amendment that should have been distributed to you all. In your floor system, you will also see and find support from a number of organizations. I want to thank my panel. I also want to thank, for the last 12 months, my Chief of Staff, Josh Paper, and I have been working diligently on this legislation to present to you. So I want to thank him as well. With that, I respectfully request a favorable amendment on HB 769, which will help prevent working class homeowners, especially in communities of color, from facing surprise foreclosure notices when they have not even received monthly statements. Thank you.
Start with Meredith.
Meredith. Okay.
Okay, thank you. Thank you, Delegate. We appreciate that. Good afternoon. Chair Corman, Vice Chair Boyce, members of the committee. I'm Tony Salazar. I'm standing in for Deputy Commissioner Kat Highland, who, as you heard, had a family funeral to attend to. I'm the Commissioner of Financial Regulation. I want to thank you for the opportunity to testify in support of HB 769 and ask for a favorable report. The bill is intended to address old mortgage debt, as the delegate mentioned, that people don't understand is due. It's been dubbed zombie mortgages. And while it's only a small part of the foreclosure numbers that our office tracks, it's important, as the delegate explained. The problem with these mortgages comes from some gaps in current mortgage law. And number one is the lack of a statute of limitations for mortgage foreclosures. So right now in Maryland, there is no statute of limitations. So that absence means that Maryland homeowners remain vulnerable to the threat of foreclosure indefinitely. So if they have a loan that they believe was charged off, which is on the books of the institution, they could still be liable for that decades later, which is what we've seen in some cases. Secondly, foreclosure actions for these older second liens are not subject to the Federal Truth in Lending Act, which is TILA. And TILA requires that lenders cannot charge interest or fees if they don't give notice, which is what this bill requires. And then lastly, the laches defense, which permits a borrower to raise a defense that the case has been withheld for an unreasonable or prejudicial amount of time, is not applied to mortgage cases. So in this case, the bill addresses all three of those in a way that allows mortgage purchasers to know what applies to the loans they're buying, and it protects consumers who have these mortgages. So with that, I'll turn it over to Assistant Commissioner Meredith Merchant, and she can talk a little bit more about what our office has and about these loans.
Great.
Thank you.
Thank you, Commissioner Salazar, and good afternoon, Chair, Vice Chair, and committee members. For the record, I am Meredith Merchant, Assistant Commissioner in the Office of Financial Regulation, also testifying in favor of House Bill 769. One of the units that I oversee investigates consumer complaints. And as you've heard from the delegate, often the zombie mortgage debt is a subordinate lien originating when the 80-20, or also called the piggyback loans, where it's like a first and second were done simultaneously, were very popular. And then during the Great Recession and foreclosure crisis, homeowners in default obtained loan modifications or filed bankruptcy, thinking their second mortgage would be included in the modification or discharge, especially if both mortgages were originated by the same lender. So years pass with the homeowner receiving no correspondence about the second loan. The homeowner may receive a charge-off notice, and if so, they're often just not cognizant of what its significance or its implications. Mistakenly, the homeowner continues believing that their debts are current. So when a notice of intent to foreclose arrives in the mail from a company the homeowner does not recognize with a demand for immediate payment, the homeowner believes it to be a scam or a mistake. Our data show that the average amount owed on zombie mortgages is $193,000. Even when a homeowner confirms the debt's legitimacy, they struggle to gather the funds needed to pay it off or find an affordable solution. And they are at risk of losing their home, even if they are current on their first mortgage. The stories are heartbreaking because homeowners intended to stay current, but they are blindsided. As just one example, I remember speaking to a homeowner who called in a panic because she owed $200,000 on her home. The original loan was only $74,000. She didn't recognize the company. She thought it was a scam, and the foreclosure sale had happened by the time that she called us. So,
Great. Thank you for your testimony.
Thank you. I'm happy to answer any questions.
Good afternoon, Chair Corman and members of the committee. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network. We are a statewide network of housing and community development organizations, including housing counseling, as well as legal services providers who provide direct assistance to homeowners on housing matters of all kinds. I just want to echo what has already been said about zombie mortgages, but I just want to make a couple of key points. First of all, this doesn't only affect the lowest income homeowners. This can also affect quite prominent higher income homeowners. There is a story in the Wall Street Journal from 2023, where Warren Brown, the prominent defense attorney in Baltimore City, was flummoxed when he got notice last fall telling him that his Randallstown home that he lived in was subject to foreclosure. And the reason he learned was the failure to make payments on a home equity line of credit taken out in 2006. Brown didn't know about the second loan existed. He said he moved into the house and started paying the primary mortgage in 2010. His brother, an architect who had designed and owned the house, died in 2015, and the house was now owned by his estate. He had been paying the mortgage for 13 years and didn't understand it at all. The affidavit said the estate owed about $180,000, almost half was interest, the affidavit said, and the charged rate at 6.625% for more than 14 years. So this doesn't just happen to the folks at the lowest end of the spectrum. This can happen to any of us. And I would urge your favorable support for House Bill 769 because we have to put into place consumer protections on these issues. And it not only affects the person, but it also affects the place. So those foreclosures are also the first place where disinvestment in that community takes place. So I urge your favorable report, and thank you so much for your time today.
Great. We have a question from Delegate Stein.
Chair and Delegate, thanks for bringing this bill, and Commissioner, good to see you. Just to confirm that when say, let's say homeowner defaulted on their mortgage in 2006, and then unbeknownst to them, there was the original borrower discharged the debt, but then it was sold to someone else, equity company, whoever. When the homeowner gets a modified loan for their home, they receive no notice about this zombie loan, I guess is being described. Is that right?
Yeah.
That's correct.
That's correct, yeah. Because they're dealing with probably the first mortgage, right?
Yeah.
Not the second mortgage, and that's a different issue.
Okay. And then, and Delegate, you referred to the CFPB, and I know certainly they're basically not functioning anymore, but do any protections that they issued by regulation, are there any still in place that would protect homeowners who are subject to these?
There are no.
There are no protections on the federal level.
None at the federal level?
Well,
Okay.
yeah, so it is.
It is, I'm sorry?
So,
Is it ready?
yeah, so all the regulations are still on the books. And that's including the Truth in Lending Act, which they were talking about. And then I'll also say the CFPB issued guidance, but that was particularly around statute of limitations. And in Maryland, its mortgages are not time barred. There was one more point I was going to make about the regulations, but we can move on.
Okay, so I guess bottom line is whatever regulations may still be on the books at the federal level don't at the state level apply to this issue.
But there's nobody to enforce.
There's no one there.
You mean there's no one to enforce the federal regulations?
And the Truth in Lending regs say that if a homeowner's in bankruptcy or the loan's been charged off, they don't have to send statements. The mortgage holder, debt buyer, servicer doesn't have to send the periodic statements.
Okay, thank you.
Delegate Holmes.
Thank you, Mr. Chair. Thank you. Maggie McIntosh is long gone. I just want to understand how this works. So let's say that I had a second mortgage back in 2006. And I have moved on from there. Obviously, this is 2025. So the way that the bill is written, I think, and I'm just taking a look at it, if I had a second mortgage prior to October 1st, 2027, then that secured party has to send me notices that I have an outstanding debt. Is that correct?
Do you want to answer? No, that's correct.
Okay, so now they have to send me notices that I have an outstanding debt. What parts of the debt are due? Obviously, the primary, and the interest, and what kind of fees are due?
That would depend. It would probably be late fees at a minimum. But typically, I think the point that gets forgotten here is that originally, in these situations, borrowers are told, we're charging off the loan. So if you're a borrower and you hear a lender tell you, I'm charging off this loan, you presume that you don't owe that anymore, because a lot of the folks are unsophisticated and they don't understand the term charge-off. The lender is not telling you that they are not, that you are not obligated. They're telling you on their books they no longer consider it collectible. Right. So they can then pass it on to someone else, and because they deem it not collectible, they don't send the borrowers statements that say your mortgage continues to accrue interest, you haven't paid, so every month you continue to accrue a late fee, things like that. that communication falls by the wayside, and so you have that misunderstanding. Then you have the lack of communication, and then some third party comes in who has bought that debt, and now they want to resurrect it, so they send out a statement that includes all the past interest, all the past fees, and that is primarily the issue we're talking about.
One final question, Mr. Chair. And you are correct. Most don't understand that term, charge-off. It is truly misunderstood. So after you begin to send me these notices prior to October 1st, 2027, are you saying that there's a lump sum payment due, or how is that payment arrangement going to be made based upon that 2006 loan that was charged off and now we're coming at me? How is that payment to be made? Lump sum, new payment process, what? How's that going to work?
Well, it's going to put the borrower on notice that they're due.
Yeah, it just follows the foreclosure process, right? So they'll get the notice and they'll follow the timeline. And
I got you. So it's going to be applied to as a normal secured loan.
Correct.
I got you. Okay, thank you.
And the dual timelines was so yeah.
Delegate Allen.
I'll just leave it.
Thank you, Mr. Chair. Delegate, thank you for bringing this bill. I was glancing at the map you gave us, and sure enough, there's a big red streak right through my district, and it's communities on both sides of the Beltway. So this is very, obviously very important. I was just looking through, and again, forgive me for being a humble English major here and not a lawyer, not a real estate agent. But when we're talking about a secured party in the bill, is there any way we can tighten that language up a little bit more? Because what you just described is a very kind of complex process where someone's selling this to someone else, and there's 3 or 4 degrees of separation sometimes between the original secured party in this case and whoever might be the ultimate holder of that mortgage. So is there a way to make sure that no company who's again selling this off 2 or 3 times finds themselves a loophole in this, to make sure that they're not actually beholden to this law?
Well, I guess I would defer to the delegate on whether or not there would be a change. We have worked with our internal Attorney General and with the staff in our office that deals with these. And I think we're satisfied that the statute covers and is written in a way that, I mean, are you worried that the original secured party would be involved?
Yeah, whoever. So there might be a passing of the buck or something like that.
No, there shouldn't be, because
Okay.
it's the person that holds the mortgage.
Okay, I was just making sure the secured party,
Yeah, no, I
the
think
definition by itself was
Couldn't kick back to the first.
correct.
Right, and some of these have been sold so many times over in large chunks that to be able to actually track that backwards would be nearly impossible at some
Okay,
point.
yeah, I just wanted to make sure that no one was going to try to find a loophole there.
Yeah,
Thank you.
Great point, thanks.
Okay, thank you very much. We have an additional panel of favorable witnesses: William Steinwedel from the Maryland Legal Aid Bureau, Marceline White, Economic Action Maryland, Lisa Sorrow, Community Legal Services. Please go ahead when you are ready.
Hi, my name is William Steinwedel. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau, and we testify, and we thank Delegate Jones and the committee for allowing us to testify in strong support of this bill. My written testimony has been submitted. I did want to take time, though, to answer some of the questions that I heard while sitting behind. So the first thing is that so a lot of these people, a lot of the homeowners that have come into this situation have filed Chapter 7 bankruptcy, and that makes the situation even more difficult. The reason is that a bankruptcy discharges debts, but it doesn't discharge liens unless they're, and so basically, once the underlying debt is discharged, they will stop sending statements, and then as was said, that they'll charge it off and they'll sell it to another creditor, and they're actually federally barred from sending statements at that point unless the person calls them and says, I want to retain ownership of this property, and they need to send me the statements. So this is why a lot of this happens, because these investors sit there and wait and wait and wait, and then they eventually get to the point that the house gains in value, and then they move forward with a foreclosure because the lien is still enforceable even if the underlying debt is not. Also, there was a question from Delegate Holmes about what the result of this will be. So the one thing I want to emphasize is that nothing in this bill eliminates the debt itself. The debt is still due, and the person needs to reach a resolution with the mortgage company to cure the debt. But what this does is provide time and time for us to investigate. My unit, we represent a lot of people in foreclosure. This will allow us time to file OFR complaints, challenge the debt, and challenge what's caused. And eventually what this usually results in is that between us and the mortgage company, we reach a deal on a loan modification, allowing the person to stay in the home. So again, we testify in strong support of this bill. Thank you.
Sorry, I'm stepping in for Ms. Sorrow. My name is Eric Orr. I'm a attorney with Community Legal Services. I do foreclosure prevention, and I am actually a lawyer who represents these people in the zombie mortgage issues. And I just wanted, most everything I heard so far was quite good, but I just wanted to clear up a few things. These people will get a bill, and it will show every month that they missed, and they'll have a late payment for that month they missed. And then there will be interest charged on those late payments, on those missed things for the entire 5 to 10 years of the loan. Now, these aren't 30-year loans. These are second loans. These are mostly home equity lines of credit, and they are getting these bills 15 years after they stopped receiving anything from anybody. And it's a toss-up whether how these loans are written to what regulations they're covered. Some are covered by, we talked truth in lending, there's a Real Estate Settlement Procedures Act. Whether they're covered by these CFPB regulations is a toss-up, and sometimes we can use that to at least delay the foreclosure and negotiate a settlement, and sometimes we can't. But I'm sitting here, and this is something vitally needed, because it's a predatory thing. These were predatory loans when they were made in a time where that was just accepted, in loans that could never be even made now. And what defenses we have against that are extremely limited. And this is just about a basic fairness of saying, if you are owed a debt, you are required to do small basic things to be able to use Maryland courts to actually reclaim that debt. And so I would like to urge the committee to give a favorable report on this bill.
Good afternoon, Chair Corman, Vice Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of Economic Action Maryland Fund. Economic Action advances economic rights, equity, and housing justice through research, education, direct service, and policy advocacy. Our direct service program works in every county in the state. We're here in strong support of House Bill 769. I won't repeat what you've heard. I just want to make a few points. This is an issue in Maryland now. As you did hear, there are more than 700 second mortgages in Maryland where companies have filed a notice of intent to foreclose. We know that in many cases, the folks had taken out the first loan and had not understood the charge-off, and these fees had accrued over time, and then they were surprised to receive the foreclosure notice. They were intending, and they're often very current on their first mortgage, so they're not intending to default. This took them by surprise. Secondly, we did a survey of 500 of our clients and our supporters last July. We found that housing issues were the largest pain point for people in terms of cost of living crisis, with mortgages being a huge issue. So having a surprise mortgage on top of this that they weren't expecting would be unbearable and unsurmountable for many, many clients we work with of all income brackets. I will note that again, while there are regulations through the CFPB, the Consumer Financial Protection Bureau, right now their staff are unable to investigate or enforce any kinds of violations in this current environment. So they are they are not available for support at that point. I will say this bill's needed because, as you all know in here from the work you've done in the past, a foreclosure depresses not only the individual and their financial struggle, but it depresses a neighborhood and communities when you have foreclosures in neighborhoods, the values of homes around it. And for these
Great,
reasons,
thank you so much. We have a question for you from Vice Chair Boyce.
I urge its favorable support.
I swear we knew that before you said it.
Yes,
Thank you.
exactly.
But thank you.
I think you got the feeling.
But
You
thank
got
you
the
for
vibe.
continuing to talk
I'm here
over
for
me.
it.
I appreciate it, Marceline. Go ahead, Madam Vice Chair.
Thank you, Mr. Chair. I have a couple clarifying questions. So one, just so that I understand, one, this bill's needed because you believe at the federal level it won't be enforced. And if that is so, can someone tell me how, if we weren't worried about the federal government, what then does this look like? I'm confused.
So even before whatever is going on in Washington at this point, the federal protections for foreclosure defense were pretty limited. Basically, we were limited to two things, basically. So if a servicer offers you a loan modification and then sells the loan, that modification must transfer to that new servicer.
Yep.
And the only other protection is essentially if you had submitted a facially complete loan modification 37 days or more before a sale date, it has to be completely reviewed for all possible options. So actually, even if CFPB was investigating complaints as they had been doing for the previous 13 years, we would still need this law because basically the issue is that these 80-20 mortgages are now coming back to life, thus the term the zombie mortgages, because the home equity in Maryland has grown so much in the last 5 or 6 years.
So that's what I'm sorry, I don't mean to cut you off, but that's what I need to understand. That's what I was confused about.
I just want to make.
We need this regardless of the federal government.
Yes.
Thank you.
I think one of the important things is that the CFPB can enforce these, but there is no private right of action for a lot of these regulations, which means no one can actually enforce it in a court by themselves. It requires the CFPB to actually do it. And you can use the violation of these regulations when you're getting the very late in the foreclosure to perhaps, but it's up to the judge whether they're going to accept those types of arguments that this is unfair. And so these are the types of problems I come across and I'm dealing with.
But yes, we need it regardless.
Yeah.
Just to be clear.
I had a second question. Is that, and just so that I understand, I get a notice that says my 2010 mortgage, second mortgage was charged off. It goes to LLC Homes and Company, and LLC Homes and Company should be sending me, kind of like when I'm saying my friend in the back saying no. Let me get to the point. So I then get this second mortgage that I thought was charged off 10 years ago, and it says what was $30,000 is now $90,000. How do you or this process assist individuals to get it back down to 30 to then maybe come up with a plan to pay it? Because it sounds like by not giving notification, I can easily, predatorily, I guess is what is the point, charge your late fees and the interest because you're not getting anything and therefore you can charge.
So I want to make something. So these banks were often forced to charge off these loans by the feds during the bailout, right? And they were compensated for that by the triggers and the insurances and everything. So these banks were compensated through our tax dollars for charging off those loans to make their balance their books and make them look better.
So it should be zero.
Right? And so the banks got compensated for it, but these were charged off and just put in a pile. And then someone, usually around 2017, and I know there's a lot of companies doing this, but in Maryland, I've seen just a couple, and they're the same ones over and over again. They are private equity firms out of Florida and other states that bought up these loans at pennies on the dollar, and they're using the threat of foreclosure to extort as much money as possible, right? They just want to get as much money. They don't expect to get the full amount ever. They're just trying to scare these people who are not sophisticated into paying as much as they possibly can.
And I understand that, but to the point made earlier in my notes, it was that essentially this bill does not eliminate the debt that is owed. So then I guess if we're talking about consumer protection, how do we ensure that the person who then knows that this debt is here pays off potentially exactly what they may owe or less, and to your point, they should owe nothing because the bank's got money for it.
So to answer your question, Delegate Boyce, what the goal of this bill is because it's making the documentation required much stronger, number one, which is going to, because to join up with what the previous answerer said, these are investors. They're in the business of making money. So if you force them to actually have to provide documentation, they're going to be very well financially incentivized to offer a loan modification, because that's going to be a lot cheaper than them going forward and sending notices for 2 years and then having to foreclose. So what you're doing is you're putting them on the same field as all of the other banks who have had to do that before they could proceed with the foreclosure. And the second thing that this bill does is it allows, because Maryland is a quasi-judicial foreclosure state. So while you can raise certain things like a motion to stay and a motion to dismiss in a foreclosure action, you can't. It's not your typical civil action. You don't have a right to discovery. You don't have a right to answer. There's a limited right to counterclaim. But what this law does is it allows you to raise the fact that they waited so long as a defense, which will incentivize the court to force the other side to either come to a deal or maybe dismiss without prejudice and force them to start the whole process over again.
And I could have a dismiss without prejudice given the fact that the company, if I can trace it back, has already been paid off for a debt that I essentially would
If you could prove that, yes.
Thank
you.
Okay, we're going to move on to a favorable amendment. Virtual witness, Jeff Walsh from the National Consumer Law Center.
Given the fact that the company, if I can trace it back, has already been paid off for a debt that I essentially would.
If you could prove that, yes.
Thank you.
Okay, we're going to move on to a favorable amendment. Virtual witness, Jeff Walsh from the National Consumer Law Center. Mr. Walsh, your YouTube is playing. You have to turn the YouTube streaming off, or we're going to get a lot of feedback starting in about a half a second.
Okay. Does that help?
Yeah, please go ahead.
Thank you. My name is Jeff Walsh, and I'm a senior attorney with the National Consumer Law Center, and I'm presenting these comments on behalf of NCLC and its low-income clients. So we believe that HB 769 is very helpful because it authorizes basically a 22-month pause in foreclosure of these materially delinquent mortgages, and it creates a framework for restarting communications between borrowers and homeowners, despite the fact that a lot of these mortgage holders were required to keep that communication in effect and provide it over the last 10 or 15 years. We have three concerns that I just wanted to address briefly about the bill that we've outlined more completely in our written statement. But the first addresses this issue about what happens to the very large arrearage that's accrued while the loan was dormant. And we'd like to refer you specifically to the provisions, for example, of the Virginia bill that we've cited to and the pending one in Massachusetts, where we think the bill could be improved if it included specific remedies that courts can authorize to abate portions of the accrued interest and fees that came due, for example, while required federal notices and communications were not being sent. Our concern is that after this pause is over, you can have homeowners who doubled or tripled the amount of the original loan and are just unable to pay it and are still going to face foreclosure. One other concern we had is that the definition of the materially delinquent mortgage shortens the period of time for calculating the 5 years based on pending foreclosures.
Thank you so much. We have your written testimony. Seeing no questions, we're going to turn to our in-person unfavorable testimony. Robert Enton on behalf of the Maryland Bankers Association. Thank you all at the table. You can move away, and Mr. Enton can come on up.
Thank you, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. This is the second year this bill has been in, and last year it was withdrawn. The concerns that we have, and I'll just give you an example. I represent the banks. They're the ones that make the loans. And if you go to your bank and you have an existing mortgage, but you want to get a second, an additional loan, and the only way you're going to get that additional loan is if you put up collateral, and that collateral would be your real estate, your home. But it's a second mortgage, it's inferior. And I'm not able, if you default on that mortgage, I'm not able to do anything about it because the first mortgage is going to come ahead of it. And unless the value of the property sells for enough to satisfy the first mortgage, I'm not going to get a dime out of it. So very often these second mortgages sit there. And nobody takes any action on them until such time as they know the first mortgage has been paid off. So you sit on it, and then, the first mortgage is paid off, and now you're going to go ahead and demand payment and foreclose. I mean, the bottom line is whether you get a statement or not, you owe the money. You owe the money. You got the money, and you pledged collateral for the loan. If you hadn't pledged the collateral, you wouldn't have gotten the loan at all. So when I look at this bill and I see the requirements so that if you didn't send this statement because you know you weren't getting paid, so you didn't spend the money to send the statement, and then all of a sudden now you've got to send a statement for 24 consecutive months in order to be able to enforce your loan. I mean, I hear the testimony and the complaints. But I think that if you really wanted to pass this bill, somehow you need to make, just have some guardrails in it to protect the person that loaned the money and secure that loan with this property.
Great. Thank you so much. We have a question from the Vice Chair.
Hi, Bob Enton. How are you? I'm talking to you. How you doing? Quick question. So I hear you. I owe money. I should pay it every month. That's fine. But what happens if it then again is charged off and the person who should be sending me notice doesn't send me notice? I mean, the reason why we do pay our bills on time is because more often than not, we get a notice. So if nobody's sending me a notice and I get something that says it was charged off, hallelujah, maybe the good Lord just paid it off. I don't know. I'm not going to pay. So tell me, why is it okay for folks not to get a notice?
So this bill says nothing. I don't see the term charged off anywhere in this.
Well, I'm talking about the terms that have been spoken to by
I understand, but I think
sponsor and others.
I think if that's your concern, maybe you could sit down and look at how to address that. This applies to every single mortgage loan that hasn't been paid for, and no statement was sent for X number of years. It doesn't say, and the loan was charged off and it's bought by somebody else.
But the testimony was that more often than not, this is why we're in this predicament, because they have been charged off and not then notified. So just help me understand, if the bank or these folks want actual money, why don't they contact these folks to let them know that it's still continuing?
All I can tell you is that if you have a second mortgage, there's a lien on it, and just the fact that you didn't send a statement because you knew you weren't getting paid, and there was a mortgage ahead of you, you shouldn't be penalized.
Well, Mr. Enton, should the banks still get money if they've had a write-off and they've been paid off?
Now, I think that once it's written off, it's written off.
So then why do you think other investors or banks should then collect money that someone else has already charged off or paid off?
Once again, the bank has charged it off. I can't speak for the people.
You charge it off, which means that you can do that, and then someone else, another bank or another investor, can then make money off of something that is essentially has been charged or wiped off.
I'm happy to get you more information on that. What my concern for the bankers is that if you have a loan and you haven't sent the statements and it's not being paid,
well, I guess I just don't understand why the bank wouldn't give a notice. If they want their money, why don't they give a notice? Why would they, why would you give a notice?
You can't do anything. You know, we have, this is the current foreclosure law in the state of Maryland.
Yes, sir.
You know, all these protections are in there. If you're going to foreclose on a mortgage, then you can't foreclose for 120 days after it's been in default. You have to wait 120 days. You have to send a notice of intent to foreclose 45 days before you file it. You're subject to pre-filing mediation, post-filing mediation. There are provisions to get a hearing. You know, we have a tremendously successful mortgage foreclosure program.
With the exception of this, with the exception of what's happening here. So do you object to this bill that really just creates a documentation process?
Yeah, I think that, you know, my concern is that if I have the holder of a mortgage that hasn't been paid, and I have a valid reason for I've stopped sending notices, to me, that doesn't mean that I, the holder of that mortgage,
Why would you not send notice? What is a valid reason, Mr. Etten? Help us understand. What is a valid reason not to send notice?
I think that if you're not getting paid after a while, you probably just quit sending the notices out. It's a waste of your time and money to send those notices out.
Well, then you don't want money.
Okay, we have a virtual unfavorable witness, Scott Nadell. Please go ahead, sir.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, Ms. Vice Chairman, ladies and gentlemen of the committee. My name is Scott Nadell. I'm a real estate attorney to focus on foreclosure and default work in Maryland and in the District of Columbia. My office is located in Prince George's County. I sit on the Real Property Council of the Maryland State Bar Association and also chair its foreclosure committee, and here in opposition to HB 769. As Mr. Anton said, the current foreclosure laws in Maryland are very robust. We have very robust processes and procedures that offer a lot of loss mitigation options for borrowers. For starters, not too long ago, there are some changes to the mentioned 45-day notice of intent to foreclose. Letters, or now they're packets, really, that get sent out to all borrowers and owners of the property. Blank loss mitigation packages are sent out to homeowners to complete and to fill out. Resources for borrowers to call for free advice. 2 good faith attempts to personally serve are needed before posting the property of a foreclosure. Preliminary loss mitigation affidavits have to be filed, certifying to the court what loss mitigation avenues have been utilized. Later in the case, a final loss mitigation affidavit is filed to demonstrate what loss mitigation developments have been made since the filing of the preliminary loss mitigation affidavit. Then there's the right for the borrower to request mediation, to sit down with the lender and the lender's representative with the aid of an administrative law judge from the Maryland Office of Administrative Hearings. Then after all of that, if there's still an issue that the borrower has, the borrower can then file a motion to stay or dismiss the case with the circuit court. That can be heard by a judge at the circuit court where the property is located. This all occurs prior to a sale can even be set. And to put further restrictions that this bill would do, possibly not even being able to file a foreclosure action to enforce a lien if certain statements were not sent to borrowers, is just not reasonable. Moreover, the constitutionality and due process issues that the bill can raise may cause major unintended consequences.
Great. Thank you so much for your testimony. That concludes the bill here on House Bill 769. I just want to flag for my colleagues, we have 7 bills left. 3 of them have double-digit witnesses, and 2 subcommittees plan to meet tonight. So just keep that in mind. We'll call up House Bill 785, Delegate Feldmark, Common Ownership Communities and Zoning Authorities, Operation of Family Child Care Homes Limitations. And if you have a panel, feel free to bring them up.
I was trying to be efficient. Good afternoon. For the record, I'm Delegate Jessica Feldmark. Pleased to be here to present House Bill 785. I know that you all are well aware with the child care crisis we are facing in Maryland, and I'm sure you're hearing as much about it from your constituents as I am from mine. The lack of access to quality, affordable child care is a challenge Maryland families in every jurisdiction across the state are facing, and a major factor negatively impacting Maryland's workforce participation and our economy.
Increasing access to childcare is an urgent need, and increasing the number of family childcare homes in our communities is a critical component of meeting this need. As we work to encourage more family childcare homes to open, House Bill 785 will help remove unnecessary barriers by ensuring that neither common ownership communities nor local zoning can prohibit or restrict family childcare homes as long as they are licensed by MSDE. You may recall hearing this bill last year. I do want to highlight one change in response to feedback we heard last year. Last year's bill was drafted very broadly to cover all common ownership communities. This year's bill was revised to exclude age-restricted communities. House Bill 785 is not a magic solution to our child care crisis, but it is an important piece of the puzzle, and I respectfully ask for your favorable report.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Hannah Allen here today on behalf of the Maryland Chamber of Commerce, respectfully requesting a favorable report on House Bill 785. The Chamber has long supported efforts to address the lack of accessible, affordable, and quality childcare in the state. Maryland currently has 33 available workers for every 100 available jobs. And we see this bill as a helpful solution to addressing the state's workforce challenges and needs. Businesses are already challenged with hiring and retaining employees, and due to the child care crisis, families are really struggling to participate in the workforce and find access, just even access affordable child care options. So that is why we are supportive of this change. We think this bill is a solution to the larger problem of creating more accessible child care opportunities within the state. So we would, again, request a favorable report. Thank you.
Thank you. Doug, is it okay if we do questions for you prior to turning the virtual? Any questions for the sponsor? Okay, thank you. You do have virtual witnesses, Ruby Daniels, MSF CCA. Ruby Daniels.
Hi, sorry, can you hear me?
We can hear you. Please go ahead.
Okay, yeah. Good afternoon. My name is Ruby Daniels, and I'm the president of the Maryland State Family Child Care Association and a family child care provider in Columbia, Maryland, in Howard County. I come to you today representing over 4,000 family child care providers in Maryland. I'm also a pre-K expansion grantee and the chair of the Pillar 1 Advisory Committee to the AIB. Family child care is disappearing. Over the past decade, we've seen a steady decline of family child care providers, forcing families to compete for fewer and fewer child care slots. Meanwhile, parents are struggling, some paying more for child care than a college tuition, or unable to find care at all. I have the space, the staff, and the passion to serve more children, but in Columbia, local ordinance prohibit me from expanding to large family child care home, simply because it's classified as commercial in a residential area. One practical solution to address this pressing issue is to amend our zoning laws to allow family child care providers to increase their capacity from 8 to 12 children while maintaining their residential status. This adjustment would enable existing providers, like myself, to offer more slots without altering the residential character of our neighborhoods. This was adopted by other states, such as Colorado and Virginia. In Virginia, they can have up to 12 children at a time. Passing House Bill 785 would increase child care slots by 16,000, allowing 32,000 working parents to go to work. Right now, there are limited child care slots, driving prices up. House Bill 785 may help drive the cost of child care, creating more access to quality child care for working families. With increased child care slots, we can keep our young families from leaving Maryland. We have to keep our young and brightest professional in Maryland. I urge you to pass House Bill 785. Thank you so much.
Thank you. We'll turn to Christina Poish, whose name I'm probably butchering, Maryland State Child Care Association.
Actually, you got it right. Can you hear me?
Ooh, I can hear you.
Great.
Please go ahead.
So my camera's not on? Okay. Thank you to the sponsor for her unwavering support of childcare, children, and families, and thank you to this committee for this opportunity to testify in favor of House Bill 785. I'm Christina Push, Executive Director of the Maryland State Child Care Association, co-chair of the Office of Child Care Advisory Council, and a State Early Childhood Advisory Council member. Child care providers are the backbone of the community, and House Bill 785 recognizes the need of the community to support family child care programs which drive the economy by ensuring access to child care so families can earn while children learn. Many people work from home, and family child care is the essential fabric of the community and should be considered a residential activity. House Bill 785 strikes a balance between inclusivity and accountability. This legislation requires the family child care providers to pay additional fees, comply with any and all insurance requirements, and provide notifications to meet or exceed residential activity protocols. Maryland has experienced a steep decline in child care, losing more than 1,200 child care programs since COVID, and prohibiting family child care is part of the problem and not part of the solution. Family child care must be registered with the State Department of Education with quality standards and ratios that keep children safe and prepare children for the next steps in education and life. Family child care is like any family in your community raising children. It takes a village, and having residential family child care in your community is an asset, not a liability. Child care is the workforce behind the workforce, and child care is an economic driver. Embracing family child care helps your neighbors with the appropriate provisions and requirements outlined in House Bill 785 will be a valuable commodity. MSCCA urges a favorable report. Thank you.
Thank you. We have a question from Delegate Healy.
Thank you, Mr. Chair. Thank you for the bill. Very interesting. I had two questions. One is about, just for the record, that any of these child care operations that would be covered in this bill would have to meet all the standards, whether not just the educational standards, but also fire code, all the health and safety of building and all of that.
Yes, they'd have to be licensed by MSDE in compliance with their regulations. That's all covered.
That's the Department of Education, but also the local fire department and the local health department to come in and make sure that it meets those standards as well.
Yes, and part of the MSDE licensing requirement includes sign off from those other agencies.
Okay, thank you. I appreciate that. That's very helpful. The other question I had is about, it's not requiring changes to these buildings because it's common ownership. If you don't require them to upgrade or change in order to comply with the law.
No, it doesn't require any changes within the common ownership community. The home that the owner of the child care business is in would have to meet all the regulations and requirements for the licensing. They wouldn't be requiring any other changes in the community.
And they wouldn't require, in order for them to become a child care place, they would have to meet certain standards.
Correct.
But it's not a requirement that a co-op is different because it's jointly owned. There isn't people don't have a deed to a home. Mm-hmm. They own shares of the co-op. So the co-op has a responsibility for a lot more than in a condominium, for example. So the question I have is about co-ops, and that if somebody wanted to operate a child care operation in a co-op, certain upgrades might need to be done. And the question is whose responsibility, who's paying for it?
So I believe those would be the responsibility of the business owner, the child care provider, to make those upgrades within their own home, even if it was not individually owned, right?
Yeah,
the home that is going to be the family child care home.
We'll look at it in subcommittee. I appreciate that. Thank you.
Sure.
Delegate Jacobs.
Thank you. Maybe I missed something here, but what's the process if it's an over 55 community?
They're exempt from this bill now.
Okay. Thank you.
Yep.
Okay, seeing no further questions, thank you. That concludes Bill on 785. We'll turn to House Bill 804, Delegate Wu, multifamily dwelling smoking policies. If you have a panelist, feel free to bring her up.
Good to go. Okay. Good afternoon, Chair Coleman, and Vice Chair Boyce, and the members of ENT. For the record, I'm Delegate Chao from District 9A. I'm presenting HB 804, which requires multifamily dwellings to develop smoking policy. This bill was supposed to cross-file with Senator Alonzo Washington, SB 108 from PG County. Due to some technical errors, it didn't happen, so we're trying to fix that issue. I have a panelist, Ms. Brooke Totten, if you can bring her on, from Legal Resource Center for Public Health Policy Law School for University of Maryland. Compared with the last year version, this bill adds language to remove HOA's responsibility of enforcing the bill under certain conditions. This bill advocates condo HOA to develop a smoking policy applicable to all common areas in the residential community, including availability of smoking permitted areas, and a clear notice of smoking policy to property owners and tenants. The bill does not require HOA to initiate civil action against tenants violating the smoking policy. In advocating for HB 804, I would first like to point out that smoking is not a constitutional right. As such, smoking policy do not discriminate against smokers, nor do they prevent the property owners from prohibiting smoking on their own property. Smoking policy should not and will not be viewed to prevent smokers from living on their property. Per CDC, secondhand smoking exposure contributing to nearly 34,000 premature deaths from heart disease and over 7,300 deaths from lung cancer annually among U.S. adults who do not smoke. On the part of multifamily dwelling managers and HOA, secondhand smoking and third-hand smoking increase cleaning and maintenance costs and can pose fire risk, as expressed by the Maryland Smoke-Free Living Guide. As such, the enactment of smoking policy is in the best interest of both property owners and property managers and residents from both a health and economic standpoint. These policies are able to lower turnover costs and potentially lower insurance premium, therefore positively impacting property values. Such policies have already been considered and adopted across certain areas in Maryland. For example, a survey by the Maryland Department of Health and UMD found that 79% of multi-unit housing residents in Maryland support smoke-free policy in their buildings. The Montgomery County Board of Health enacted Regulation 7210 early this year, prohibiting smoking in any common area in a multifamily residential dwelling. Note that the bill is not intended to block tenants who buy legal tobacco products from consuming them on their own property. The goal instead is to require the governing body of a dwelling to develop a clear smoking policy, where it is easy for tenants to realize whether the dwelling allows smoking or not. Furthermore, while it is difficult to clearly pinpoint the original smoke, the existence of policy is a strong starting point to push residents to be mindful of their impact of smoking on those around them, hopefully promoting greater self-regulation with the community. So I'm looking forward to your favorable report. Thank you.
Thank you. Are there questions for the sponsor of the bill? Okay, we can turn to Brooke Torton, Legal Resource Center for Public Health Policy, virtual favorable amendment. Please go ahead.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Brooke Torton. I'm an attorney and the managing director of the Legal Resource Center for Public Health Policy. I'd like to thank Delegate Wu for bringing this bill and for speaking with me about some necessary, really technical amendments here that do impact the substance. And I'm just going to speak to those amendments. So number one, recommending expanding the policy to address other areas in addition to common areas. The reason I say that is because the Maryland Clean Indoor Air Act already covers common areas in indoor workspaces. The common areas in common ownership communities can be considered indoor workspaces because of community managers, sales managers, maintenance staff. And so they're already covered. So requiring a policy in that area doesn't really do much of anything. Amendment number 2, removing Clause E, it's on page 3, lines 16 to 19. That would remove a prohibition on the policy that says the policy can't have an impact on people living there already. Governing bodies in common ownership communities They do this all the time. They pass bylaw amendments that do impact people that already live there. And I wouldn't want to curtail their authority. The Office of the Attorney General has also weighed in on this and has said that passing these types of bylaw amendments are fine. Also want to point out that the definition of smoking here includes cannabis. So if we were to leave that clause in there, it would make it so that governing bodies couldn't pass a bylaw amendment that prohibited smoking cannabis also for people that already live there. And the very last point that I'd like to make is the importance of broadening the language to make clear that current tenants and owners retain rights to pursue legal action under any civil cause of action, not just for violating a smoking policy. Most often what we're seeing is a resident and owner bringing a complaint for nuisance against another tenant. And with that, I would ask for the amendments to be adopted and that the committee issue a favorable report. Thank you.
Thank you. We have another virtual favorable amendment witness, Scott Weber. Please go ahead, Scott.
All right. Chair Corman, Vice Chair and Boyce, and members of the ENT Committee, my name is Scott Weber. I'm co-founder of the Vaping Awareness Public Education Society, and I'm submitting this testimony in support of HB 804, but with amendments. The Vape Society is strongly in favor of any policy that clarifies, limits, and reduces tobacco smoking because medical science and all available statistics reveal smoking to be the single largest contributor to preventable death and the most costly. However, the conflation of smoking and vaping as being the same or even similar is wrong, both in physical science but also in their relative harms and costs. The simple reality is that smoking involves smoke. It's a byproduct of combustion. Vaping does not involve any form of combustion, and therefore actually defining in law something as smoking that has nothing to do with smoke is both incorrect as a matter of simple physical fact, but because it becomes irresponsible when it becomes an outright known falsehood, and particularly egregious when it involves public health. This conflation of smoking is further complicated by the reliance of this bill on Business Regulation 16.7 that refers to electronic smoking devices that do not produce any smoke, but expressly states that it only applies to the delivery of nicotine. So how does this bill address the delivery of cannabis via atomizers? Would it only address THC atomizers, or would it also impact CBD? How does this bill impact users of valid medical marijuana use? But the real underlying issue is the equal treatment and definition of two entirely different substances and conflating their vastly disparate harms with equal weight and equal penalty. This is just bad legislation. It's no different than defining drinking as the consumption of any clear liquid and therefore treating water and Sprite and vodka and Everclear equally, irrespective of the relative harms. And so for the record, based on statistical reality, vaping is actually safer than Everclear, vodka, Sprite, and even water. So we respectfully request that the language be changed to differentiate substances that produce smoke and do not. And in everywhere there is smoking, turn it to smoke, and vaping, turn to smoking and vaping, or smoking or vaping, but differentiate. Thank you.
Great, thank you. Seeing no questions, I know we have one more in-person favorable witness, Karen Strawn from the Consumer Protection Division of the Office of the Attorney General.
Mr. Chair, Madam Vice Chair, members of the committee, my name is Karen Strawn. I'm with the Consumer Protection Division of the Office of the Attorney General, and we are here in support of this bill. This bill is improved over last year because it does limit things to the common areas, and it makes sure that it does not affect people living in their homes that have been living there when the policy is made. The importance of this bill is to make sure that a smoking policy is developed. It doesn't tell anyone what kind of policy it needs to be. It simply says make a policy so that people coming into the community can know where smoking will be permitted and where smoking will not be permitted in common areas. And for that reason, we believe it is something that is beneficial to allow people who are looking at places to buy or looking at places where they might want to go to for relatives, anything of that nature, that they know what the policy is, and they know whether or not this is some place that's going to allow smoking in common areas and expose them to secondhand smoke or not. For those reasons, we had asked for a favorable report.
Thank you. Any questions for Ms. Strong? Thank you. Seeing none, we will go to unfavorable testimony by Mr. Bariano.
Good afternoon, Madam Vice Chair, members of the committee. For the record, Bruce Bariano here on behalf of the Maryland candy and tobacco wholesalers. I once just said tobacco wholesalers, and Chairman Corman said, well, you represent candy too, don't you? I said, yes, so I wanted to clarify that. We're in opposition to this bill. For those of you that have been on this committee for a while, this bill was in about 4 or 5 years by then Delegate Washington, who's now a state senator. This is a mandatory bill. That's a very important thing. It is mandatory. Secondly, it includes medical cannabis smoking and smoking marijuana. The definition of smoking in here clearly includes that. And it is mandatory. It requires what now can be done, but is not forced to be done by condominiums and common ownership cooperatives. And not only is it mandatory, but if you look at the language of the bill, it shall throughout. One of the things they have to do on page 3 of the bill is that they have to establish conditions of where you can smoke in the condominium area and grounds, and also shall establish penalties and fines for violation of the policy. It's a shall. It's mandatory. I don't know. Do you want to give condominium associations that authority? And then lastly, yes, it does let you smoke in your unit, but then there are common areas that you're paying for as a condominium owner that you're not going to be able to smoke your cannabis or smoke where you're doing that now. And lastly, on the latter part of page 3 of the bill, what it does is it empowers local government to adopt more stringent policies. So it's a very authoritarian bill. It's been given an unfavorable report by this committee previously, and I would ask for that continued treatment of this proposal.
Thank you so much, Mr. Bariano, for your words. Any questions for Mr. Bariano? Delegate Foley.
Mr. Bariano, isn't it so that condominium policies enacted by these common ownership committees, don't they have to be voted on by the residents?
I'm sorry.
Don't
yes,
they have,
yes,
don't any policies, they have to be voted on by the residents?
Yes.
Okay, so if the residents then have a right to weigh in on this policy, wouldn't that be true?
Yes, they would, but it makes it mandatory. And I'm a member of 2 condominium associations, and there are a lot of issues that really don't come up because people don't want to intrude on other people's habits or people that have been there for a long time or coming in. But of course, that can be done.
Right. So if your condominium association adopted a policy or proposed a policy on this that you didn't like, you could vote against it. Isn't that right?
But that, respectfully, though, that's not the point. Yes, I can. But you're making it mandatory that they have to adopt a policy.
Okay. Thank you.
Thank you.
Are there any other questions? Okay.
Thank you.
Seeing none, that ends the bill hearing for HB 804, calling up HB 817, residential leases, use of algorithmic device by landlord to determine rent prohibitions. Madam, do you have a panel?
Yes, Madam Chair, I do. Marceline White, Zafar Shaw, and Ben Winters.
If they can come up and just remind everyone that we have a couple of witnesses for this particular bill, so it is 2 minutes. Please respect 2 minutes, with the exception of the sponsor.
Thank you. Good afternoon, colleagues. For the record, I'm Delegate Julie Plotchkar, here to present House Bill 817. This bill is needed to stop a growing practice that has resulted in Maryland tenants needlessly paying more for rent simply to fuel corporate profits. The problem arises from specialty software that uses artificial intelligence to recommend rent prices to landlords. The software takes information from public sources as well as confidential proprietary data on rent and vacancy rates provided by other landlords. The AI then uses this information to recommend a rent price. As alleged by Attorney General Brown and in other antitrust lawsuits, this is price fixing. The committee is probably going to hear a lot today about one company, RealPage, but please know this legislation isn't just about them. The purpose of this bill is to ensure that all landlords and technology companies comply with our state's consumer protection laws.
With that disclaimer, let me share what the U.S. Department of Justice has said about RealPage. Quote, by feeding sensitive data into a sophisticated algorithm powered by artificial intelligence, RealPage has found a modern way to violate a century-old law through systematic coordination of rental housing prices, undermining competition and fairness for consumers in the process. Multiple antitrust lawsuits have been filed against RealPage and some of their corporate landlord clients. This includes a lawsuit by the U.S. Department of Justice along with 10 state attorneys general. And that case has already yielded a settlement and consent decree with one of the landlord defendants. There are also lawsuits being pursued separately by Arizona, D.C., and here in Maryland by our attorney general. Additionally, more than 20 class action lawsuits have been filed nationwide. There is strong evidence to support these antitrust cases, including from internal company documents and sworn testimony from RealPage employees and commercial landlords. For example, RealPage referred to as its products as, quote, driving every possible opportunity to increase price, end quote. A RealPage executive said that, quote, there is greater good in everybody succeeding versus essentially trying to compete against one another in a way that actually keeps the entire industry down, end quote. For instance, one landlord reported that within 11 months of starting to use the software, they had raised rents more than 25%. The landlord, who was now pricing at the top of the market, noted that they had, quote, brought the rest of the comp's rents up with us, end quote. And this is having an impact on renters to the tune of $112 a month on average in the DC metro area. That was from the Biden White House. It's not just rents that are impacted, it's also vacancy rates. As reported by ProPublica, RealPage has touted to investors that landlords can make more money by leaving more units vacant. One large landlord client doubled their vacancy rate and still increased company revenues. Meanwhile, roughly 1,000 apartments sat empty purely to fuel corporate profits. Use of this technology is growing. Statewide, our Attorney General estimates that it is used to set rents for more than 100,000 rental units. Let me be clear about what this bill does not do. It does not prohibit a landlord from seeking out public information about their competitors. It does not prevent a landlord from using software to manage their properties or to analyze the state of the rental market. And it does not prevent a landlord from raising rents. Nor will this bill put RealPage out of business. They've already created an option in their software that allows landlords to exclude non-public competitor data. What this bill does is prevent landlords from using AI-based software that includes non-public proprietary data sourced from competitors. Ultimately, the decision before us today is not whether RealPage and their landlord clients are guilty or not of price fixing. They will have their day in court in the multitude of lawsuits filed against them. The decision before this committee, is whether or not we should close the loophole in our statute that opens the door to landlords colluding on rents via artificial intelligence. I would say now is the time to act. Some landlords in Maryland are already using this type of technology, but many are not, and we should get out ahead of this growing problem and help Maryland renters. And lastly, I do anticipate providing amendments to the committee to tighten up some of the language in the bill, and I will get those to you as soon as I can. Thank you.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White, Executive Director of Economic Action Maryland. Economic Action advances equity, housing justice, and economic rights through research, education, direct service, and policy advocacy. We are here in strong support of House Bill 817. Why the bill is needed? It promotes a free and fair marketplace. A fair marketplace relies on competition where firms compete for consumers based on price and quality. If the market's functioning, consumers decide to make purchases based on their preferences, price, elasticity, and quality. When companies collude and fix prices, as has been alleged, consumers lose out. It affects Maryland tenants. As you've heard, many properties are already using this algorithm and setting prices, so this is important for us to act now. As you all have heard many times in this committee, rents are too high already. In 2023, 53.3% of Maryland tenants spent more than 30% of their income on rent. Through the use of these kinds of algorithms that set prices, we know that in many cases you see up to a $70 a month increase in rent for the companies who use these kinds of prices. Our families simply can't afford that. I do want to address a few things you may hear from the opposition. One is that they don't have the ability to do this and it would be complicated. As you've heard, RealPage has, as one example, has a tool in their own toolbox to comply with this law now, so they can do this. And they can do this because San Francisco and Philadelphia have already passed this kind of legislation, so all of these companies have to comply in those cities. There are many states who are putting forward similar legislation, so they will have to comply in cities as they do now and in other states, so they will be able to do this. And you may hear that it decreases prices, and that's not altogether clear. In the White House study that came out, it found that it increased rent. So we think this is important for a number of reasons, and we urge a favorable report.
Zephyr.
Hey, thank you, Vice Chair Boyce and members of the committee. Zephyr Shah from Maryland Legal Aid. I just want to express how disgusting this practice of rent fixing collusion is for tenant advocates, specifically for us at Legal Aid, serving the lowest income renter households in the state. I want to just point you to a quote by a CEO of a multifamily company that was an early adopter of the RealPage software. This is on page 3 of my testimony. This CEO said the net effect of driving revenue and pushing people out of their homes was $10 million in income. I think that shows keeping the heads in the beds above all else is not always the best strategy. So while the General Assembly and most of all the members of this committee have been working year in and year out to solve the housing crisis and prevent evictions and displacement and the worsening of affordability, landlords have been one step ahead of you. They've been using technology and exploiting fear of progressive policies like rent stabilization to get in place these kinds of practices that the bill addresses. I think this is a tailored measure. I expect that you'll continue the good work that you've been doing, and part of that will be passing this bill. Thank you.
Thank you, Vice Chair Royce and members of the committee. My name is Ben Winters, for the record, from Consumer Federation of America. I'm the Director of AI and Privacy. CFA is an association of nonprofit consumer groups that was established in 1968 to advance consumer interests through research, advocacy, and education. Today, I urge you to speedy passage of HB 817, which would prohibit landlords from using an algorithm fueled by non-public rental data to keep rental prices and terms artificially unfair. Algorithms increasingly mediate critical determinations for Marylanders, whether that's housing eligibility, hiring decisions, credit rate determinations, what content they're shown, and more. This is often done with no transparency or choice for consumers, to the detriment of their bank accounts and opportunities. At the same time, the cost of living, in particular in housing, is simply too high. In the past several years, as illustrated by lawsuits by the Department of Justice and many attorneys general, including Attorney General Brown, major property companies and landlords conspired to do this through using the same third-party entity. I want to just make sure to harp on the fact that although it is an AI and it is algorithm and that is all cool and shiny, this is pretty simple price fixing done through a little shiny veneer called an algorithm. What they do is they each hire the same, would sign up with the same company, like a RealPage, even though they're not the only game in town. They provide non-public rental data, and the reason why it's so important about the rental data is that it is not public in the same way that home sale prices or grocery prices are that allow competitors to be competing in a fair market. And so what they do is then recommend rates that are never going to go lower than what your competitors are doing. It basically creates a higher rate for everybody, and they pressure the landlords to auto-accept the rates they recommend. So it really takes that choice away from the landlords and creates an anti-competitive environment. The bill is simple, well-tailored, and will address this legal behavior. So I please urge you to do a favorable report out.
Thank you so much. First question is from Chair Holmes.
Thank you, Madam Chair. I'm asking this question out of pure ignorance. I don't use RealPage. I use multiple listing service. How is this different? How is RealPage different than multiple listing service to set prices?
Sure. So multiple listing service is takes home sale prices, not necessarily rental pricing, as well as, especially the rental renewals, which are often not reported out. So the norm in home pricing using the MLS is that it's all transparent and created and reported out. That's not the case with both the rent terms specifically, like, whether they're giving a month free here or utility cut here, or, they increased, please, yeah.
Pricing.
Pricing.
All I want to interest is pricing.
The same deal. So the pricing for rental apartments are not transparent. Like, you would not be able to know through the internet or through public availability what I pay for rent, or what your neighbor would pay for rent. Whereas you could check what they paid for their house. That's just how the data in the system works.
But rentals are on the multiple listing service, aren't they?
The rental renewals, the cost that, yeah. So I think it's an important distinction, because that's a key part in the marketplace, right? People renewing their rentals and having different prices for the same apartment. And so those are not on the MLS. Those are not reported each year. You pay this for this apartment, whereas last year you paid this. And so that's the main difference.
Okay.
Yeah.
Thank you.
Thank you. I do have a question, and I want to play devil's advocate just for a second. When I first read about this, I thought, oh, how interesting. But I thought, wow, this could be something that could be used to, from like an affordable housing standpoint, to figure out how we lower prices. So given AI is unfortunately and fortunately what we play with now, and we have set regulations not only in this body and in other places about how to be able to have technology, but also at the same point make sure it's safe. Tell me how this would play out if I were someone in the affordable housing realm that wanted to use this to figure out, one, how do I do my research to figure out average rents, and then figure out, oh my God, I like picking on Homes & Co. Is charging $1,300 when I could potentially be charging $1,000 in that regard. So just help the body a little bit.
Thank you, Madam Chair. And I share your good intentions in terms of affordable housing. I will note at the bottom of page 2, going on to page 3 in the bill, it does already have a carve out in terms of affordable housing. But I think if you're talking more broadly about landlords just out in the market who are looking to do good, I would view that as a friendly amendment as we continue to work on the language in the bill. And I'm happy to circle back with you because I would agree if there's some good actors out there, we should be helping them.
Yeah, and that's what I'm afraid of. I mean, I think with any technology, it has many good uses. And of course, we know there are certain people or groups that could exploit it. But I just would hate for the technology or the algorithm per se to be deemed totally bad when it could be also used for good. So I just wanted to put that out there.
If I can,
I wanted to also, I'm sorry.
Oh,
go
no,
ahead.
sorry. I just wanted to say that the section 3B here basically makes it so it's only a violation
I'm
if
sorry,
they're.
what page are you on?
Sorry, page 3, line 20.
I see it.
It only makes it a violation to use that information and analysis to then charge the rent. And so if you're doing an analysis as a nonprofit or a legislator, that makes a key difference. And one thing that I say in all of these fields of where AI is used, it really becomes like this mirror. You can see what the culture or the system that you're working within is like, and you can either choose it to squeeze people out or to make good choices and do it. So it's not a tech problem, it's a collusion problem.
I mean, and that's, unfortunate. So I want to follow up on Delegate Holmes' question, and I will see if anyone else has questions, and I'll call the rest of your panel. How currently would either a private or a public or an affordable housing organization now how do they currently now research to kind of figure out the lay of the land so they can then quote unquote set prices, whether it's for luxury apartments or it's for affordable housing or workforce housing? Like how currently does a housing provider do that? And then I will.
I think we might need to circle back with you on that one. I will say there are other products on the market that many landlords subscribe to get a generalized state of the market to figure out what rents are in their area. And I'll say this bill does not touch those. So I think people are using tools like that.
And there's a lot of sources of public data. Like even if you just go on Zillow, you could see past rental history and analysis, meta-analyses of those. But rather, just
I'm
not
just
the number.
trying to help draw a distinction between technology and I guess to the point of your bill, and again, I want to thank you for bringing it, the potentially abuse of the algorithm. And I'm also worried, hopefully at some point, the subcommittee can get some type of demonstration about how this actually works and how it works between the different organizations. Because again, I would hate for the algorithm not to be able to have the inability to be used in the future for housing, because we are in a housing crisis, and I would argue it's because we have a lack of housing, not because of potentially somebody who's trying to, go up on rents because they want to settle luxury apartments or whatever. But with that, I'm sorry. If there are any other questions, Delegate Healy.
Just kind of along the same lines, but is this algorithm or something equivalent to it, something that renters might be able to use? You're looking for an apartment, you want to know what they cost, so you don't waste your time knocking on doors, finding, this isn't an apartment building, this is a condominium, or, but they do rent a few places out, and so you want to know if this is a neighborhood I can afford, or should I go look somewhere else without having to do like individual painstaking research to find a place to live.
Thank you for the question. No, so the software that we're talking about is not available to tenants. I don't know if a tenant would try to sign up, if they would even be able to afford it.
Okay,
but
so there's a cost to it.
Right, so really when we're talking about the type of data that is exempted out of this bill that is not in the crosshairs of this bill, looking at apartment listings on Zillow or other websites, to the extent there's news reports about market rents, those sorts of things, we think that's fair information for both tenants and landlords to be looking at.
Okay, thanks.
Okay, I'm going to call up the other favorable witnesses. You might have to do some seat rotation to fit everybody. Franz Schneiderman, Consumer Auto; Lisa Sorrow, Community Legal Services; Matt Hill, Public Justice Center; Terrence Kavanaugh, SCIU Local 500; and Councilmember Jackson, City of Rockville. Please go ahead when you're ready.
Mr. Chair, I'll be brief. It's Matt Hill from Public Justice Center, and I'll just say me too.
Hello, my name is Ashley Blankenship. I'm with Community Legal Services, and I am an Equal Justice Works Fellow attorney. CLS is a nonprofit organization that provides free legal services to support housing security for underserved individuals and families in Maryland. In our day-to-day work, CLS represents countless tenants who rent from landlords using algorithmic devices that employ this non-public data we've been speaking about. Tenants have suffered financial stress and housing instability when landlords have used these programs. Instead of ensuring a free market for rental housing in Maryland, companies that use algorithmic devices exploit tenants by using non-public data from other landlords to minimize competition among landlords and artificially raise rent above actual market trends. This practice precludes low to moderate income families from securing new housing and forces those families out of housing when the rent rises at the end of their lease terms. These practices also prevent tenants from moving into new housing, which sometimes forces them to remain in uninhabitable or unsafe conditions. Under Maryland's Consumer Protection Act, or CPA, tenants are protected from unfair or abusive business practices. Companies using algorithmic devices with non-public data to set rent cause financial harm to tenants, cannot be avoided by tenants that are renting from landlords who use these programs, and they do not benefit tenants. These programs also hide the non-public cost-determining information used by such programs, which materially interferes with tenants' ability to understand rental costs and takes advantage of tenants by minimizing landlord competition and eliminating the free market. The use of non-public data in programs using algorithmic devices violates the CPA and justifies this legislature taking further action to codify these protections for tenants. As such, CLS strongly supports House Bill H 817 and encourages this committee to submit a favorable report. Thank you.
Hello. Thank you to Chair Carmen and members of the House Environment and Transportation Committee. I am Rockville City Council member Barry Jackson, and I thank you for the opportunity to testify in support of HB 817, which would prohibit a landlord from using certain algorithm software that leverages non-public competitor data to set residential rents. We thank delegates Pelakris Carr and Stewart for sponsoring this important and timely legislation. The U.S. Department of Justice, together with the Attorney Generals of North Carolina, California, Colorado, Connecticut, Minnesota, Oregon, Tennessee, and Washington, filed a civil antitrust lawsuit against RealPage Incorporated for colluding to raise rental prices, decreasing competition among landlords in apartment pricing, and monopolizing the market for commercial revenue management software that landlords use to price apartments. 8 multifamily properties in the city of Rockville have been identified as being managed by companies named in this lawsuit. Together, this represents nearly 2,000 market rate apartments in Rockville, meaning that there are nearly 2,000 families who may be paying higher rents than needed due to this sharing of non-public competitor data and algorithms that have an unfair impact on renters. Estimates from the DC metro area approximate that landlords' use of these unfair approaches to algorithms has caused the average renter an additional $112 a month. The Rockville Mayor and Council take the issue of housing affordability seriously. We care deeply about our community and have developed 43 action items to increase housing and affordability in the city of Rockville. Nearly half of Rockville households are renters, a percentage which continues to grow. Our community would greatly benefit from the general protections in this legislation against price collusion for residential rents that have a disproportionate impact on housing stability and affordability. Thank you.
Thank you, Chair Corman, members of the committee, for the opportunity to address the bill. My name is Franz Schneiderman. I'm with Consumer Auto Maryland. We work to protect consumers and drivers across Maryland. Look, I want to join other advocates in supporting this bill strongly because it will protect overburdened Maryland renters from further price increases caused by this unfair and probably illegal price-fixing algorithmic technology. Just quickly, I mean, if dry cleaners or car dealers or home improvement contractors were getting together to share information that wasn't available to the public in order to maximize their prices and maximize the revenue that they get, instead of competing to serve customers on price and other things, I think we'd all agree that that was unfair and probably illegal. Essentially, the same thing is happening through this software. It's just they don't do it face-to-face. They do it through the auspices of this software. You know, the White House Council on Economic Advisors found that it cost consumers nationally about $3.6 billion and found that it gave monopoly power to individual landlords that were supposed to be competing. The Maryland Attorney General said a similar thing in filing suit in January, says it cost Marylanders millions, and says that the owners of more than 100,000 apartments in Maryland are essentially acting like an anti-competitive cartel. Now, there are lots of suits around the country about this. Courts will make their rulings. You know, but again, you know, we're before the legislature. The legislature has the ability to, if you guys feel that that's unfair, price discrimination and price fixing that hurts consumers, you know, I'd ask you to act proactively to address it and prohibit it to protect consumers instead of waiting to see what the courts may do. So thank you, and I ask for a favorable report on the bill.
Mr. Chairman, members of the committee, Terry Kavanaugh here on behalf of SEIU Local 500. We have submitted written testimony. I won't go through it. Of the 23,000 families we represent across the area, many, if not most, are renters. They're on the front lines of the housing crisis, and they're not doing well. you can take this small step to show them that you're on their side. So for all the reasons that were stated, we're in favor of the bill. Thank you.
Great, thank you all. Councilman Jackson, it's important you know that both the vice chair and I grew up in Rockville. Seeing no questions, we will move on to our unfavorable testimony. I'll call up Robert Enton, Maryland Building Industry Association, Lisa Jones, Real Page, Brian Anlou, AOBA, Sean Malone, also representing Real Page, Matthew Pipkin, Maryland Multi-Housing Association, and Mike Semko, also Real Page. You all can sort of do a rotation through and
on behalf of Real Page, my name is Sean Malone. Good afternoon, Mr. Chair, Madam Chair. It's a rare occasion where I get to speak before Lisa Harris-Jones. We are testifying in opposition to this bill. It's astounding as an attorney, a member of the bar, to sit and listen to attorneys sit and recite allegations in a lawsuit as facts. These will be heard out. What I won't do is recite the response and the answer to this from Real Page today. That's in a different setting. But suffice it to say, attorneys are looking for sanctions in the District of Columbia for factual mistakes that have been filed in those cases. As has been said, equating this tool to the cause of rent increases is like blaming a thermometer for a fever. That's not what it does. This is a tool that's used by landlords to optimize their property. Optimize does not mean maximize rent. In fact, often through the use of this tool, a landlord or a housing provider can understand why a piece of an apartment's not renting, because they've listed it above market. And if you do the simple math, renting an apartment for $2,500 a month and getting 12 months is better than renting it at $3,000 and getting 7 months. That's not the purpose of this tool. What it's used for is to understand the market and set rates at the right spot. That could be lower, it could be higher. As far as a monopoly, you can't establish a monopoly with 17% of the market, and that's what Real Page has in Maryland. 17% of the market uses this tool to help them understand rents. And I think the question, Madam Chair, that you asked with regard to this utilization of technology, it's not to be scared of, it's to be embraced, to be utilized on both sides to make sure that we're doing it. With that, I look at my time, I submit.
Good afternoon, Mr. Chair, members of the committee. For the record, my name is Matt Pipkin. I am here on behalf of the Maryland Multi-Housing Association asking for an unfavorable report on HB 817. You have my written testimony. I'll try not to step on Sean's toes or Mike's toes here, but I want to make something absolutely clear. There is absolutely no collusion with housing providers. Let me say that again. There is no collusion. This is nothing more than a tool in the toolbox. I know that's overstated a lot. But it is. It's truly just a recommendation, not a final say or answer to the price of a unit that is made at the point of execution by the leasing professionals. And I will tell you, the scope of the legislation itself, as I read it, you know, this goes beyond Real Page. I mean, anybody who would use CoStar would bring that data and put it into an Excel spreadsheet. I think you've just run afoul of this. MLS, as you said, Chair Holmes, I do believe that this bill makes it problematic to use this. Lastly, again, this is being litigated. It would be prudent for the Maryland General Assembly to await the results of litigation before tailoring public policy around the premise of a case that is yet to be decided. I'll respect my time. Thank you.
Well, I'm Mike Semko, and I'm with Real Page. I would just second the comments of everyone who's gone before me, but I'd be happy to answer questions about the software if you have any. Software can be complicated, but I think I can walk you through how we do things and why we think that the use of non-public data is actually beneficial to consumers in the housing market, and why we think and can show and will show when we get a chance to in court why that non-public competitor data has a cooling effect on rent recommendations rather than inflating them. But thank you. I'll cede the rest of my time.
Good afternoon, Mr. Chair and Madam Vice Chair. I'm Lisa Harris-Jones. I'm here on behalf of RealPage and Maryland Multi-Housing Association. I think listening to the proponents to this bill, I think it's very important to understand that the way that RealPage's software works, and it's not just RealPage. RealPage has been around for over 20 years. The software that the intent of the bill is trying to get at has been around for probably more than 20 years. And it's not the software that's increasing rent prices. We all know that the governor, as we know, has a bill in, I think it's Housing to Jobs, Jobs to Housing Act. I keep getting it mixed up. But it recognizes the fact that the problem is not software. It's more that we have a housing shortage. And when you have a housing shortage due to issues with zoning and ordinances and the inability to build, prices go up because you don't have the stock out there. And another thing I think it's important to point out is that landlords aren't price fixing. They're not in the same room. Whoever uses any type of software, it's all configured based upon that particular landlord or that housing provider's property. So if I use it, I may put different information in based on the type of property that I have, how aggressive I may want to be with renting spaces, as opposed to another person across the street who wants to maximize and get the highest rent possible, even if they can't fill every vacancy. So one of the big things that it'll come out during the litigation is that we don't all get the same price. And 35% of landlords that use it, that's the highest percentage of who actually takes it. They generally go lower or higher. And I will stop there because if you have questions, actually RealPage is better to answer them.
Mr. Chairman, members of the committee, Robert Enton on behalf of the Maryland Building Industry Association. We're also opposed to this legislation. When we took it up in our legislative committee last week, the comment we got from several of our members was that, we use it, we build an apartment house, and then we rent the apartments out. And we use it because we want to get a feel for, where's the marketplace? And sometimes we look at it, we think, gee, we were thinking we could rent it for X, but really we can't. We're going to have to rent it for a lower amount. Sometimes we find that we were going to rent it for this amount, but the market right now, and the market changes from day to day, from week to week, to month. Right now, the market's here. So, it's a tool that they use. There's an assumption from the proponents that this is used just to increase rents, that there's collusion. I don't think there's any collusion. My clients aren't talking to other clients and getting together for a cup of coffee and, agreeing on what they're going to charge. It's just a software package which people look at to see what's going on in the marketplace. And I really think that's all. The only other comment I would make is that we have a very robust antitrust statute on the books in Maryland, and we have a very aggressive attorney general we've seen that's looking at those statutes and seeking to enforce them. I think, let it play out in court. So for those reasons, we'd ask for an unfavorable report. Thank you.
Good afternoon or good evening, Chair Corman and the committee. This is Hugo Cantu on behalf of the Apartments and Office Building Association. Without getting into what everyone else is saying, I'm going to probably do that too. What I think the most important thing about this piece of legislation is to remember that the non-public data we're running into is the non-public data is putting downward pressure on some of these rents and some of these suggestions. What we have to remember is that what's public, like the Zillow or the apartments.com rents, are not seeing these concessions from housing providers. And so by removing that non-public data, we're not having that aggregate information that would ultimately lower the entire suggestion. So by not including that, we're kind of running into an issue there. Additionally, Montgomery County does have a requirement, and it's had a long requirement for this information to be publicized. And so by removing that, would the bill then prohibit the county's ability to collect some of this information? I think that's something that the committee has to think about. And just one more thing, some of the areas that have the highest use of RealPage are also seeing the quickest downward pressure and decrease in their rents down in the Sunbelt states. So again, it's really just a supply and demand issue, and that's without getting into the complicated factors of an algorithm, decision-based making software, and what generative AI and artificial intelligence, where the fear could be, and that's not even including that conversation. So I yield the rest of my time, and we ask for an unfavorable report.
Thank you. We have a question from Delegate Addison.
Good evening, all. So I work for the Department of Housing and Community Development, but I'm following the lead of Vaughn Stewart, who always tells us to Google. And I have a question for you. I have a question. How would this be beneficial to our residents?
Okay, that's a great question. Thank you. Would it be beneficial, I can answer that question, would it be beneficial for me to maybe go through how our software works? And I can point out, where regulators have a problem with us, why we don't think they should have a problem, because the data set they have a problem with, we think is very beneficial to residents, and then just sort of explain what we do and where we're coming from, if I could do that. If you'll indulge me, maybe. So the primary driver of our pricing recommendations, and I should back up and say, RealPage does not set rents. We have nothing to do with setting the rents. We are market research with a pricing suggestion. And as Lisa pointed out a little earlier, only about 35% of the time do our customers actually accept our pricing recommendations. When they don't accept our pricing recommendations, 50% of the time they go higher than what we recommended, and about 50% of the time they go lower than what we recommended. So this is market research with a pricing suggestion. So the way we get to that suggestion is the primary driver is the property's own data, meaning the software is looking at a single property and it's trying to determine the supply-demand balance or imbalance at that property. And no regulators have a problem with the software using the property's own data to figure out whether or not units are renting or not. And it's looking at things like how much foot traffic is at the property, how many guest passes have been issued at the property, because if you issue guest passes, that's typically to people who are shopping the property. How many phone calls have come in looking for, rates? What are the current vacancy rates? We're pricing not individual units, but we're pricing on a floor plan level. So a price for your 1 bedrooms, your 2 bedrooms, your 3 bedrooms. We're pricing every unit, right? Every unit gets a price because of the floor plan. And so, again, another factor, we're in February. For this specific property, how many leases do you typically write in February? And so in this scenario, let's say you have a lot of vacancy with your 1 bedrooms. You haven't had a lot of foot traffic. You haven't issued a lot of guest passes. And there haven't been a lot of people calling to see if you have vacancies. So at that moment, after considering the property's own data, the software will make a decision. And that decision is pretty easy. Either raise the rent, keep the rent the same, or lower the rent. If the recommendation is going to be keep the rent the same, that is the end of the process. The software has only considered the property's own data and determined that your renting is fine, you're going to fill your units, that's it. And no regulators have a problem with that, as I mentioned before. All right, now, let's say the pricing recommendation is going to be higher, like raise the rent or lower the rent. And in the scenario that I was suggesting, right, you've got a lot of vacancy and nobody seems to be interested in the property, the suggestion would probably be lower the rent. At that moment, the software is not going to operate in a vacuum. It's not going to go, I think you should charge whatever. It's going to take a look at only two additional data sets that are outside of the property's own data. The first data set that it's going to look at is what we call publicly available asking rents. And again, no regulators have a problem with the software pulling data from the internet, from that geographical area for similar properties, similar floor plans, and using the publicly available asking rents. And that is about 70% of the data mix outside of the property zone data that the software is going to look at. Okay, now everyone brace yourselves because here comes the controversial part. The other 30% of that data mix is going to be what we call non-public competitor lease transaction data. I don't know why our data scientists call it that, but that's what they call it. But what that is what did folks actually get for rent on their leases? And this is the pro-consumer part. That the ironic thing about all of this to me is, and I'll analogize this, somebody in here was talking about cars earlier. Let's say I walk into your dealership, okay? And I say I want to buy a truck, and you say the truck is $50,000, or the sticker price, if you will, is $50,000. It never happens where I walk into that dealership and say, I know you're asking 50 for the truck, but I want to pay 55. What typically happens is I walk in and your salesperson will say, well, what other trucks are you looking at? And I'll say, well, you know, Toyota, Ford, GM, Nissan, whatever. And they're going to say to me, what is it going to take for me to put you in a truck today? And I'm not paying 50, I'm going to pay 46 after their manager says, yeah, we can do that. In apartments, that's very similar. That's a very similar transaction. It's not apples to apples. I would call it lemons to limes, because there are markets, I will tell you, there are markets where I walk in to your leasing agent at your property and say, I know you're asking 1,000, but I'll pay 1,100 and take it down right now. That does happen. That is very rare. Typically what happens is I walk in and your leasing agent says, where else are you looking? And I say a duplex down the street. I'm looking at the apartment complex across the street. I might try to get a place closer to where I work. That's what I say. And they say, what is it going to take for me to put you in this apartment today, Mr. Semko? And so they will give me a concession of some sort. Maybe it's 1 month's rent. Maybe they waive the parking fees. I know I'm going on and on. Maybe they give me some sort of monetary concession. Our software knows that. So our software is not looking at the sticker price with the executed lease transaction data that's non-public. It's looking what they actually got. And we can prove, and we will prove, that that information, the non-public information, is lower. And in Maryland, every year we looked at for 5 years, that non-public data is lower and has a cooling effect on our rent recommendation. If you're only looking at publicly available sticker rent, our rent recommendations are going to be higher. If we're looking at what was actually executed and negotiated, it's going to have a cooling effect on our rent recommendations and bring our suggestion down. That was a very long-winded way of dealing, and I apologize. And Lisa's rolling her eyes because she knows I can talk a lot. But the data set that we're talking about is very pro-consumer. And if you get rid of that data set, folks are going to be left with nothing but publicly available data and we're going to shoot high. And why is that bad for our customers? It's not just bad for tenants, but it's bad for our customers. Because unlike the car dealership that I was talking about earlier, if you sell all your cars, you don't sell any cars Monday through Saturday, you sell them all on Sunday, you're good. In our industry, what landlords or housing providers are selling or renting is nights. And so every unit, contrary to what has been alleged, every night that apartment sits vacant, the price is zero. And so what our customers want is accuracy. And if that means a lower pricing recommendation, that's fine as long as they can rent that unit quicker. So it's good for consumers and it's good for our customers. Sorry.
Yeah, no, you can follow.
I'm sorry.
You sure?
I apologize.
It's okay, because I'm looking at the website, but thank you.
Okay, Delegate Stewart.
Thank you, Mr. Chair. Thank you all for coming. Mr. Simcoe, I have to say you're the second delightful Southern accent that's come in today. And the other one was from the council member from Anne Arundel County. And I have to say, as a native Southerner, a native Alabamian, it makes me inherently trust you. I also will say that you have a very disarming nature to you, the way you just explained that I think is extremely effective, which also biases me in your favor. However, I'll also say that I use Google, and I read earlier the entirety of the 162 page amended complaint that the Department of Justice has filed against your company. And I don't want to pre-litigate all these cases. I don't know if this is price fixing. I don't know if this violates the Sherman Act. I don't know any of how that's going to go. I don't want to litigate that today, like you guys don't either. But what I do want to ask you is, in the complaint, it mentions a couple quotes that your company said, and they seem to be at odds of what you've been telling us today. And I want you to tell me if your company did say these things. Okay? First.
Well, I mean, and we're lawyers. This is pending litigation, and you're asking him to respond to something that's in a complaint, and I don't know if he's authorized to do that.
Yeah, if you're not authorized, don't say anything.
I'm not allowed to sneeze without talking
Okay,
to
well,
our
let's let him
outside
go through the quotes, and you can say you can't answer
It's
that,
something
okay?
that-
So we can go through that. You referenced the litigation in your comments about how we should.
And what I'll do is I'll share the sanctions with you too.
You referenced the litigation and the comments from your firm and your client. So let's let them go through the questions, and you can respond and say you can't answer. Okay?
I mean, this is public information. Anybody can Google what I'm about to say. It's not like really that explosive. Supposedly your company said this publicly. If you can't answer it, that's fine. I'm a lawyer too. I get it. The first quote is that apparently your company said publicly that your software is aimed at, quote unquote, driving every possible opportunity to increase price. You also said, and let me say the second one and then I'll let you respond. Allegedly said. And then allegedly, you also said that among landlords, quote unquote, there is a greater good in everybody succeeding versus essentially trying to compete against one another in a way that actually keeps the entire industry down. Did you say that? Can you not respond?
I personally did not say that.
No, I know. Did your company say that?
I honestly don't know if we said that or not. I will tell you that this software that we have has been around for close to 25 years. It's not new software. Nobody had a problem with us until COVID occurred. There's a severe lack of supply in the industry, severe. That was exacerbated by COVID. And there's a lot of demand, and that's what's causing rising prices. And then all of a sudden, people cared about software.
Okay, one more question, Mr. Chair, if I could. So I was not familiar with the studies. My committee colleagues will know that I love studies, and this one's actually from my alma mater, the University of Pennsylvania. So I especially love it. And it came to me not because I Googled it, but because AOBA cited it in their written testimony. So I took a look, and presumably they thought it supported them, but it says that, quote unquote, we estimate that the coordinated channel results in, so in other words, basically the use of algorithmic software results in, quote unquote, an average markup increase of $25 per unit per month, impacting about 4.2 million units nationwide. So that's about in total $100 million per month extra that's being charged to renters because of the use of their algorithm, according to not exactly a socialist institution, the Wharton School of the University of Pennsylvania. That was published this past August. So my question is, have you seen that study? And whether or not you've seen it, do you disagree with those results?
I have not seen that study. I will tell you what we are, the way we would describe our software. And that is, if you use our software, you will get better competitive pricing, meaning you will rent your units quicker, and therefore you will have better revenue results, meaning you'll get more revenue. That doesn't necessarily mean you'll get a higher price, but you'll be occupied for longer periods of time at the best price that the market will bear. So it's not anti-competitive pricing. It's competitive pricing in order to fill those units as quickly as possible. And that will result in better performance.
Okay, I appreciate it. And where are you from originally?
I spent a lot of time in New Orleans, Louisiana.
Oh, okay, awesome. All right, thanks. Roll Tide.
Delegate Lewis for the penultimate question.
Thank you, Mr. Chair, and thank you to this panel. I'm a little confused. I had 10 other questions, but I'm going to focus on one. To the gentleman who spent time in New Orleans, thanks for that explanation. You mentioned that 35% of your software's clients actually use the recommendations the software generates. Did I understand that right?
On average.
On average.
Yes. On average,
So
35% of the time, they accept our pricing suggestion.
They accept your suggestion.
Yes.
Which I would take to mean they implement your suggestion.
That's right. Yes.
So and I don't know, if I got 35% on a test, I would if I got 30% of the vote in my next election, I wouldn't become back, but, okay, fine. But, well, maybe I could. But anyway, in that case, if that's the case, how is it also true that the software puts downward pressure on apartment rental rates if only a fraction of your clients apply your recommendation?
That's a great question. And so I had the exact question. The first part is only 35% of the time our customers accept our pricing recommendations. And so when I heard that stat, I've been working on this issue now for about 2 years. When I first heard that stat, I called our chief product manager and said, Amy, there's no way that's true. Why would anybody buy our software if they're only going to accept our pricing suggestion 35% of the time? It's obviously not useful. Why do they buy it? And she's a lot smarter than I am. She said, well, we had the same question about 10 years ago. And when we went to our customers and said, hey, do you like the software? Is it not accurate? Why are you only accepting on, and by the way, it's not, some are at 9%, some are at 50%. It's all over, but on average, it's about 35% of the time. Why aren't you accepting more? Like, is it not accurate software? What's wrong? And they said, no, we love your software, but you have to understand that that pricing suggestion that we get from you is only one data point in a whole series of data points that we consider when we're setting our price. And so while it's helpful to us, the software doesn't know that the frontage road outside of the property is under construction and the leasing agent's worried about access. It doesn't know that we just refurbished all the kitchens with marble countertops and we think we can get a better price. Whatever, right? It's just one data point for us. That's number one. Number two, the downward pressure that I was talking about earlier is in the pricing suggestion itself, not in the market. We will say we have nothing to do with whether the market's going up or down. We're just holding up a mirror to the market and saying this is what's going to our customers and saying this is what's going on with your industry. So if I could answer it this way, if you drew a map of the United States right now, if you look at where we have our highest market penetration in the country, and in no market do we service more than 30% of the units in a market. So we don't have market power anywhere. But if you look at where we have our highest penetration, it's in the Sun Belt. It will start in Arizona. Let's count Colorado, my apologies, as the Sun Belt. We go all the way down through Texas, the South, maybe up to Virginia. That's where we have our highest market penetration. In those markets right now, rents are stable or falling. In places like Austin, Colorado, Nashville, the rents are down 5, 10%, and that's what our software reflects. Not because we want to lower the rents, but that's just what the market is. And why is that? It is easy to build apartments in the Sun Belt. If you've ever been to Houston, Texas, you know that. I mean, there's no rhyme or reason to their zoning, but there's apartments everywhere. And so there's a lot of supply, and that supply helps lower the price of rent. If you look in places in the Northeast right now, we service 1.4% of the market in New York. To state that another way, 98.6% of the units in New York do not use our pricing software. The rents right now in New York are through the roof. If we're a cartel, we are the worst cartel in history because where people are using us, the rents are falling, and where people aren't using us, like New York, New Jersey, Oregon, the rents are through the roof. And that's because they don't build enough in New York, New Jersey, and Oregon. There's just not enough supply, and there's a lot of demand. And so that's what's going on.
Thank you, Mr. Chair.
Last question, Delegate Holmes.
Mr. Santo, yes or no? Okay?
Sorry.
If your customer does not accept a pricing suggestion, you cancel them? Is there a punishment? Is there something along those lines? Must they accept your pricing suggestion? Thank you.
Sorry. Okay, thank you. That concludes the quite lengthy bill hearing on House Bill 817. We'll move on to House Bill 911, great number, Delegate Guyton, real property, landlord and tenant, family child care homes.
Thank you.
Thank you, Mr. Chair. Thank you, Madam Vice Chair and members of the Environment and Transportation Committee. For the record, I'm Delegate Michelle Guyton, District 42B in Baltimore County, and I'm going to sponsor responsibly. So I am going to present to you, and I ask for your consideration of House Bill 911. And what it does is suggest a solution for not one, not two, but many of the most pressing problems resulting from a severe shortage of licensed child care spots that we have in Maryland. Now, you have already heard Delegate Feldmark's testimony, and you have letters you should have letters from some of the same people in favor of this bill, but I'm not going to have you listen to all that again at this point. I will say just a few words. I think we all understand the importance of child care. We've lost 25% of our licensed child care spots since COVID in the state of Maryland, and I'm sorry, our licensed child care spots, and most of those are the family child care programs. You heard a lot about family child care programs earlier. Those are different than the traditional licensed settings, and it can have many children. These are actually programs that are occurring in people's homes, and that's the main difference. And there are two sizes. Delegate Feldmark's bill, I believe, and I was following closely and I'm familiar with it, was referring to the larger family child care settings where you can have up to 12. My bill is referring to the small family child care settings where you can have up to 8. But let me tell you what it does. So family child care programs, home-based programs, and the reason they're important is that they tend to have more flexible hours than all those centers, right? You can drop your child off from 8 to 5 in a center setting every day. But if you have to work shift work in particular, it is very, very difficult to find flexible child care for that. And this is where family child care programs really, really come in handy. Currently, family child care programs are only 1%. I'm sorry, the flexible family child care programs, those that serve those non-traditional hours, are only 1% of our current child care spots. So I want you to think about that. All right. The other reason it's important is that this is a viable business opportunity for women, and I will say particularly women of color, to actually start a small business in their home while raising their children and supporting other children at the same time. And then most of you are familiar with a report by our comptroller recently. The scarcity of childcare directly impacts the economic health of our state. And then finally, when you don't have licensed childcare in your area, particularly that's flexible for your needs, families tend to make do with unlicensed childcare, unregulated childcare, and childcare, honestly, that is often quite unsafe. And these are the things that this bill is trying to address. So one of the primary barriers to starting licensed family childcare programs is that landlords, not always, but generally, prohibit it in rental properties. They're able to do so. House Bill 911 prohibits landlords from banning the operation of remember we're talking about the smaller licensed family child care homes in their properties. The homes must be regulated and they must be licensed by the Maryland State Department of Education Office of Child Care. Delegate Healy asked the question earlier during Delegate Feldmark's bill, what does that include? And you have a letter of information, if not in front of you, then somewhere deep in those files that actually lists the requirements for what you must have in your home to be licensed and regulated by the Office of Child Care. So not every property and not every person who wants to run a child care facility is going to qualify. In addition to that, landlords may collect an extra month of deposit. They must receive significant notice that the person wants to run a business on their property. And the renters must also provide certificates of insurance for the landlords so they can have a little bit more peace of mind. House Bill 911 does not limit, and this is the difference between this bill and the bill you heard earlier, one of the differences, does not limit zoning requirements. So these are two separate issues. If this bill is passed, landlords could not prohibit small family child care and rental properties unless zoning or common ownership rules prohibited it. That would still be possible under this bill. No, my preference would be to get rid of both of those provisions, but I'm not here to speak to hers. This is a main priority of the Women's Caucus, the Women Legislators of Maryland, something we've been working on for a while. And I request a favorable report on House Bill 911 because as the Maryland Child Care Association shared with us in their letter of support that you have, but also in their testimony today, any bias, and this is what we're talking about, bias related to childcare should be prohibited, and instead childcare businesses should be embraced as an important community support system and economic driver. So I do want to address the fact that you're going to hear a couple of favorable with amendment testimonies and one just straight unfavorable, to be expected in these sorts of conversations. I have discussed this bill with all of these folks and have had expressed my interest and my willingness to work with them to move forward in this space, at least take a small step in the right direction. So I may be willing, as Delegate Holmes and I discussed earlier today, we may be willing to consider their amendment depending on the will of the committee. So thank you very much. And I guess it's just me, so I will be happy to answer questions.
Any questions for the bill sponsor? Okay, thank you, Delegate Guyton. We will bring up our two in-person favorable amendment, Aoba and Ashley Clark. You sent the other guy up for the unfavorable. You're here for the favorable amendment?
That was strategic, Mr. Chair. No, don't worry. I'll be unfavorable shortly.
Good evening again, Chair Corman, Vice Chair Boyce, members of the committee. Again, Ashley Clark here for the record on behalf of the Maryland Multifamily Housing Association. So I do want to thank Delegate Guyton. We did have a conversation about this legislation. We appreciate her efforts in addressing a growing child care concern in Maryland. However, we do feel that multifamily dwellings are not the appropriate accommodations to resolve that concern. One of our predominant concerns would be over occupancy. Looking at the Maryland Education Code in 9.5-305, the adult to child ratio is 1 adult to every two children under the age of 2. And so prospectively, that could significantly increase the number of people occupying the unit beyond what's allowed by local occupancy standards. And so that presents not only a safety concern in the event of an emergency, but also a liability concern for any incidents that arise as a result of having child care homes on the landlord's property. Another concern would be noise complaints. Neighboring tenants, not the leasing centers, would likely express concerns over the noise that's emanating from those apartments, leaving leasing offices to field those complaints and respond to inquiries about the type of business that's occurring in those units, the reasons they weren't informed prior to move-in, and requests to transfer due to noise. Landlords will not be able to answer many of those questions as a matter of fair housing because familial status is a protected class. They also can't steer tenants who would like to have child care homes into certain units as a matter of fair housing. Lastly, the bill states that tenants must be named as a landlord, must name the landlord as an additional insured on the certificate of insurance, but that doesn't factor in the administrative burden of the landlord having to ensure that the policies don't lapse in coverage. It's silent as to the amount of coverage that would be provided, and it doesn't account for any additional insurance that the landlords may have to acquire because of the child care homes. It's asking for a favorable with amendment to remove multifamily. Thank you.
Thank you, Mr. Chair. For the record, Brian Anlew with the Apartment and Office Building Association. We are also favorable with amendments removing multifamily. While it's true that the bill does not preempt local zoning, the reason that we have local zoning and that they place restrictions on where you can have family child care center is because of compatibility. And I would submit to you all that in certain zones, if you notice my testimony refers to residential multifamily zones in Prince George's County, for example, the county has determined that it is not a compatible use, particularly in areas like our central business districts where you have high-rise multifamily buildings. One of the requirements that Prince George's County has is that you have 75 square feet of outdoor space for a child to recreate in, and you just simply don't have that in some of these buildings. If you have a rooftop terrace with a pool and patio furniture, I think most people would agree that is not a suitable space for the child to recreate. And not only that, the local zoning code says you can't cross a major street to get to like a nearby park for the child care center. Beyond that, there's other restrictions that it's not at all clear to me who would be responsible for resolving. In Prince George's, if you do want to have a child care center in a residential multifamily zone, you could apply for what's called a special exception. That is a $2,500 fee. You have to do a community meeting, and you have to get county approval. Typically, it's the property owner that applies for that special exception. So what would happen if the tenant wants to move forward with this, but the property owner does not? Would they be restricted from doing so under this bill? Would they have to pay the $2,500 special exception fee? What if in the community meeting, the neighbors object to this use? What happens then? And so for those reasons, we respectfully urge that multifamily be exempted out from the bill. Thank you.
Thank you very much. We have a question from Vice Chair Boyce.
Thank you, Mr. Chair. Thank you so much. So let's say this bill passes and I'm in a facility that you're discussing. Wouldn't I still be subject to child care rules? So let's say I decide I want to do a child care in my second floor apartment and they come and check it. I'd probably be denied because it probably wouldn't be of size, it wouldn't have certain ADA accessibility, so on and so forth. So I would still be subject to the rules and the standards for child care for the state. Isn't that so?
Correct.
So I guess the next question would be, suppose I'm in an apartment building and I decide I have an agreement with my landlord that the community space, for instance, on the first floor is suitable to have, I don't know, before and after care that I can manage, and I have an MOU with the landlord to do so, and it meets the requirements of the state for child care. Would that be something that's acceptable?
Well, I guess one thing, and speaking with Delegate Guine, it appeared to me that she wanted to be able to have as many children that would be accommodated, and so that in that scenario, I feel like that would limit it to maybe one resident, and opposed to maybe more that are looking to do the same thing. And so I guess prospectively, it could be considered. But I think it would limit the intent of the bill, which is to have as many children.
And if I may, Vice Chair, I don't think there's anything presently in the law or in COMAR that would prevent that from happening. I think you could probably already, if you were a tenant, ask your landlord to enter into an MOU to do something like that. This bill just simply prohibits the landlord from imposing those restrictions.
Thank you.
Delegate Lehman.
Thank you, Mr. Chair. I'm sorry, it sounded to me like you were addressing a specific scenario in a specific county when you were talking about like a Board of Appeals situation. This is a statewide bill, is it not?
It is, but, and I didn't check, with apologies, Delegate, every single county in the state. AOBA only represents multifamily members in Montgomery and Prince George's, so I did check Montgomery and Prince George's, and I did find that Prince George's has special exception requirements. There could be other jurisdictions around the state that have similar local zoning ordinances that restrict where you can put a family daycare center.
So in my experience, counties deal with, zoning very differently. Sometimes it's like in Prince George's County Council sitting as the district council, but you have boards of zoning appeals and you have other, bodies, appointed bodies that deal with issues like this. So what, can you say again, just briefly, what the gist of what your requested amendment would do?
Yeah, so we're just suggesting that multifamily specifically be taken out. We think that if the committee's will is to allow single-family rentals to be used as daycare and prohibit single-family landlords from banning the use of their property for daycare centers, we'd be supportive of that. But we just think that multifamily in particular is an incompatible use for a lot of the reasons we just stated.
So you're saying all multifamily, you're speaking to your membership in particular? So you're talking about apartments in particular?
Yeah, yes, I'm talking about apartment buildings specifically. I can't speak for, every type of landlord and every type of building, but for apartment buildings specifically, I do know, and I guess somewhat to your point, that there is a lot more flexibility in allowing daycare centers, say in commercial office buildings, for example. There's a lot of office buildings that have first floor daycare centers and that meet both local zoning and the state's requirements for family daycare centers.
You're probably correct, but I would just think that would create more obstacles to, in terms of access and affordability for somebody who would want to operate a daycare. I assume that's part of what Delegate Guyton is after. I've not discussed the bill with her, but the fact that there is such a shortage of daycare and that it is easier for, potential operators to provide it where they live. Thank you, Mr. Chair.
Delegate Healy.
Thank you. Thank you, Mr. Chair. And I apologize, I missed the beginning of your testimony, so this may have already been covered, but I'm going to ask a couple things. One, from what you were saying, you focus on Prince George's County. Is this bill disproportionately affecting Prince George's County over the way things are done in other counties throughout the state?
No, I can't say that it is. All I'm suggesting, both in my written testimony and orally, is that we have local zoning codes because they determine compatibility. And while the bill does not preempt local zoning codes, the reason that the local authorities have determined that it's not a compatible use for multifamily zones is because there's a lot of barriers to putting a family daycare center in those buildings, the outdoor requirement being one of them, the size of the unit, as Ashley touched on.
If we're talking, are we talking about like daycare centers, or are we talking, there's also family daycare where people just take a small number of children into their home for the day?
And that's my apologies, Delegate. I'm sort of using the two terms interchangeably, but yes, I essentially mean family daycare center.
You're talking about
family
a
childcare
center where you.
Yes. Well, no, I specifically mean family childcare. What this bill is trying to address. The zoning codes don't quite make that distinction. They essentially call them daycare centers, or sometimes they're called family daycare, and that's why the two terms are sort of used interchangeably.
Okay,
but
so
I'm specifically,
what are you referring to? Are you referring to like somebody who takes a few children into his or her home to watch them during the day, or are you talking about an educational facility that would be covered, for example, by the 3-year-old program in the blueprint?
I'm talking about even in the first scenario, the person who takes 1 or 2 children into their home to be a licensed and registered family child care facility in Prince George's County, and also with some of the state requirements that the education article in Comar imposed, you do have to meet certain requirements.
Okay, so that's one question, and I'm not sure I agree with you about that. But the other question has to do with specifically Prince George's County, because as you know, all along the US 1 corridor, there are a lot of buildings, new apartment buildings being built as we speak, and a lot of them have various kinds of businesses, retail, and so forth on the first floor and of those buildings. And so it's a mixed-use area anyway. Is that what you're talking about, or are you talking about like an old-fashioned apartment building?
No, so again, and I think this goes to the Vice Chair's question about the use of, say, a common area, or perhaps in one of these mixed-use buildings, the use of like a retail component of a building that meets both the local zoning code and the state's requirements for a family child care facility. But that's not what is specifically contemplated by this bill. It suggests that the unit, the residential component, that be allowed to be used as a family child care facility. And what I'm suggesting is that the unit itself is it's an incompatible use. Now, if there are other pieces of the property, because it's mixed use or because it's, whatever have you in that development, that make say, the commercial space within the zoning code allowable for family childcare or a daycare, if you will, then that would still be okay. But I mean, we're referring to specifically the use of a unit for a family childcare facility.
So if I live in a house and I can do this, you don't want me to be able to do this if I live in an apartment building. Is that what you're saying?
What I'm saying is that in a residential apartment building, strictly residential or strictly the residential component of an apartment building, it could potentially be an incompatible use. There are other parts of a building or property that may be more compatible, but it's not a compatible use.
All right. Thank you for sharing your information. Appreciate it.
Delegate Addison.
Hello. So as a former child care provider, what I know is that we can, under Maryland State Department of Education, who took over child care licensing, if you come into a house, apartment house or whatever, if you have the amount of space, you can use that as a family child care space. However, if you go downstairs, you can use that as a part of a play area, as long as you can walk and have distances where you can walk so that the children can be able to play. So I don't know about the apartment size, because you can be licensed in apartments for the family child care use.
And thank you, Delegate Addison. I think what we're trying to convey is we're not saying that legally it cannot be done. You know, like if you are able to go through the proper channels to get it done. I think what we're trying to express is that there are issues if you are in multifamily housing, such as the over-occupancy that I discussed as a safety concern, or the noise that a neighbor, someone may have a very high sensitivity to noise or might not be as tolerant of children running over their heads. And those are things that the landlord's going to have to field those questions. But they would also be limited, and that's why I was referencing fair housing, because familial status, anyone in your apartment under the age of 18, you can't really discuss what's going on in that unit. And then I also can't steer someone who does want to have a child care home into, oh, well, do you mind moving into a ground floor apartment? Because that's also a violation of fair housing. So those are just some of the concerns we were saying that would be a hurdle for us in being okay with having child care homes in the individual units.
Okay. Just trying to make it clear, because Comar says that you can have them. Oh, I'm sorry. Because according to Comar, I know that they do allow you to have it in apartment buildings, whether you're on the top or on the bottom floor.
Right.
Okay.
Understood.
Okay, thank you. We'll turn to our unfavorable, Bill Costelli on behalf of the Realtors.
Thank you, Mr. Chair. Bill Castelli on behalf of the Maryland Realtors, and we appreciate our conversation with Delegate Guyton on the bill. We are opposed, though. A couple of the concerns that we have is that when you're renting out residential property, right now, you typically will have insurance on that property. That property insurance will typically preclude you having a commercial activity. So under this bill, while it does talk about you having to be additionally insured and added, that typically would be to the liability insurance that the child care provider would have. But it doesn't talk to the property insurance that's on the home itself, so that would also have to be addressed. But generally speaking, I would just say that, you know, we think that this is a conversation a tenant should have with a landlord, and there should be agreement between the parties about whether they're going to be conducting, you know, a commercial business in the property. And, you know, those are our major concerns with the bill.
Thank you. Any questions? Okay, that concludes the bill hearing on House Bill 911. We will turn to House Bill 872, Delegate Stewart, Residential Real Property, Tenants' Right of First Refusal. And if you have a panelist, feel free to grab them.
Mr. Chair, Madam Vice Chair, members of the committee, this will be the easiest bill of the day. This is a typo bill. This is just a clarifying bill. The governor passed 3 big bills in his housing package last year. You all remember one of them was about renters. There was a typo in it. It said tenant when it actually meant third-party purchaser. And as a result, inadvertently, it set up liability for a third-party purchaser to, yeah. I almost beat that. I almost beat that. Essentially what we did inadvertently last year is that in a scenario where a tenant was given the opportunity to purchase their home, but then, or maybe weren't given that opportunity, and then the landlord sells to a third party, we set up liability for the third party, even though the third party was not in a position to know whether that notice was given or not. And that has clouded some of the land title issues and some of the insurance issues, and is actually inadvertently could hurt the landlord, the tenant, and the third party purchaser by clouding the marketplace. So this is a very easy fix. We just replaced tenant with third party purchaser, which was the original intent of the bill. I hope that you will vote favorably.
Okay, do we need to hear from Mark Glazer as well?
You want just me too, or did I screw something up?
No, I think you about covered everything.
Okay.
Okay, great. You covered everything. Any questions? Okay, that concludes the bill here on House Bill 872. We'll now turn to House Bill 896. Delegate Stewart, Human Relations, Discrimination in Housing, Income-Based Housing Subsidies. If you have a panel, please bring them up.
Yeah. Unfortunately, Mr. Chair, this one's a little bit more complicated. Mr. Chair, Madam Vice Chair, members of the greatest composition of humans ever assembled. I am Delegate Vaughn Stewart, and this is one of my House bills. I don't remember the number. Okay, 896. So this bill, so let me just say this. I think it's bad to discriminate against poor people. I think it's bad to discriminate against poor people. I think it's bad to discriminate, of course, on anything, gender, race, but I think it's bad to discriminate against poor people. I'm not saying it's worse or better than other forms of discrimination. I just think it's bad to discriminate against poor people. And that's what this committee and that's what the entire General Assembly agreed with back a couple of years ago when now Comptroller Learman passed the Home Act, which finally, after years and years and years of trying, outlawed discrimination against poor people, and specifically the kind of poor person who has a housing voucher. It prevented, for the first time, discrimination based on what's called source of income. In other words, if you have a housing voucher, either from the state, we heard earlier from the secretary that the state has a voucher program, or a federal voucher or some other form of rental assistance dollars. We passed that bill. It was a landmark. We're not the first state to do it. We won't be the last state to do it, but it was a landmark bill. Unfortunately, since we passed that bill, 2 forms of insidious workarounds have been developed by a very small but very inventive group of landlords. I'm going to mention the 2 types of discrimination that we have an opportunity to prevent with this bill. You may like one, you may not like the other. We'll see, right? Here's the first one. Landlords are using income requirements to state that, for example, if the rent is $1,000 and someone's voucher covers $500 of the $1,000, the landlord is requiring the tenant to show 3 times the $1,000 instead of 3 times the actual amount they have to pay. Now, I have good news about that type of workaround, that type of discrimination. I think almost everybody in this room, maybe literally everyone, agrees that that's unlawful discrimination in violation of the Home Act. I think. They may tell me differently, but I think the good news, ladies and gentlemen of the committee, is at least on that issue, I think we can put that to rest this session with this bill. But I wanted to go to tackle one other type of discrimination too, and this is where it gets a little bit more complicated. The other workaround that some very, very few inventive landlords have developed is once someone gets a housing voucher, let's say they got it 5 years ago. After they get the housing voucher, that's basically like winning the lottery. If you're a poor renter in Maryland, getting a housing voucher, I mean, you got to wait a long time. In some jurisdictions, you wait 12 years. Getting that call or getting that letter that you get a housing voucher, that's like the golden ticket in Willy Wonka. That is an amazing victory for your financial future, all right? So what some landlords are doing, however, is they're saying, okay, you got your golden ticket 5 years ago. You've paid your rent on time every month, and you haven't had any problems with your credit. You've paid all your bills on time since you got your golden ticket. Now, why is that the case? Well, probably because an extra $800 or $1,000 a month or $1,200 a month is life-changing for people that get the golden ticket. However, unfortunately, some landlords are saying that even though you haven't had a single problem since you got the golden ticket, we're denying you because you didn't pay your bills, not your rent, but your other bills more than 5 years ago, before you got the golden ticket. And my argument with this bill is that's a proxy for discrimination. Maybe you don't agree, but I would analogize it to this. If I, Vaughn Stewart, had all sorts of trouble paying my bills, maybe I had some bad medical debt, maybe I just got laid off or whatever, and I couldn't pay a bunch of bills, and my credit score was terrible. But then 5 years ago in 2020, I won the lottery. And then my financial situation markedly improved. I paid all my bills, I paid my rent on time, everything was awesome. Then in 2025, I don't think that there's a landlord in the country that would deny me. And I would think that if they denied me based on what happened in 2017, 2018, or 2019, before I literally won the lottery and became a millionaire, I would argue that they're discriminating against me. Maybe they don't like someone who has so many awesome bills. Maybe they don't like members of the Environment and Transportation Committee. I don't know, but I would argue that's a proxy for discrimination. You might disagree. I think maybe the landlords would even agree that that's suspicious. So those are the two types of discrimination that we're trying to outlaw. So what the bill does is it says that for housing vouchers, housing voucher holders, landlords cannot look at their credit score, credit information, et cetera. Now, maybe that's a little too broad. They may tell you that we need to narrow the language, and I'm very confident in Chair Holmes and members of the committee that we can narrow the language in a way that works, because I've certainly been accused, and rightfully so, as drafting bills that are a little bit too broad than what I intended, and maybe that's the case here, and maybe we can narrow it down, and maybe there's a way to fix it. I'm certainly open to those conversations. But again, the point of this bill is that we decided as a committee and a General Assembly that it's wrong to discriminate against poor people. Bad actors have found two very clever ways to discriminate poor people in violation of the law. I want to plug at least one of those loopholes this session. If we can plug both, that would be awesome. And that's what the bill is about. And I hope that you guys vote for it. Thanks.
Chairman, Vice Chair, members of the committee, thank you for having me. I do want to point out that the sponsor is also disarming in his own right from the last hearing. We've actually worked with the sponsor over the interim. The concept here, especially in source of income for DHCD, was a priority issue that we wanted to tackle. And in conversations with the sponsor, we found out that he was carrying the same exact bill. So great minds think alike, and I'm using Secretary Day and Delegate Stewart, by the way, here on these great minds. So all I want to say is we love the bill. We were supportive of the bill from last summer. We'd love to see it passed in its current form. Thank you.
Good evening, Albert Turner of the Public Justice Center, coming in favorable with this bill. I'll be very brief. Just wanted to highlight, we get calls from renters with vouchers all the time dealing with this type of denial. I'll regale with one story. A single mother who had just left an abusive relationship was one of the lucky few to get a housing voucher. She was a full-time student, so that meant that her housing voucher share was $0, which meant that her voucher paid for the full monthly rent. She lived here in Annapolis. She applied to 20-plus different places and was denied from all of them. Of those 20 places, almost half of those denials were because of her credit. Now, I will repeat, she did not pay, she was not required to pay any of the rent because she was a student. She had a 0% share, and yet the landlord denied her for that. We believe that is a circumvention of the Home Act that was passed by this body. We believe that it is something that cannot hold, as voucher holders are, because of their voucher holding status, low income, don't have enough money, have a lot of history of unpaid bills, and because of their voucher status, they are allowed for that payment standard to pay a fraction of the cost. And there is no type of relation between a credit score and someone who pays $0, $100, $200. These are the stories that we hear from clients calling in stating that they've been denied, even though they're only paying a fraction of the rent. And for that, we are asking for a favorable report. Thank you.
Afternoon, Mr. Chair, members of the committee. Jonathan Smith. I'm Chief of the Civil Rights Division of the Office of the Maryland Attorney General. I also try to be brief, although that is often difficult for me, so I will try to stay within the 2 minutes. I think there's a couple of points I just want to make that in addition to preventing discrimination against poor people, this is a racial justice issue. The primary voucher holders in the state of Maryland and across the nation are persons of color. And the housing voucher program itself was originally started in the 1980s as a method to desegregate site-based public housing. And the HUD looked at the way that public housing had a segregating effect and developed the voucher program as an opportunity to create for people to go into opportunity neighborhoods and to place their vouchers outside of highly segregated communities. Maryland still has a very serious problem with housing segregation. This is in part being driven by continuing discrimination based upon the ability to use a voucher once that it's been awarded to a resident. The second thing I want to just sort of focus on is I don't think this is a small number of landlords. Sorry about that. If you go online now and look at advertisements for landlords, and my office has been doing that as part of sort of attempting to identify where discrimination is taking place, a very large number of advertisements, particularly in the market where you could place a voucher, have a minimum credit score requirement. And that excludes most people who are using house vouchers. The third point I want to just make is that there's no harm to landlords. At this point, and you're going to hear in a minute all the parade of horribles, but if you just look at those jurisdictions where there has been a statute like this, where that protects from this kind of voucher discrimination, the housing markets continue to be very effective and profitable for landlords. And I will conclude there.
Great. Doug, is that having Liz Kruger up with your panel?
Sure.
Hi, good evening. I see that most people have tried to be brief, so I will do the same. I'm Liz Kruger, Director of Homeless Services for Interfaith Works, Montgomery County-based nonprofit, and we work with those experiencing housing challenges and poverty. So a couple of points I want to add that are important to our experience is that we do collect data, and we have seen the overwhelming barriers that credit scores have created. It's the one thing landlords still have that they are using in large numbers against our population seeking housing with vouchers and subsidies. I would say about one family or individual a week gets denied because of their credit, and they are just languishing in our shelters. We have the longest stay in shelters we've ever had in Montgomery County, and it's about 8 months is the average right now, which is it's really bad. So the other piece of data that we collect is that we do track how many people are struggling with payments and struggling to pay their portion of the voucher, and it's under 5% in the last 2 years. That is significantly under like the national average of just general renters in the country struggling to pay rent, right? So that is, you know, anywhere from like 10 to 13%. And those that are struggling, of the 310 individuals and families that we've served in the past 2 years, it's less than 5% that have struggled to pay their portion. So I know that's just our experience at IW, and I think we need more eviction data. We need more data like this out there, but it tells a very strong story that credit scores are not the strongest indicator of someone being able to pay their rent, and certainly judging them by when they were in the throes of poverty and crisis, and then using that to say that now with your extra support you will not be able to succeed is keeping them in poverty. So thank you. I obviously want this the passage of this bill.
Question from Delegate Ziegler.
Thank you, Mr. Chair. So I just looked up what you have to do to accept a housing voucher as a landlord, and it really is a lot of stuff. I'm wondering, and I'm really just wondering, if the credit thing isn't just an excuse for landlords who don't want to deal with the government nonsense, with the housing quality standards and you know, it's a lot of stuff.
Yeah, we think it is an excuse. I mean, that's the reason for the bill. I want to make it really clear. I mean, there's some landlord representatives that are going to come after us. I think landlords should be able to screen out tenants. You know, I think that if someone hasn't paid their rent and you get a tenant screening report on them and says someone hasn't paid their rent, that person should be able to be rejected by landlords. And that's why this bill has nothing to do with tenant screening reports. We heard about tenant screening reports earlier. Landlords can still get tenant screening reports. If someone has had eviction filings against them, haven't paid their rent, all of that, whether they were a voucher holder or not, they can still consider that. What we're saying is poor people, if they struggled to pay their bills and they had a bad credit score dating back to before they got a voucher, before they won the lottery, before they got the golden ticket, if you're judging them based on that and not what's happened since you got the voucher, to me, that smacks of discrimination. Now, you're right. A lot of landlords are resistant to taking voucher holders, and that's why the bill is here. A lot of landlords also, I think, smartly have realized that voucher holders can be a really good deal financially. So I don't want to leave them out, too, because a guaranteed check every month is a really powerful thing. And I'm sure the landlord advocates will tell you that, you know, landlords, a lot of landlords like voucher holders, you know, they pay every month, but some don't. And it's the same voices that were resistant to the Home Act for 2 or 3 decades. And unfortunately, they found clever ways to get around it, and that's what we're trying to solve.
And maybe we can make it easier and take away some of this rigmarole.
That would be nice. I mean, some of that is federal rigmarole, but I agree that, I mean, any ways we could smooth that burden, you know, make that burden easier on them, I'd be in favor of.
Vice Chair Boyce.
Chair, and thank you, Delegate Stewart, for this bill. And I just want to say, isn't it so that you don't need a credit score to even get the voucher to begin with, right? So I'm just curious about why this even a thing. If I don't need a credit score to get a voucher, I get a voucher based on need. And then, okay, I just wanted to clarify.
Yeah, that's so.
Delegate Morgan.
Thank you, Chair. Delegate Stewart, the golden ticket, do you get to keep the ticket for life?
No, it's a good point. The federal government can take away the ticket from you if, for example, you end up making a lot more income.
Do you have to report that you're making more income, or do you just sort of keep it under the table until they come and ask you the question?
You do have to report income data regularly to the federal or the state government to make sure you're still eligible for your voucher.
Okay, thank you.
Okay, I do not see any additional questions for the sponsors panel. We have a few virtual favorable witnesses. We'll start with Adria Crutchfield, Baltimore Regional Housing Partnership.
Good evening, Mr. Chairman, Vice Chair. My name is Adria Crutchfield, Executive Director for the Baltimore Regional Housing Partnership. And I thank you for the opportunity to testify today in strong support for House Bill 896, which seeks to protect recipients of housing assistance from exclusionary rental screening practices. BRHP is a nonprofit that administers the Baltimore Housing Mobility Program, which provides over 4,300 low-income families with rental assistance and housing counseling as they transition to areas of opportunity in Baltimore City and the 5 surrounding counties. Credit scores measure lending and ability to pay back money that is borrowed. They fail to reflect the history of on-time rental payments, as rental housing operators rarely report this information to credit bureaus. And as many of you all know, the rent eats first when it comes to paying bills. The widespread use of credit scores and history in tenant screening is an unfair and unreliable method. It poses an undue barrier and results in the discriminatory exclusion of individuals from quality housing for which they otherwise qualify, because it ignores the financial security of the housing subsidy and excludes tenants based on factors unrelated to their ability to pay rent. As a reminder, housing assistance goes up or down as the tenant's income goes up or down, with the tenant paying 30% of their income towards rent and the housing subsidy accounting for the rest, and often the bulk of the monthly rent, directly to the property manager or owner reliably. Further, a participant's failure to pay their portion of rent jeopardizes continued housing assistance, making them even more reliable renters in many ways than unassisted counterparts. This legislation does not prevent landlords from using more relevant tenant screening like rental history, past landlord references, court cases for failure to pay rent, tenant holding over, or evictions, which more accurately speak to whether a prospective tenant is a risk. Further, the practice of not using credit screening is specifically encouraged by HUD as a practice to ensure compliance with principles of fair housing and anti-discrimination. HB 896 aligns with best practices adopted in other states like Colorado and California, as well as in Washington, D.C., and ensures that Maryland upholds the intent of the Home Act by opening housing opportunities for low-income families receiving housing assistance. For these reasons, BRHP respectfully urges the committee to pass the bill. Thank you for your time.
Thank you very much. We'll move on to Holly Hickman.
I'm here to tell you my story, how I almost couldn't find
a place to live with my voucher because of my credit report. I asked that the House bill pay $896. I have a disability with 3 adult children, and I have a disability too. Our house income is SSI. Because of my disability, the Arc of Frederick County works with me and supports me. My last year, my lease was not renewed. My children and I started applying for other housing, hoping to find somewhere to move so we could not be homeless. We applied so much places where we were rejected from because of my credit report. Every application was expensive. They charged me every adult in the house. I paid $100 to $160 every rental application. So I submitted, and then they rejected us, and I would not get not money back. I did not have enough good credit, because of my abusive husband and my ex-husband. Credit card report was both in our names. I can't afford my rent with my voucher, and I always paid rent on time. It was very stressful and scary because me had so much anxiety because I didn't think we would find a place to live. It took us more than 6 months to find a place that took us my credit, and we end up homeless for we end up in homeless and lived in a hotel in 9 days. If the House Bill 896 was the law in Maryland, I would not have such a hard time finding a place for me and my children.
Thank you, Holly. Great job. Appreciate you being with us. Let's turn to Melody Mitchell.
Hello, how are you doing?
Great. Please go ahead.
My name is, thank you. My name is Melody Mitchell. I'm a proud mother of 3 children, including one with special needs. And I'm also a participant of BRHP, which is Baltimore Regional Housing Partnership Program. I'm here for my testimony and my support of House Bill 896, a bill that will ensure families like mine are not discriminated against due to our credit scores. Just to piggyback off of what they said before, I feel like landlords use this particular method in order to use it as a loophole to discriminate against us. I have encountered firsthand the challenges that many voucher holders face. Landlords initially will express willingness to rent to me, but as soon as I mention my voucher, the conversation changes. Suddenly, they claim the unit is no longer available, or they impose credit score requirements that have no bearing on my ability to pay my portion of my rent. The issue wasn't that I couldn't pay my portion of the rent. It was because of my credit score that became the deciding factor in being rejected for housing. Majority of the time, there is a stigma attached to voucher holders that are simply discriminatory and untrue. In my case, my credit score didn't accurately reflect my financial responsibility like many others. I faced financial hardship in the past due to circumstances beyond my control. Medical debt, past student loans, and unavoidable financial setbacks are not reflective of my ability to pay my rent on time. The purpose of House Bill 896 aims to prevent landlords from using credit scores as a reason to deny housing to voucher holders. This legislation is crucial to families, particularly those facing systemic barriers in the housing market. Many voucher holders have faced discrimination despite the guaranteed rent payment offered by the vouchers. And this bill seeks to move this unjust practice. So I urge you to please side with this bill.
Terrific. Thank you for your testimony. Appreciate you being with us. We'll now turn to our in-person unfavorable witnesses. Aaron Greenfield, Maryland Multi-Housing Association, Bill Castelli on behalf of the Realtors, and Brian Anlou with AOBA. You guys gave Bob Enton the night off?
He's got one last hurrah. housing provider will still need. Okay, good, thank you. A housing provider will still need to screen for income, even if a resident receives a housing subsidy for several reasons. One primary concern is the ability to cover the non-subsidized portion of the rent. Housing subsidies typically only cover a portion of the total rent, leaving the resident responsible for paying the remainder. A housing provider needs to ensure that the resident has sufficient income to meet this obligation. Beyond rent, residents must also afford other housing-related costs such as utilities or renter's insurance. Screening for income helps verify financial stability and ensures that tenants can handle these additional expenses. Furthermore, risk mitigation is an important factor. Even with a subsidy, a resident's financial situation may change due to his job or failure to comply with the subsidy program's requirements, which could lead to a loss of assistance and difficulty paying rent. Housing providers play a critical role in ensuring that residents can afford their housing costs. Housing providers essentially have a fiduciary responsibility to ensure that prospective residents can afford their portion of the rent along with utilities. This is not just a business imperative, but also a necessary step to prevent evictions and the associated social and economic costs associated with evictions. By precluding housing providers from screening residents based on their income, credit score, or credit history, this bill would undermine this critical process. Without the ability to assess a prospective resident's financial stability, housing providers would be forced to take on undue risk, which could lead to increased evictions and destabilization of the rental market. For these reasons, we respectfully request an unfavorable report on House Bill 896.
Good evening again, Mr. Chair, members of the committee. Brian Anley with the Apartment and Office Building Association. We agree with Mr. Greenfield's comments, so I won't repeat them. I would just simply say that we believe that income and credit screening are fair and objective ways to determine these risks, and it's not true that we can simply look at previous evictions. The General Assembly last year, you'll recall, passed a bill that shields those eviction records, so you can no longer consider that. And the alternative would be perhaps to call previous landlords for the tenant, and we think that that potentially adds additional bias or discrimination into the rental housing process. So with that, we respectfully urge an unfavorable report.
Thank you, Mr. Chair, members of the committee. Bill Castelli on behalf of the Maryland Realtors and the property managers in the association. They are also opposed to the legislation. I won't repeat what has already been said, except to say that credit checks are one tool that they use to verify a tenant's ability to pay that rent. And I will tell you that, when they're looking for a tenant for a property, they are not just looking for any tenant. They're looking for the best tenant. They have a duty to find the best tenant. And oftentimes with the housing shortage, they have multiple tenants to consider for most of these properties. So I think it's just part of the duty that they have to find the best tenant. This is just one more piece of information they use to determine which of those tenants is best for the property. And for that reason, we encourage an unfavorable report.
Thank you. We have a question from Delegate Healy.
Thank you, Chair. Just given that it's already against the law to discriminate on the basis of source of income, and my question is, would it be reasonable to say that you really only need to know if they can pay the rent that's not in the subsidized portion? You're going to get whatever the subsidy, whatever that voucher says it is. You're going to get that. So you only need to really know, can they pay the balance? So if they have a voucher that says they can pay 50% and they can afford to pay 50%, and you want to know that, that might be more legitimate than just going back and saying that they have to be able to afford something that clearly they can't afford. Don't you agree?
Well, I think, if I could, I think, again, as Mr. Castelli said, it's a tool in the toolbox, right? And so you're trying to paint a picture of whether this prospective resident can actually meet their obligations. And so it is a part of it. And frankly, this bill.
That's the question. I'm looking for a compromise here. I'm looking for, yeah, maybe you can use a credit report, but there would be limits to how you would use it, rather than just have it and use the information any way you want to.
Well, again, I think, I think we need to have all these tools to look at the full picture. But I agree with you. We should be able to look at income as it relates to the prospective residents' non-subsidized portion of their obligation. Rather
than the full amount.
Correct. I think that's the appropriate way. I would agree with the sponsor when his first category of discriminatory practice.
Yeah.
Yes.
But even on this piece of it, I mean, you're going back in time for somebody who had a credit problem before they got a subsidy. Now they have a subsidy. They have income from the subsidy that would go directly to the landlord. It wouldn't even pass through their hands, but it puts them on a different footing than, it doesn't show a true picture of where they are in their financial life. Wouldn't it be better to have a bill that said you have to look at only what is relevant to this situation?
Well, I think it's all the things that this bill strikes that is all entirely relevant to painting that picture.
Okay, thank you.
Delegate Foley.
Thank you, Mr. Chair, and thank you for being here today. My question is, so let's say the son or daughter of a billionaire, maybe, I won't name any billionaires, but the son or daughter of a billionaire, or even a millionaire, or even someone who has a lot of means, comes to rent an apartment, and the parent or the guardian pays the rent. Would you do a credit check on that person, on the tenant?
Well, I can speak for AOBA members. There may be instances where that would be something that they would do. However, I think in certain situations like you're describing, where the parent is paying for a child, usually they're showing a certain amount of assets, and so I'm just not sure that's a good comparison.
But isn't it so that the tenant who is renting with vouchers is showing a certain amount of assets in that they're showing that the vouchers cover a certain amount of the rent. So that's a certain amount of assets too, in a way, right?
It is, and I think in this case, to what Mr. Greenfield was saying, we still want to be able to consider that person's income for their portion that is not being covered. So I think the analogy would be in your situation, if the parent said they're only going to cover 50% and then the tenant or the child has to cover the other 50%, we would ask certainly that the child demonstrate proof that they can cover that 50%. We'd probably also ask that the parent co-sign the lease effectively for that child. And so again, it's not an apples to apples comparison.
Okay, well, thank you. I disagree. I think it is. I think you're basically saying it depends on where the income, where the subsidy, I'll call it a subsidy, for the rent comes from. So thank you.
Vice Chair Boyce.
Fine question, because I think I understand what you're saying. This is not about the voucher. This is about whether or not they have enough income per the credit score to, what you're saying is to live in the space. So what I'm hearing you saying is that it's not about the credit score as it relates to the voucher. You want to know if they can pay the BG&E. You want to know if they can pay all the other things. You're looking at whether or not they can live in the home. So this has nothing to do with the voucher.
That's correct. We're not allowed to consider the voucher based on the source of income. I mean, we have to accept it. It's a question of what's the full picture. Can they afford utilities? Can they afford renter's insurance? Can they afford their non-subsidized portion of their rent?
I understood that. I mean, they wouldn't get the voucher if they couldn't, I think, one. So getting the voucher means they can cover their part. And in the example of Ms. Holly, she was saying she'd always paid her bill because of her abusive ex-husband. Her credit was ended up being messed up. So therefore, in her trying to get a place, she couldn't get a place because someone else messed up her credit. But it sounded like she was, quote unquote, she had the ability not only to pay her part of the voucher, but also live in the space. So I guess how would you determine something like that? Because it sounds like she could live. She couldn't because of a credit score, but she was attached to somebody else's credit. So how would you make that distinction to know whether or not someone can fully live in a space if in this case here, to Ms. Holly's point, her credit was attached to somebody who was abusive to her and divorced, so it carries?
Yeah, I guess I can't speak to that specific example, and I missed it, and apologies if I missed it, whether the subsidy covered the entire portion of her rent or not. So I'm not sure about sort of that component. I think, I would go back to my earlier comments that really the only other thing that you could do at that point is call and check for references. I mean, that's still something that you're allowed to ask for, and you could potentially do that if you're barred from considering all these other factors.
Okay, thank you. That concludes the bill on House Bill 896. We'll turn to House Bill 709, Delegate Wilkins, good cause eviction. As Delegate Wilkins and her witnesses are all coming up, I just want to remind everybody still in the room that we passed a almost identical bill out of this committee 16-5 a year ago.
Thank you so much, Mr. Chair, Madam Vice Chair, and the honorable members of this committee. For the record, I'm Delegate Janelle Wilkins, and I'm pleased to present House Bill 709, Good Cause Eviction. I will be brief because I want to first thank the committee once again for passing this bill last year. We are grateful for the work that the committee did on this bill, and therefore I will keep my remarks brief, and I'll ask all of my witnesses to be brief as well. As you know, House Bill 709 is a statewide enabling bill authorizing counties and the city of Baltimore to enact good cause policies that will require landlords to provide a justifiable reason for a lease non-renewal. At its foundation, good cause is about the right to stable, secure housing. A renter who is paying their rent and following the rules should have a stable and secure place to live. And when a landlord decides not to renew a person's lease, it should be for a reason. For that reason, I urge a favorable report on House Bill 709. Thank you.
Good evening, Chair Corman. Thank you, Vice Chair, and everybody who's here tonight. I'm here in support of Bill 709. In the old days, when I first was doing tenant organizing in Tacoma Park, what the landlords used to do, and the legislature corrected it, they would, if the tenant called the housing department and got an inspection, the landlord would upgrade the tenant, write him a note saying, I'm going to evict you because you're causing trouble for me. The legislature passed a bill that prevented retaliatory eviction, and we thought the problem was solved. The problem was not solved. Landlords learned to be quiet, not say anything, not get angry, and simply notify a person 60 days before the lease was up that they were not going to renew the lease. And we saw it constantly targeted on people who are tenant organizers, people who are in buildings with lots of quality issues, who called the housing department and asked for support. And so I've been supporting this bill, I think, since when you were first on legislature and possibly before. So this, to me, is really important. The problem still goes on today in Montgomery County. We see it in normal life. We talk to tenant organizers, people in buildings that have had serious maintenance problems, and they wind up coming up for eviction when their lease is at expiration. These are people who have no problem paying bills. This is no issue about their financial wherewithal, no issue about how they behave or act in the building, simply because they ask for help from the government to get them evicted. No place should operate this way. This bill is carefully written. It allows massive numbers of reasons for eviction, and they're all good reasons for eviction. And as long as the landlords are protected against abusive, destructive, harmful tenants, they should be comfortable that if somebody pays the rent, they should be able to stay there. So I hope you'll pass this bill and that we're successful this time.
Good afternoon. Chair, Vice Chair, members of the committee, my name is David Wheaton. I'm an attorney with the Legal Defense Fund. I know it's been a long day for all the members, so I will be brief and just focus on 2 points. One is the disproportionate impact to Black Maryland residents on holdover evictions, and the second, the changes from last year's bill that this committee passed to this year's bill. First, the eviction crisis disproportionately affects Black Maryland residents. Black households have the highest eviction removal count in Maryland, almost 3 times higher than the eviction rate for white residents. Households headed by Black women had the highest number of eviction removals in Maryland. New original research from the Legal Defense Fund's Thurgood Marshall Institute shows that Maryland house neighborhoods with higher Black renter populations face higher rates of holdover eviction warrants and executed holdover evictions. Specifically, a 10-point increase in the percentage of Black renters in a zip code was associated with a 29% increase in the rate of no-cause eviction warrants and a 22% increase in the rate of executed no-cause evictions. This means that landlords are bringing more Black Maryland residents to court for no-cause evictions and are getting evicted at a higher rate because of no-cause evictions. And the second thing I just wanted to highlight was what is new about the bill this year. We took language from New York, which passed good cause in 2024, to clarify that a large corporate landlord should not be able to hide behind multiple LLCs to claim that they are exempt small landlord when they are not. We also added some transparency, which requires landlords to disclose in the lease and in the filing any tenant holding over complaint whether good cause laws applies or the basis for an exemption for a small landlord, and then some consistency measures as well, which provides that DHCD will develop a form notice for any non-renewal, and DHCD is okay with that. That concludes my testimony. Thank you.
Chair, Vice Chair, members of the committee, thank you so much. Once again, Chuck Cook, Chief Legislative Officer for DHCD. I want to make it short and simple. I'm happy to sit next to the sponsor for a second year on this bill. I am happy that this committee passed this out last year, and I will be even happier when you pass this out again this year. So thank you very much.
And I'll be happy when the Senate passes it out, because that's what has to happen for us to get something to the governor. Any questions for the sponsor or her panel? Okay, we have additional in-person favorable testimony. Lisa Saro, Community Legal Services, Zainab Shadre from CARE, Rebecca Clausen, and Isola Shaw, City of Rockville. Please go ahead when you're ready.
I'll go because I'm already sitting. My name is Lisa Saro. I am Director of Advocacy and Litigation with Community Legal Services. We provide free legal services, and a lot of what we do is helping people to stay housed. We promote housing stability in any way that we can. A lot of our clients face non-renewals of their leases for no reason, or it's kind of retaliation light or maybe discrimination light. It's a situation where you know there's a reason, but it's not something that you would be able to prove in court as an unlawful reason. The lack of stability and certainty in the lives of our clients' homes, where they're going to be from one year to the next, is incredibly difficult, particularly for seniors, people with disabilities, and people with vouchers. And I'm just going to focus on vouchers for a second because we just heard how difficult it is for people to get housing when they have a voucher. Imagine having to do that every single year. And some of our clients have to do that. Clients with vouchers, even when they get that 60 days notice in advance, it's still incredibly difficult to find someplace where they can find their voucher or use their voucher, not just because of continuing discrimination based on source of income. It still happens, but thank you for passing the law against it. It still happens. It's not just that, it's difficult because prices have raised so high that in order to use the voucher, you still have to find a place that's rent reasonable. And often they cannot find that. They're also looking for a specific size. So when you're considering this bill, keep that piece in mind as well. Thank you.
Good evening, Chair, Vice Chair, members of the committee. I know it's been a very long evening and you have the written testimony in front of you. I think just to add on to what's already been said, obviously Maryland families, especially those from marginalized communities, disenfranchised communities, are facing a housing crisis that's really been exacerbated by the arbitrary evictions that stripped them of the stability and security. Recent evictions in Montgomery County, for example, that left dozens of refugee families unhoused, placed a burden on local houses of worship that were forced to contribute hundreds of thousands of dollars to help make sure that some of these families would continue to have a roof over their head and have access to a safe, warm environment. And we know that obviously there are resources on the state and local level that can help contribute towards expenses that many of these families incur, but we believe that this particular bill would help provide protections and stability for many at-risk families that otherwise are facing undue hardship. We believe that this legislation would prevent unjust practices by providing legitimate documented reasons for evictions. And also, Maryland residents don't find home as just a place to live. It's really a foundation for economic mobility, education, and community engagement. Unchecked evictions not only harm individual families, but also strain social services. They now are placing a burden on houses of worship that really are having to dig into their pockets, and instead of providing a safe space for congregations to be able to worship in safety and security, they are now forced to find solutions to make sure that families within their communities have access to safe and affordable housing. So we urge a favorable report on House Bill 709. We will also be sharing testimony in the Senate as well and helping to get that bill passed, the cross-file passed, and we thank you for your time and consideration.
Good evening, Chair, Vice Chair, and members of the committee. I am Isola Shaw, a Rockville City Council member. Thank you for the opportunity to testify in support of HB 709. I speak today on behalf of the City of Rockville as one of Maryland's many renters. I also want to thank Delegate Wilkins for sponsoring this important legislation. Good cause eviction prohibits a landlord from failing to renew or terminate a lease without reasonable justification. A stable home provides a foundation for overall safety, and being unfairly forced to move can uproot a household from their community, social network, employment, and can also lead to homelessness. Many marginalized renters remain silent about their living conditions, fearing a lease non-renewal by their landlords. This reality affects our entire rental community. Even as an elected official, I too face the risk of non-renewal for advocating for stronger tenant protections. The Rockville Mayor and Council take the issue of housing stability seriously and support steps to move the state in a direction that provides more housing security for all tenants. We care deeply about our community where nearly half of our population are renters. Many residents reach out to our city staff seeking assistance in cases where they feel their lease has been unjustly terminated or not renewed. And currently, we are limited in how we may help these residents. In conclusion, strong and fair tenant protections will make Maryland and Rockville a more equitable and desirable place to live. For these reasons, we urge the committee to provide a favorable report. Thank you.
Good evening. My name's Rebecca Clausen. I'm a single parent to 3 teenage daughters, a decorated Army officer with over 30 years of service, a 100% disabled combat veteran, a senior-level federal advisor, and a 2010 Presidential Management Fellow. Our family has chosen to be residents of Anne Arundel County since 2012. I'm here to share our story and to urge you to pass good cause eviction. Since leasing a home in Gambrills, less than a mile from my daughter's schools, we faced a series of egregious violations by our landlord, SMD Capital Group, including repeated ankle-deep flooding, extensive mold growth, leaking pipes and toilets, chipping lead paint, rotting floors, and a severe rodent infestation. These hazardous conditions have jeopardized our health and safety, causing respiratory issues, allergic reactions, and significant emotional distress. Despite reporting these issues to the landlord and housing protection agencies, no meaningful action has been taken. Instead of addressing the violations, SMD management retaliated by issuing a notice of lease non-renewal just 14 days after being cited by the lead and health departments for dozens of unremediated housing code violations. Unlike the vast majority of Marylanders, facing eviction, I've been represented by an attorney, which has been critical in navigating the legal system, but it wasn't enough. We fought the eviction in court with a retaliation defense, and we lost. Now my family faces imminent eviction. This eviction is not just a loss of housing, it's a devastating domino effect. The eviction judgment has severely damaged my credit and rental history, making it impossible to secure a new home for our family. Without stable housing, I will lose custody of my children and be forced to live out of my van with my dogs. This issue is not a matter of poverty or bad tenants, nor is it a matter confined to Baltimore. The common perception of what homelessness looks like is a stark contrast to the reality my family is experiencing. I served my country honorably for 30 years in the active National Guard and Reserve Forces. Yet the very laws and freedoms I defended have failed my family. We've been forced to endure hazardous living conditions, retaliation, and now eviction because Maryland's laws allow landlords to hide behind a wall of privilege and silence, putting profit over people. Please pass this bill. Thank you.
Great. Ms. Clausen, thank you for your service and sharing your story, and thanks to all of you for hanging with us for so long. We will turn to our virtual favorite witnesses. We'll start with Holly Hickman.
My name is Holly Hickman, and I'm here to tell you my story. Ask about the House of Bill 709. I used to live in an apartment building in Frederick. I have a disability, and I get support from ARC of Frederick County. I take care of 3 adult children with disability and my grandson. In the early March last year, my ARC worker and I went to the rental office together to ask about would I sign a new lease. The rent office said they sent me a letter that my lease would not be renewed, and I had to be out by the end of March. I had never gotten the letter of a non-renewal. I was really shocked and scared. I didn't not know how I possibly could move out so soon, just in a few weeks. Maryland Legal Aid helped me buy some time since I had not received a notice. Because of current law, my landlord could decide not to renew my lease and kick me out for no reason at all. I was always paying rent on time, but they still told me I had to move out. I felt so much anxiety and couldn't focus and had no energy, and I was scared of my belongings would be put out in the streets. My grandson was a newborn. I was very scared we would lose him if we were homeless. I felt like I was having a panic attack. My children and I started applying for other housing, hoping we find somewhere to move so we could not be homeless. If the House Bill 709 is the law, I would not have to go through such a scary and stressful experience, and my lease would have been renewed since I was paying my rent.
Holly, thank you again. We'll now turn to Kenton Card, University of Minnesota.
Good afternoon. Thanks for the opportunity, Chair Corman, Vice Chair Boyce, and the rest of the committee. My name is Kenton Card. I'm a postdoctoral research associate at the University of Minnesota, visiting scholar at Boston University. I'm testifying today in support of good cause legislation because it is an innovative, measured, and proven approach to keep families in their homes. So if we look at the evidence in the academic literature, a 2019 study found good cause reduces evictions. A 2023 study found it directly and immediately mitigates displacement. So if we're going to address the housing crisis, we have to keep families in their homes and increase the supply of affordable housing. So my team at the University of Minnesota and Loyola University, Maryland, have conducted the first analysis of the impact of good cause on new housing production. We've examined data from 3 states that recently passed similar laws: California, Oregon, and New Hampshire, using what is a difference in difference methodology to test the impact of the policy on new construction permits, controlling for other trends. We found no evidence of a decline in new permits relative to trends in the neighboring states that did not have protections. These findings have been endorsed by 54 academics around the world, economists, urban planners, other housing policy experts. So I hope the committee can hear this evidence, that the evidence is clear that passing this kind of law works, or providing the opportunity at the county level, it works, in order to protect tenants, reduce evictions, stabilize families without the concern of reducing the rate of housing construction across the market. Thank you so much.
Thank you very much. We'll turn to Scott Weber, who has favorable amendment testimony.
Chair Corman, Vice Chairman Bryce, members of the ENT Committee. For the record, again, Scott Weber, testifying in support of HB 709 with minor amendments. I've been a licensed realtor here in the state for more than 15 years. My father was a broker and a multi-thousand unit property manager. I've been either a landlord or a landlord's representative for over 40 years. I've been a homeowner and a renter, and I've also been the victim of unjust eviction. So as a realtor, I engage in the rental market, frequently in the affordable housing space. And over the years, I've worked with both landlords and tenants in cooperation with multitudes of partners. So in this topic, I've experience coming at it from just about every vantage point. And there's no question, evictions are costly and often devastating to tenants, but they're also costly for landlords, and all too frequently costly to support partners and taxpayers themselves, who must often pick up the pieces and the tab of a shattered household and on an emergency basis. Evictions create a net loss to the public well-being, and minimizing evictions is just sound public policy. Fair housing is the law of the land. By definition, anything that's unjust eviction or eviction without good cause is unfair, and thus has to be a violation of fair housing law. No doubt, there are times evictions are necessary, whether for the failure to pay, destruction, or even the decision of a landlord to self-use his own property. In these cases, eviction is fair and just. But if eviction is initiated arbitrarily, for no good cause, with the personal whims, opinions, or perspectives of a landlord, or even just simple greed, then the resultant harm to both the tenant family and the instability and cost it imposes upon the community of a whole is unfair, and unfair housing is unlawful. Evictions for good cause should be strongly enforced. At its core, eviction for no cause is unfair. Violating fair housing should be rightfully reflected in Maryland law as illegal. I have a couple of proposed amendments are primarily technical in nature regarding to sending it via certified mail and making sure that all notice is written. I thank you for the opportunity.
Thank you very much. Okay, we will turn to our in-person unfavorable panel. Bob Enton, Maryland Multi-Housing Association, Bill Costelli on behalf of the Realtors, and Brian Anlou for AOBA.
Mr. Chairman, members of the committee, Robert Enton on behalf of the Maryland Multi-Housing Association in strong opposition to this bill. I'm not going to repeat all the testimony I've given over the last, 6, 7, 8 years since we've had this bill in front of us. I just would like to say that this bill, House Bill 709, is much different than the bill that passed out of the committee last year. And I would urge you and the staff to take a look at this year's provisions and compare them to last year's provisions. I've gone through it and done a comparison myself. For example, like the language on page 2 in lines 11 through 32 was not in last year's bill whatsoever. The language on page 3 in lines 1 through 28, not in this last year's bill at all. Just to give you an example of some of the differences, you're required now to state in a notice to the tenant the full legal name of each individual and the business name of each entity with direct or indirect ownership or membership interest in the residential rental unit. I mean, what does that mean, direct or indirect? I don't know. Do you know? I don't know. I know I don't have much time left, but I really would urge the committee to look at the provisions in this bill and the vagueness of the terms. Good cause is a tenant engaging in routine disorderly conduct. What does routine mean? Once, twice, 10 times? If you're going to pass this bill out, and I anticipate that you will, I would though ask you to look carefully at the provisions in this year's bill because they're much different than last year's. Thank you.
Mr. Enton, since you work for the banking industry, I want to make sure you know that if I'm a member in an LLC, I have a direct interest in it. If I'm a member of an LLC that then is a member of another LLC, I have an indirect interest in that bottom LLC. Very basic business information.
Direct or indirect?
That I know you know.
Direct. What does
that I know
mean?
you know. Mr. Anlow?
Direct or indirect?
Brian Anley with the Apartment and Office Building Association, unfavorable for the last time this session, I hope. No, I think we are. I won't repeat all the previous testimony we've given on this issue either. I'll just highlight one thing that perhaps the committee did not consider last year. It's a study out of the New York University Furman Center that looked at the trade-offs of good cause. And some of the things that they looked at for risks of good cause, just cause, include discouraging investment in both the maintenance of existing housing and development of new rental units, lengthening how long it takes to resolve eviction filings beyond 133 days. That's what it was taking in New York prior to the enactment of good cause. For reference, it can take about 12 to 18 months to resolve a good cause case in DC, where AOBA has members that deal with that. Increasing the cost of resolving disputes with tenants who are violating lease terms or making the building less desirable for others. AOBA members have reported spending thousands of dollars to evict problem tenants in DC, which ultimately simply makes housing more expensive. They have to recoup those legal costs and lost rents somehow. And then lastly, encouraging landlords to screen tenants more rigorously, which could further limit housing opportunities for lower income tenants. And I would just, to the point about the study that has looked at the impact of good cause on new construction permits in other areas, I would just submit to you all that good cause is one piece of the puzzle. And as you all know very well, we also have rent stabilization in Montgomery and Prince George's counties. And I think when taken cumulatively, the impact of all of these policies is that it does have an impact on things like new development, in particular compared to our neighbors in Northern Virginia. With that, I respectfully urge an unfavorable report, again, for the last time.
Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors and their property managers, we are also unfavorable to the bill. Fundamentally, we do not believe that a non-renewal is an eviction. This legislature has worked to create longer notices about non-renewal. We think once two parties agree to the start of a lease and two parties agree to the end of the lease, that is, an agreement by those parties. So fundamentally, we do not view these as evictions. And for that reason, we encourage an unfavorable report.
Okay, thank you. Any questions? Okay, that concludes the bill hearing. Subcommittee announcements. Chair Lewis.
Thank you, Mr. Chair. The Land Use and Ethics Subcommittee of Environment and Transportation will meet immediately after we adjourn from committee. Again, land use immediately after adjournment. Thank you, virtually.
Madam Vice Chair.
Thank you, Mr. Chair. We will meet after land use, so 7:15.
All right. Thank you all for your hard work today. See you on your Zooms.